पार्टिसिपेंट्स हमारे कई पार्टिसिपेंट्स जुड़े हैं, 6 पार्टिसिपेंट्स अभी जुड़ने वाले हैं। So good morning participants.
Very good morning sir.
Good morning.
Good morning sir.
आज की हमारी फैकल्टी से आपका रेगुलर परिचय है ही. So I am handing over the session to Sumit ji. Welcome Sumit ji.
Thank you Vijay ji. Just give me a minute.
हाँ, no issue.
I'm still getting echo. मेरे को receive में क्या हो गया दिक्कत आ रही है. So I'm just trying to check out what I can do
आ रही है,
best.
नहीं भी आ रही है.
Sumit ji, if I can make a suggestion, आपने कहा था कि आप मोबाइल से भी लॉग इन करते हैं to see how you're appearing on the screen. वो आप वरी मत करिए. अगर आपको जो जरा से भी गड़बड़ होगा, there are enough of us to let you know. Maybe if you wish, you can just switch off your mobile and log in only from one device.
Me?
No, that was Sumit ji.
मुश्किल हो जाएगा.
Vijay ji, voice is okay now?
हाँ, वो
Yes,
तो
it
ठीक
is.
है, बिल्कुल.
और इनको सबके साथ देखो.
Good morning everyone.
हम से क्लास लेंगे. चाय पियेंगे क्या? 8 घंटे ही होती है.
म्यूट कर लें बाकी, या एक बारी मैं सबको म्यूट करके सुमित जी को ऑन करता हूँ, एक बारी बाकी अपने आप कर लेना. सुमित जी अपने आप को अनम्यूट कर लीजिए बाकी, ताकि हाँ आप सब अपने आप को धीरे धीरे अनम्यूट कर लेंगे जब जरूरत होगी, क्योंकि गलती से रह गया होगा किसी का, आई थिंक, म्यूट अनम्यूट.
Fair enough. Okay. So now again today we'll have a theory session. General laws, as you all would have discussed yesterday, syllabus. What is the coverage? General laws have approximately all the sessions, and coverage is approximately from 18 marks. That's the standard given in syllabus. This 18 marks you can consider as 18% passing exam, or you can consider as a 30% for passing an exam. Choice is yours. If your aim is just to get a degree, then 60 marks is sufficient. And out of 60 marks, if 18 marks can be achieved, so that becomes almost 30% of the passing percentage. If somebody's aim is to score 100 out of 100, then for you it's only 18 marks. But this is a low-hanging fruit, because here no calculations are involved. You can easily achieve this. It's not complicated. Yes, it is tricky, but we can achieve that. So SFA would be a very simple act. Generally, 1 marks question comes generally from this act. Those who have been dealing into bank finance, for them it would be very easy. They would know it. For those who are hearing it first time, this act is very simple act. And the basic of this act is it gives the power to banks to quickly recover the assets. This came in 2002. Let's take questions first before we understand the act. How much time limit? I know a lot of people are not aware, but it is just a guesswork we are trying to build up. Once we build up this sheet, this slide covers the maximum questions which come on SurfAC. If we are through on this, then majority of this course is covered. So how much time do you think SurfAC mentions the bank need to give to a borrower to repay the entire loan? Suppose a borrower has defaulted, then bank will give how much time to settle the loan before the bank can take action under SurfAC. Options are 30 days, 60 days, 90 days, 180 days. I'm very happy with your responses. Right or wrong, it does not matter, but I'm very happy. At least without giving my option, you started throwing numbers, and that is what is required. So I'll again repeat my question. And why you are 182 is for resident. So my question is how much time will bank give to borrower to settle the loan before the bank takes action under SurfAC? So my options are 30, 60, 90, 180. Okay. So note it down. Bank will give 60 days timeline. 60. So 60 days is the time limit as per the SurfAC Act, which banks need to give. I will explain all this process, but just understand the timeline and note it down. Because in exam they will ask only numerical, section-based questions. So just we cannot go wrong on this. Now this act, SurfAC Act, is applicable to 4 options: whole of India, India minus J&K, India minus J&K minus Union Territories, fourth, India minus J&K minus Sikkim. Your choice. Don't consider Section 370 amendment into this answer. Now you respond. When this question comes in exam, actually people get so confused, and I respect whoever is making this questions. He put so confused. So when we got this question, first option was India, second India minus J&K, third India minus J&K minus Union Territory, fourth India minus J&K minus Sikkim. And we thought D. I thought personally that D should be the answer, because I thought why they're excluding Sikkim and J&K. The correct answer is A. This act is applicable to whole of India since inception. These are one of the rarest acts which applies to whole of India. And in exam, this is a question where a lot of people get flunked, because generally whatever we read in all acts, it all starts with India minus J&K. Take it, Contract Act, Sales Act, whatever acts you start reading, J&K is generally excluded by default. So we always have a brain wired that it will be India minus J&K, but the correct answer is it is India, including of full India. Now, in SurfAC, does the account need to be NPA account, or bank can take action on normal account? So understand my query. SBI has given a loan to Jet Airways, and Jet Airways has not defaulted. Jet Airways is paying its installment, but bank knows that now Jet will not fly for next 6 months, and bank knows it will going to be default in coming 6 months time. So bank knew it's a short condition, it will be defaulted, but as of now the account is normal. Can bank take action under SurfAC? Yes, no, maybe. So the simple rule is account has to be mandatorily classified by NPA. The moment a bank classifies it as an NPA, then only you can go to SurfAC proceedings. Else, you can never go, even though the bank knows, yes, it will actually go into NPA later on, because we understand they are not flying, flights are all down, but still your judgment will not work. The bank has to classify as NPA, then only they will be allowed to take under SurfAC proceedings. Is there any minimum amount due criteria here in SurfAC, or a bank can go for any account? For example, a bank has 50,000 rupees loan NPA, can bank go to SFA, or there has to be some criteria? So if there is some criteria, then what can be the criteria? So we are having few, because I said 50,000, so your answer is coming to 50,000. Now the minimum amount due is minimum. It should be 1 lakh rupees. So minimum is 1 lakh, or 20% of principal outstanding, principal and interest outstanding, whichever is higher. So minimum benchmark would be 1 lakh rupees. That's a minimum, or 20% of principal outstanding and interest due, whichever is higher. We'll come to all this also in slides, coming slides. So just understand, and if you can note down for this slide questions, PPTs will always be there with you. But if you start writing it down, making notes, it will be helpful for you to study. The rest, you are all intelligent enough to make your call. Now, what is the time limit within which borrower can appeal? So my query is, suppose a bank has gone to SFA court and the district magistrate has passed an order. Now, within how many days borrower can appeal to debt recovery tribunal? My options are 30, 45, 60, 90. So we got one option, two options. Okay, just hold. Yeah, I got your responses. Now my another query is, I have not given the answer still yet. We have not concluded the answer, but moving to another question. So a borrower has gone to DRT, Debt Recovery Tribunal, against the order, and borrower lost it. So if he loses at DRT, he will go to Debt Recovery Appellate Tribunal, DRAT. Just like we have NCLT and NCLAT, we have a TRAT. Now, within how many days of losing at DRT, borrower can go to DRAT? Again, I will give 4 options: 30, 45, 60, 90. Now note down this, and this is a classic difference compared to all other acts. One, from the order of district magistrate, the borrower can appeal within 45 days to DRT, within 45 days. So first level is 45 days. I got an order, I want to go against the order, I can go to 45 days to DRT. If I loses a DRAT, generally in all other acts, the higher court gives you more time to appeal. It's a general principle, presumption. In this case, it is the reverse way. From DRT to DRAT, the answer is 30 days. So normally it confuses to people, because normally we always thought it should be 30 and 45, but it is other way around. So 45 for a lower court and 30 days for a higher court. But generally it is reverse in all other acts, but this act is specific. So just take it. 45 days is from order received from a district magistrate to bank that take action against Sumit for his borrowed property. I can go to DRT, Debt Recovery Tribunal, against the order. I can say this order is fudged, or the bank is not cooperating me. I am trying to pay loan. So I can go to within 45 days of that order. So I can appeal. First appeal lies to DRT, Debt Recovery Tribunal, for 45 days. If I lose at 45 days, if I lose at Debt Recovery Tribunal, then law allows me 30 days to go to DRAT. That is the logic. And that is the logic. Yes, it is less days because public money involved, government money involved, banks are involved, and you cannot enjoy on the bank's luxury. Fine. So that is 45-30 noted in exam, because I'll come. No, Rajit, it's different. I'll come to that separately. IBC is totally different animal, and this is totally different. We'll come to that after 15-20 minutes. So in exam, you'll get confused between 30 and 45. So just make a note of this. Now, Section 17A Agreed to Appeal Act. So in exam, you will get straight away this question like this. Section 17A Agreed to Appeal Act. Now, we don't know what is Section 17A, because I have not told you what is Section 17A for those who are not aware of IBC, SFA. Now, what is Section 17A and what it talks about? So we agreed that this is applicable to whole of India. So Jammu and Kashmir is also included in this act. Unlike rest of India and Jammu and Kashmir, rest of India has DRT and DRAT. Except Jammu and Kashmir, entire country has DRT and DRAT. In Jammu and Kashmir, we don't have DRT and DRAT. We don't have there. So this exception is only for Jammu and Kashmir. Section 17 deals with Jammu and Kashmir. So in place of DRT, what we have in Jammu and Kashmir, we have district court in place of DRT. So section 17A says somebody would have filed against district court, a Jammu Kashmir resident, if he loses at district court, where he will go and appeal, High Court or Supreme Court? Somebody need to answer. If a person is High Court, so just note it down, section 17A agreed High Court. That's the answer. So he will go to High Court. Okay. Now, just coming to a different perspective, not related to SURFACE, just a different perspective. We go into IBC. I filed at NCLT as a company. I'm a defaulter company. I lose at NCLT. Then I go to NCLAT. I lose at NCLAT. Now, where I can go? Except IP professionals, they should not answer. They know the answer. Apart from IP professionals, I lose at NCLAT also. Now, after NCLAT, where should I go? District Court, High Court, Supreme Court. So just note a classic change. In IBC, there is no High Court. IBC straight away you go to Supreme Court. IBC, there is no role of High Court. That will be a differentiating mark between SURFACE and IBC. So that we will cover also in IBC, but just to bring it to the perspective that in SURFACE we have High Court, but in IBC we don't have High Court directly. We go to Supreme Court. So section 17 goes to High Court. Can all properties be enforced, or there is certain same time limits? Yes, exactly the same time limits. Can all properties be enforced, or there are certain properties which bank cannot take under SURFACE? If you can think of any properties where you think the bank cannot take under SURFACE. Woman is what I answer. I am not sure. It's jewelry. Okay. House. No, bank can take your house. Bank can always take your house. You have taken a loan. Okay. Now you tell me. I'm sure you all would be knowing there is one property. They are all secured. Yes, but there is one property bank cannot even secure. Suppose I have one land of 100 crore rupees land, and I go to the bank and say, take this land. Which nature of the land which the bank can never take, will not take? Agricultural land. However clean the property may be, agricultural land cannot be enforced at all, even if the bank is willing, even if the customer is willing. So suppose I actually have a, let's say, land of 100 crores and I want to give to bank and just want to take 1 lakh rupees loan, bank cannot even take, even though I'm willing to give the property. Act has specifically excluded agricultural land. The logic of excluding agricultural land was simple, because India is an agriculture dominated country, and it is assumed that a lot of farmers will lose their right if they started giving land to banks or NBFCs, so it will be having a problem. So that's why per se constitution also excludes agriculture income and taxation. So agricultural property is excluded. Now, when we mean, what do we mean by property? What do we mean by property? Can we enforce? Can I mortgage? Can I hypothecate brand my goodwill to bank and bank can give loan to me? Yes, no, maybe. Any example you can think of? Very classic example which made news in a lot of newspapers. Kingfisher. Kingfisher actually, the SBI and the consortium, they gave loan. One of the mortgage was the brand value. Any idea how much was the brand value coming? Any vague idea? how much the brand in 2013 the brand would have valued at approx 6,000 crore approximately. That was the brand value came. Now when the company went into SFA issue and all, SBI got it valued again from one of the firms of US who only deals in brand valuation worldwide, one of the best firms. How much valuation they give? Any idea? How much valuation they would have given? So this is 5,000, 6,000 crore. We know it's all in public domain. How much value the second valuer would have given after the fraud happened, after he ran to London and all? How much you think the value would have come for the brand? Approximately value. No, not that. It cannot be that different. No, so it came approximately 1,500 to between 1,500 crores to 2,000 crores. That's the brand value came. So the problem of this issue was, this is all subjective. Valuation is subjective, but the court says you cannot have that much difference between, even if you follow all the standards, two valuer cannot have that much difference. The only reason why I presume the valuation would have gone to 5,000 crore, you always get a biasness. And yesterday we discussed on biasness. Why we get a biasness? If I tell you that you need to value a company where the promoter is a sitting member of parliament, owner of the largest liquor company in India, the credential always goes up. Whenever you say it is a member of parliament, yes, the value goes up because you think he can get so many things under control, and politics is priceless. So might be that factor would have worked and the valuation could have gone very high. So anything which you can demonstrate has a value can be mortgaged to the bank. It can be your brand, your goodwill, your patent, your copyrights, debtors, stock, anything tangible, intangible, movable, immovable, which you can demonstrate has a value, can be hypothecated to the bank for a under SFA for a secured property. Now, suppose I have taken a loan from a bank and I have 10 properties with me, but I have mortgaged only one property to the bank. I defaulted on the loan. Can bank take my 10 properties to SFA, or they can take only one property which is mortgage and secured? So bank can take only one property which you have secured, which you have hypothecated to the bank. Even though it becomes short, bank cannot take under SFA all this property. So under SFA only those properties will go which have been secured to the bank. Now just note down this. What is the designation of authorities who passes the order? So in the court, when the bank goes to take order for SFA, for the possession, who passes the order? So if it is a city which is a metropolitan magistrate, it is called CMM, Chief Metropolitan Magistrate. If it does not have a CMM, then they have equivalent to district magistrate. So depending on city, that's the section they have put. So it can be either CMM or DM. So the CMM or DM will give an order for symbolic possession. So for example, I have taken a loan and I have built a home. I have defaulted. The bank will go to SFA and they will go to court and say that I have taken this loan, I have secured this property. Now you give us a possession order. So the Chief Metropolitan Magistrate or DM, whichever is in Jaipur, will issue an order that now the bank legal person has authority to take over the possession of this property. So they will just go outside my house and paste one notice that government has allowed us to take possession of this. So you are requested to vacate within 30 days. So bank, it is up to the bank, whatever time they cooperate with the borrower. So borrower will have to vacate, else the police machinery has to come. So that is the reason SFA had a lot of fast recovery mechanism as compared to any other law earlier. And what is the designation of the bank officer which can take the case to SFA? So in the act, it is written not below the chief manager level. So just note down these two designations. So they ask questions in exam like this, which is the designation of a manager who can take action under SFA. So it's not like any assistant manager or junior manager can take file application to chief metropolitan magistrate. It has to be taken approval only up to minimum chief manager level. So this is probably the all points which are generally covered and generally question comes. So if we are clear on this, majority we are through. Still we'll run to a few of the basic points to understand. So this is not relevant. It is just a note why SFA came. SFA came because earlier we used to have an act called Recovery of Debts Due to Bank and Financial Institution. That was not working well, not giving good results. So, and a lot of public money was going out. So they started this act. This act extends to whole of India. It came in 2002, and 2002 onwards it was applied to whole of India. It gives banks huge faster recovery to take action. The first condition is whenever the borrower defaults, bank declares it NPA, bank will tell the borrower, so since you have defaulted now, we have made you NPA. And if the bank wants to take action against the borrower and bank thinks there is no point of giving chance, the borrower is a regular defaulter, bank will say to the borrower, now within 60 days, you will either pay us the entire loan. If you don't pay the entire loan within 60 days, then we will go to the SFA proceedings. So 60 days timeline is given to the borrower. So he may go some other bank, arrange any other funding and try to settle the loan if he does not want his property to be sold out. Now, suppose a bank has given a loan of 10 crore rupees to a person. He has mortgaged a property of 15 crore rupees. That is a fair value of the property. A bank has incurred 2 crore rupees expenses on recovery, lawyer fees, judges, court filing fees, protection area, boundary area, whatever area. So 2 crore or insurance. So 2 crore have been spent on securing the property. Now the bank has sold the property at 15 crore rupees. So the 3 crore excess which the bank has received, so 10 crore as adjusted against loans, 2 crore adjusted against expenses, 3 crore should be booked into P&L account, income from business sources or income from other sources by bank. What should be done? So fundamentally, which is the right principle, it is not a bank income. Even if you are getting anything extra, it has to be refunded to the borrower. You cannot take a call saying that lets the bank enjoy the money because bank has done all the efforts. And why they have put this kind of principle? One of the reasons they have put, if they allow banks to start booking income like this, so somebody may said the guy has defaulted, let's bank also get the rights for whatever reason. Then they don't want banks to enter into real estate business. Otherwise, what will banks started doing? Bank will started giving loan to real estates. They have started defaulting, and the bank started selling. It is not the bank's objective to earn money by selling real estate, and that is the reason they are not allowed to make any gain. Whatever gain excess comes, it has to go to the borrower, refunded back. But generally, this is a very rare that you will get more value than the loan. Generally, very rare. You generally get always less because the valuations are always overstretched. So when it comes to actual valuation, you don't realize that money practically. So what bank can do when the order passes? Bank can take the possession of the property. Suppose we are talking of a Jet Airways. Bank cannot keep all the planes at their bank's premises. So they cannot take a hardcore possession. So instead of taking possession of the property, bank can take over the management of the borrower. So bank can take a management of it. They can appoint their own person, their own manager, or whomever they deem fit. They can appoint as a CEO, CFO. That a bank can do. This is what all bank can do. Whatever way the bank thinks they can realize better value, the bank has a right to do. Three conditions. The debt has to be secured, mandatory. So there has to be some collateral, some mortgage, some hypothecation against the debt. Then only you can go to SFA. Unsecured debt can never go to SFA. Debt has to be classified as NPA by bank. If it is not classified, you cannot go. Outstanding should be minimum of 1 lakh rupees or more than 20% of principal loan and interest outstanding thereon, whichever is higher. security cannot be agricultural land. Even if the borrower is willing, agricultural land can never come into SFA. How the sales proceed are treated. So in case of example of 15 crore, or suppose instead of 15 crore, we would have sold land at 8 crore rupees. Then the first adjustment will always happens, first appropriation always happens to all the charges you incurred, all the panel interest, all the charges you incurred for taking the property. After that, you adjust against the loans, dues, whatever the bank actual loan you have given. After that, yes, you're free to discuss by audio whenever you want to. Just interrupt me, please. Yeah. After that, they can always refund to surplus if possible. Borrower means who has taken a loan, who has given a guarantee. When you have given a guarantee, you are also considered borrower. You have given a mortgage. So if somebody has taken a loan and you have given his guarantee that if he defaults, I will pay, you are still considered also a borrower if he defaults. NP, we understand. In case of deficit, then you can go to court for recovery. Then you can go to normal court for recovery. Then SFA will not do anything. So suppose it's a very good question. Suppose I have taken a loan, let's say same example, 10 crore loan, property realize only 8 crore. So 2 crore loss. So now it's up to the bank. Should you happy with the 2 crore loss? Or if you think I have other properties, or you can go to civil case here. It will be civil case, not 138, because your check bouncing will not happen. No, they cannot proceed against guarantor without the first borrower. First will always go to borrower. When it exhausts, when the proceedings against borrower exhaust, then you can go to guarantor. Otherwise, you cannot go directly to guarantor first. In exam, a simple question come, which is a very illogical question come, but again good for us if question like this comes. What is the full form of NPA? Non-polluting assets, non-projecting assets, non-progressive asset, non-performing asset. So I'm sure none of us can go wrong in at least NPA definition. That's we have to go through. Then they ask the simple questions. What is the substandard criteria? So substandard criteria is from 90 days to 12 months. If your outstanding dues more than 90 days up to 12 months, you are classified as substandard. From 1 year to 3 years, what do we call? What is the category we call from 1 year to 3 years in banking terminology? If there is a loan is defaulted, it's doubtful. And 3 years above is we call it loss. So they just ask a simple questions of 1 to 3 years has been NPA, what category it will fall? So it is doubtful. 3 years above it is loss, and 91 to 12 months is substandard. So that simple questions they will ask. That's what they are asking. So just be aware of that. Property we discuss means any property. Property means immovable, movable, rights, receivables, debtors, intangibles, brand, trademark, license, whatever you think has a commercial value, you can get a valuation done, and the bank is satisfied with the value. You can do that. You can only secured against enforcement can be only against secured assets, whatever has been secured and pledged. That is fine. That is not relevant. Appeal we discussed. The borrower can approach DRT first, and then after DRT can go to DRET. Time limit is 45 days and 30 days. So just note that time limit. That will be sufficient. Yes, borrower can still negotiate when the recovery is in proceedings, and generally banks negotiate. Because if the borrower is giving a plan, whatever percentage, banks are giving an opportunity to settle off. Generally, they do that. It can be enforced if you want. It can be enforced here also. So suppose if the borrower, that is secured, because if I say that if this guy is not paying, then I will pay, then banks will take on me that now you pay. So though I have no assets, but my guarantee will itself is a secured.
No, so
yes, bank can also go on appeal.
Your point was that only secured assets can be taken to SFA. So it is that personal guarantee is not exactly. Will it be considered as a security?
It is secure. It is considered as security. Yes, it is considered security, and that is one of the reason. If you realize, when Anil Ambani's companies got defaulted, so first he made a statement in newspaper that I have not given any personal guarantee. I don't know if you can recall a few months back when his companies got defaulted. So he made one public statement that I have not given any of my personal guarantee. So then a lot of analysts have gone back and a lot of banks have gone back to see why they have not given. So in India, he has not given any personal guarantee. So he could not be proceeded under SFA. But in one of the London Bank, yes, he has given a guarantee. Then it becomes an issue. So what do you mean by personal guarantee? So just like I mentioned, brand. So if I am company saying my brand is 100 crore rupees, so that is the value I have given you. Now you have taken that brand value and taken considered as a brand and started giving me funding accordingly. But my brand is actually coming only 10 crore. So that is the assessment bank has made wrong. That is one. Now if I say, suppose if I am not saying paying, my brother will pay. Now my brother has not given any property documents to you. My brother has just given you a plain guarantee that if he defaults, I will take care. Then it falls back on me because personal guarantee is considered as a secured asset also. Because so that is the reason people say that do not give guarantees to banks or companies or any unknown not so close friends and family because it might get in trouble. Luckily the banks are not that aggressive on borrowers. Suppose third party is given, so generally banks are not aggressive on third party generally. But if you go strict by the law language, they can always claim money from you. IBC is more stricter than it. So in SFA the rule is they are first consume entire resources of borrower. If that is not sufficient, then look into the guarantor. So guarantor always has a second line of defense. In IBC, they both are first line of defense. If it is a choice of a IBC professional to take only borrower or take only guarantor, because he realizes that if I break my head with the borrower, it will not deliver me results. Let me directly sue guarantor. He can still do that. So that is one of the few things which they do update civil. They need to update civil, and civil is the only way they can threaten people. So this is all about
Sumit, just in a brief, if it was that SFA is the act under which the manager will be approaching the DM for that order. Once he gets that, the borrower can appeal to the DRT or the DRAT later on and the courts thereafter. That's in brief, right?
Yes, sir. Yes, sir. Exactly.
Okay, thank you.
Indian Stamp Act would have been done in your last session or not yet? No. Okay, then we'll ignore. So I was taking some questions, then we'll not do that. And we'll take questions in next class. I thought in the last session would have happened. Okay. So just give me 2 minutes time to settle the screen for IBC. And whenever you get time, once you finish the exam, just look into the Kingfisher case. It's an interesting case for professionals to understand how the value got so high, and the case is still going against in SFI on the valuation field. And now we have Rajkumar ji and Iti ji who will be taking the session now, helping me in IBC. IBC, I'm sure we all would have been hearing so much and reading so much, so I'm sure everybody will have a fair idea. May not be detailed, but at least fairly we know what IBC is doing, what is happening. So IBC is a game changer which happened recently. I know Stamp Act will be covered by Preeti ji. So I thought it was done last week. I was not aware that it was not done. So it will be done tomorrow then, I guess. Yeah. So just okay. In the meantime, if you can, let me take you to Deepak ji. Deepak ji अभी चले गए. मैंने 2 मिनट के लिए बोला था. जब तक दीपक जी आते हैं, we'll take one PDF. I want to take one PDF to you. You can see this PDF.
Hey, Sumit ji, I'm here. Actually, I'm on the other side.
I know, sir, you are here. I'm just think I want to show something to you before. So I was just waiting for you if you're here. I'm trying to show you one PDF. Just a second. Again, not related to the course. No, related to the course, not related to my subject, but just one thing I want to you to see and check out. Question number 56. Read question number 56 and give me your answer. Screen is not visible, तो सर राजकुमार जी फिर इति जी को कैसे दिखा?
आपके स्क्रीन में ऐसे लिखा रहा है सुमित has started screen sharing, बाकी आगे कुछ आने।
सर मेरे ख्याल से आपके एंड पे इशू है नेट पे, क्योंकि बाकी सबके आंसर आ रहे हैं, इसलिए तुमको स्क्रीन दिख रही है। सर आई नो चॉइसेस आर गुड टू यूज, बट यू कैन एक ही चूज करेंगे ना सर, दोनों कैसे चूज कर लेंगे? See, the problem of life is I want everything, but the MCQ problem is they want only one thing. So choose only one, at least for this exam purpose. I like people who questions. I like Chetan. The question is correct. Fine, question is correct. I know. And in my session or till whenever we are interacting, I would love you question. It's not what I'm saying may be correct. I may either you will learn or I will learn, but somebody will learn in the end of the process. So it's always good to question. Coming to your answer, Chetan, question is absolutely correct. I can understand where the doubt you're coming from. It's fine. जब मैं स्टूडेंट था मेरे को भी ये डाउट था, मैंने कहा ये पूरा है क्वेश्चन है, कुछ बच गया ना, क्वेश्चन इज करेक्ट, दैट्स नॉट द प्रॉब्लम. My answer, my question, the question is, it is the IBBA sample paper, exactly the question, and this question comes in exam. This question comes in exam. Now you need to answer, is voice issue for all? Because what is happening today, there is raining at lot of places. So at least in Jaipur it is not raining, but a lot of places it is raining. So network may be a problem at many places. Okay, now bear with me for 2 minutes. One, the question is correct, that we all know. We also know A and B is not the answer, right? We also know A and B cannot be the answer. Answer will be either lie between C or D. That's what we know, right? Now see what the answer IBB has given first. Just a second. Okay. Now this is a complete wrong answer. So in the sample paper, because IBBA was in a hurry to produce sample paper, so it was a typo error happened. Immediately they put answer 1. Now what will happen, and the reason of showing this problem to you, we should not blindly learn the MCQ answers blindly. You need to apply logics and then figure out. If you're not able to understand logic, then okay, go with what answer is saying. But now I'm sure everybody common sense logic was going C and D is the correct answer. So D cannot be, A and B cannot be the correct answer. But here they've given a wrong answer. So do not consider answer as A. Now what has happened now? IBBA has updated this correct answer on the website again. So if you go and download the sample paper today, you will get a correct answer. Now what is the correct answer between C and D? Ideally 10% 10 years makes sense. So it will be between C and D. Given the two things, the problem of this question is, which is the bond has shortest duration? Now this duration word, again note it down, duration. You need to research on duration before you go for exam, because a lot of questions are coming on options and durations, because duration comes to bond. Now the correct answer is D. D is the correct answer. Why D is the correct answer? What do we mean by duration? Duration means two things, primarily two things. One, the time period. So tenure means D, 10, how do we understand out of 20? 10 is a time period I'm getting faster, that is shorter. Second, how much faster I will get my recovery? How much faster? No, there is no sensitivity happening here. Sensitivity is not happening. Here what is happening? Because in a bond, if it is, I'm just giving a debenture, 100 rupees debenture, and I'm giving you 10% coupon rate. So price sensitivity may not be impacting me because I'm just getting a, yes, less time, more return. That is what the duration is. So if I am having a bond of 10 years with 10% coupon rate, my recovery rate will be faster. So in the shorter duration, I will be getting money faster. That is the reason the answer would be 10, D. In exam, you may get another question, which bond will have the longest duration? I'm sure now we all get the correct answer for that. If the same question that changes to longer duration, the answer would has to be B, because then 6% will give you longer returns. So that would be, so go, so okay, A is an incorrect answer. It is a typo happened on the IBBI sample paper. The only reason of showing this was to you that do not blindly go through sample papers. So A is incorrect answer. Now if you go to now website, अगर आप Google से ढूंढेंगे sample paper ये वाला तो आपको गलत answer मिलेगा. Now you go to the source document of IBBI, they have corrected this. But again, my point of mentioning only this, do not blindly learn all MCQs, just go through the logics and you all will have good logics to find out. Just take care of logics. Let me share the now PPT for IBC. Now, so IBC has started in 2016. It is considered as a game changer in debt recovery process. Last 3 years have been a roller coaster ride for borrowers and lenders. Some people were very happy. Some people were not happy. Is it good or bad? There are two sentiments of people in the market. Somebody will say this is just made for banks to just made for borrowers to banks are giving huge discount, borrowers are misusing it. Some people are saying banks are misusing it. It's a both way sides happening. But what is my personal observation that I will tell at the end. But before that, answer the first question: why this code was needed? I'm not looking for a right answer, wrong answer, a thought process. Just why? What do you think this? What led have to have this code coming quickly? What is the question? Just a second. If it is 10 years with 10 years, just a second. I missed the question. So if it is 10 year with 10% and 11 year with 18%, shorter will be 2 years, even if 10 years is less than second. Yes. Then you will see how much money is faster. Exactly, Deepakji, then shorter will be second year, second options.
But on the face of it, you see, one would think that 10-year maturity is, of course, a shorter duration than an 11-year maturity.
But in the bond, duration also means the recovery money. So if I can able to recover my money faster, because in the 11, you will be able to recover your money faster. So it will be, again, you need to do a calculation. So it will be a mathematical model calculation would be done. And then the recovery of money will be taken out. So then it needs to be followed. Generally, it looks 18% will be faster. It looks. So if you follow the calculation, the model returns and discount, whatever gives you first value, will be able to find out.
Okay.
Yeah. So there are, yes, whatever all you have mentioned, this is the reasons. But one of the reasons which was jokingly quoted in so many places, that this act was needed because of this person. So on a lighter note, they used to always say, when the king of good times started having a bad time, things started turning ugly for Indian capital markets. And why things were started turning ugly? Because when a sitting member of parliament takes so much of a bank loan and moves out of country, and the banks, the financial institutions, do not have any mechanism in place where they can do swift recovery or fast recovery, they say that something is wrong with our system. And then, and again, Mr. Mallya has just become a poster boy. It is not to tarnish his image. It is just one of the examples you just quoted. I have no personal enmity against Mr. Mallya. Do not quote me anywhere. Because if he comes back, he will be still a member of parliament. So do not play with politics. Mr. Raghuram Rajan made a very classic quote that time. The then RBI governor, he says, and it was quoted somewhere in 2014 when he was on the helm of the affairs. He mentions, "We do not punish the wrongdoers unless he is small and weak. Nobody wants to go after rich and well-connected wrongdoer, which means they get away even more." And that was actually happening in India. So if you are having a political connections and if you're taken a bank loan, nobody can touch you. But if you're not having any political connection, then every small banker will come and threaten you. So that was actually happening. And this is all what they were a little bit scared. Just give me a minute. I was seeing my video is not working. So tomorrow Vijayji will say you have not on your video. So let me on my video also. Now, what was happening in 2015? This is a 2015 data. So World Bank has given a ratio of world entire country economies. What is their NPA ratio? Greece was coming very high, and India was coming approximately 10% of NPA. But there was a doubt among World Bank that India reported data may not be the correct data. The banks might be fudging the actual NPA ratio, and according to them, the actual ratio would be more than 20%. That's what the bank estimate, World Bank estimate at that time. This was a very scary number. Another scary declaration they made in the World Bank report came in 2015 was it took average 1 year, 1.5 years in UK and US to get resolution of insolvency. So some company has gone into trouble within 1 to 1.5 years. The rules are so good, it can get a shape. In India, the average time was 4.5 years average time. And ironically, see our country, one of our neighbor country, Pakistan, was having 2.7. This actually hinted the running government at that time. They say that this actually number is not in a good sense, and this actually defaming that why you're taking so much of time. And when your neighbor country nearby, if we compare Asia and Europe, then we can always argue, okay, Europe is a better country, more sophisticated, more knowledgeable. But within Asia, if I compare Pakistan is doing this, India is doing that, and China is doing, then we cannot say, no, we don't have infrastructure. You are in the same continent almost. So that was a concern government had at the time, and this report was actually scary. Then World Bank another issued a report which says India used to rank 136 globally on resolving index. So 136 was a very, out of 200 countries, if I say you are at 136, it's not a good sign to discuss. Whereas the other countries of Japan, of our Asia, were under below 100. China, Indonesia was below 100. And the global recovery rate, so that means if I have put $1, if an investor has put $1, if he is gone into Japan or Singapore, he would be able to recover 92 cents out of it. But if you put $1 in India, you will be able to get 25% out of it, 25 cents. So that number was also not a great number. This led to the government working fast, and we need to appreciate the way government has worked to pass this IBC code. They worked on a drug so fast they proved, and in 2016 March, first draft would have came approximately, and 2000 November the bill got enacted. It was very fast because we got IBC launched. Our ratings from 136 went 130 in 2016, 2017 we reached up to 100 because by the time the impact of IBC was actually visible. 2018 it reached up to 77. 2019 their target was to come below 50, but there is one reason why we could not touch below 50, and that we'll discuss that reason also. So that was expected. Government expectation was we should come below 50. So and one of the reasons why it did not cover below 50 because we started IBC in 2016 with the view that it will apply on companies and individuals also. till 2019, we only have companies. Even till today, we only applies to companies. We do not apply to individuals. So that is the reason our rating did not reach up to 50. So it will take another 2-3 years to reach there. So that is the changes happened recently. What was before that? What was happening in India? We talk of corporates. We used to have Companies Act, then we got SICA, then we got RDD-BFI, then we got SFA. Then still also there was a vacuum in recovery mode. Then Companies Act came, new amendments came in winding ups, and then in 2016 this code came, which actually had covered all acts in one. And for individuals, we have only 3 acts: 1909, 1920, 1932 that can work on individual and partnership insolvencies. So objective of IBC was to consolidate and amend all the laws relating to insolvency of individuals, partnership, corporates in India in a time-bound manner. And the main objective was so that the value of assets can be maximized. So suppose if a company has gone into insolvency or a liquidation today and he has an asset of 10 crore rupees. Now, if the company closes on next 4 years, after 4 years, the 10 crore might be 2-3 crore because we have lost so much of time. The value and the asset may deteriorate. Here, the objective is within 6 months, you try to resolve it so that out of 10 crore, at least 7-8 crore you can realize. That's expectation, and which is a reasonable expectation. How much it covers up, that is a different story, but there's an expectation of the government. And once you start IBC, you will get World Bank funding more because World Bank have a trust on you. And why availability of credit? Because World Bank says if our investor comes in India and they cannot exit through IBC route, they're not able to exit on insolvent companies, why should we come into India? So after this IBC, investors' sentiments have gone positive. So these are all theory. Any thoughts why it is called code? Why not act? Because we would have had so many acts: Income Tax Act, Companies Act, GST Act. Why this is called code? And why not act? Any thought process? Anybody like to speak or answer? Bunch of act. So they call it, why it is called code not act? Because it supersedes all acts and separate laws was there for each separate persons. This codifies, this consolidate all laws relating to insolvency into one law, and this becomes a master stroke itself. Because the thought process of the bench or the people who are making this law, they say if there is an act, then to make an amendment in all different sections, it would have taken ages. But with this one IBC code getting passed, 27 acts got amended with one simple notification. One official gazette, they says, tomorrow IBC is effective. Because of IBC, certain acts will go and change 1, 2, 27. So many acts got changed just because one letter would have come. Had they would have made only act, and each act, no act can supersede other act. So we need to go through different process. So that was one of the effective. This code is incomplete itself. As of today, this is superior to all acts relating to India in India for any insolvency or bankruptcy. That is the ultimate crux as of now. So IBC covers all. I'll skip those things which are not relevant. Time bound. So we discussed our rating was just because it's taking long time. Now it is expected that because of time bound manner, we are jumping from 136 to 63. Another current rating of 2010, 2020 will be coming in October 20. Every October, because so many changes happened. Let's understand the entire layout. Those who don't know IBC, it's for them. Those who don't know IBC. Is IBC applicable to whole of India? Partly true, partly correct, or fully correct? राजकुमार जी, आईबीसी पूरे इंडिया पे लगता है या कहीं नहीं लगता? आफ्टर सेक्शन 370 को भी हटा दे. अभी कोड में क्या है? एग्री 370 हट गया कोड में. So IBC mate was a funny thing. So there are, I'll come to that part. So there are 5 parts in IBC. Part 1 talks about criminal living. That's just a basic definition of IBC. Part 2 talks about corporate persons. So corporate persons means company, LLP, or anybody with limited liability, limited structure. So since inception, since 2016, this was applicable to whole of India. Corporate was applicable to whole of India, 2016. 2016, we also have part 3. So part 2 only talks about corporate process, and that is relevant for your exam. That is, we have a liquidation process, and this talks about what happens in corporate process, voluntary liquidation and all, is relevant for our example. Part 3 talks about only for insolvency resolution and bankruptcy process for individuals and partnership firm. Since inception, it was not applicable to Jammu and Kashmir. So when they made a law, they say for companies in Jammu and Kashmir, we will apply IBC. For individuals in Jammu and Kashmir, we will not apply IBC. So part 3 was not applicable because of section 370 impact. As of now, still it has not amended. If we go to part IBC regulation, as of now also it is not amended. Though section 370 abrogation has done, it is abolished, but in the code itself it is not amended. So part 3 is not relevant for you, and it is not active also as of now. Why it is not active, we'll understand once we finish part 2, we will find out why it is not active. Part 3 is not active. So when I say part 3, it means insolvency on individuals and partnership firms not active as of now. It is not in place. The draft is there, but it will take time to activate it. Part 4 not relevant for you, but just for understanding. Part 4 talks about who are insolvency professionals. So just like we will be registered valuers, we have an insolvency professional in the IBC. They have the same process. There is only one little different process. In IBC, you give exam first, pass the exam, then do 50 hours of training. So what you are doing today, you need to do after you become IP. Here in valuation, it is different. First, you complete 50 hours training, then give exam. So IPs can be CA, CS, ICWA, and a lawyer with a 10 years plus experience. That can be IPs. What are IP agencies? IP agencies are, as of now, as we discussed, we have 14 RVOs in valuation. In IPAs, there are only 3. So only 3 bodies have been recognized by IBBI: CA, CS, ICWA. Only 3 institutes can conduct programs, and only members can register only these 3 institutes. Information utility is a utility tool, online platform where banks upload the data of loans taken or defaults. It is just like CIBIL. Here, anyone can upload. So suppose I am an individual, I have given a loan to you, and we have documented. So you are a company, and you have taken a loan from me. I can go to information utility and upload the details that you have taken a loan from me. Detail will go to you. You verify, you update it. So it is just a process where government can come to know when the disputes happen. Your loan has been recorded in information utility or not. That becomes a evidence. Part 4 not relevant for exam purpose, so do not put much stress on that. Part 5 just talks about miscellaneous. It talks about IBC chairman salary, IBC others disciplinary conduct, which is not relevant for our syllabus. So our syllabus only relevant is. So let's understand the basic characters of the code. Once we understand this, then half of the IBC will be at least logically available to accessible to us. So if we consider IBC as a story, the first character is corporate debtor. What is corporate debtor? Here, corporate debtor does not mean trade receivables. So do not confuse. Corporate debtor means the person who has taken a loan, the company who has taken a loan. So as of now, we'll only talk about companies or LLPs. That is what applicable for us. So suppose I am a company, I have taken a loan from a bank. So for this act purpose, I'll be considered corporate debtor. I think there is one. I think there are one or two mics which are on probably. Just okay. So this definition confuses a lot of people because they say corporate debtor means somebody whom we have to take loan, take money. It is not trade receivables; it is the borrower. So corporate debtor means any company who's taken a loan. Financial creditor means any person. It can be you, it can be me, who has given a loan to a company, or and the objective was to earn interest. Time value of money, if you have given a loan, you are considered a financial creditor. Okay, that is one. Where you are providing finance exactly. Operational creditors are those who has rendered goods and services to that company. When I say company means corporate debtor, CD. So if you have given audit services, audit fee, rendered audit services or valuation services to a company, and they have not paid you, you are considered as an operation creditor. So if this three is understanding is clear to non-IPs, sundry. Sir, sundry creditor would be as per the company's balance sheet. As per the company's balance sheet, it would be sundry creditor. But as per the code, we will be operational creditors. Correct? Fine. So you understood. So I have two questions. Only Iti ji and Rajkumar ji will not answer. Rest all us will answer. Why I'm excluding them? Because I'm sure they know that because they are working in that, so they know the concept. But the two concepts: one, income tax dues, income tax, TDS to be deposited. I need to deposit TDS to income tax. So I have collected a TDS from or any tax dues, government dues, sales tax, GST dues. The government is a financial creditor or operational creditor. So I am a corporate debtor. I'm a company. I need to deposit, let's say, income tax dues or let's say GST. So I'm a financial or operational. And we know that there is an interest charge on delay also, right? So if I don't pay income tax TDS by a certain day, I need to pay interest also. So am I financial or operational? Okay, so those who are saying first operational, those who are saying first, Atulji is taking a safe position. Let's come out. Okay, my first query is those who are mentioning operational. Okay, did government provided me any goods or provided me any service? We can always argue, yes, indirectly they've given you infrastructure, they've given you right to live in the country, blah blah. Fine. Directly no, rightly no. Fine. Again, I'm not coming anywhere. We have not concluded. And those who are saying financial, did government give me loan to earn time value of money, or it's a penalty what they are charging, or their intent was they want to charge money from me? The intent was never to charge money, right? They never wanted me to earn interest out of my income tax dues. That was not the objective. So in case if that is not the objective, in that case, prima facie does not seem it falls into any of the category. But if I exclude from the category, then the law of recovery also loses. So in the code they have decided and they've enshrined in the code that the government dues will be considered as an operational creditor. So now the government will come into operational creditor category. So if I need to pay a TDS dues, it will go into operational creditor category. That is one. Second, I am a real estate company. I've floated a new project and I asked people that I'm digging अभी मैंने गड्ढा स्टार्ट करा है, मैं यहाँ पे 20 फ्लोर का बिल्डिंग बनाऊंगा. You pay me advance money now so that you will get a discount in price, and after 2 years I will give you a flat. People who have given me advances now, they are financial creditors or operational creditors. And I defaulted. I am not able to make the building. So now we are going to IBC. So I am a financial or I am a operational? Did they give the money to earn interest or to or to get a discount. So clearly we understand they cannot be operational creditor, right? Because neither they've given goods nor they've given a service. They want to take a product. So they are not operational creditors. That's what we understand. But what happened first? In 2017, in the first judgment, NCLT declared that the flat owners, home buyers who have given advance will be considered as an operational creditor first. Later on, in 2018, in Amrpali case and JP Infra case, which I'm sure we all are, those are from Delhi side are aware of that case very much. Amrpali and JP, it was overruled, and NCLAT decided that now home buyers will be considered as a financial creditors. So as of today, so this was the rulings first. In 2019, in the code itself, they added this term home buyers, and they added in a definition that now financial creditors include home buyers. So as of now, now this dust has been settled. Now the home buyers are financial creditors because it is assumed that the interest, the advance they've given, it is a deemed interest. They want to reduce the price. So that is a home buyer. That home buyers are now financial creditors. End of the discussion now on this. Now what happens in IBC if financial creditor says the corporate debtor CD has not paid my money, or OC says I have given a bill of 2 lakh rupees for audit and the company is not paying me, we can go to NCLT and say this company is not paying my dues, you need to take action. So what NCLT will do? NCLT will say, and it is proven that this company has not paid. Fact is that it has not paid. Genuine dues have not paid. So company NCLT will say, if you have some IRP with you, if you want to appoint your IRP, let me know. So FC will say, let's say FC is let's say SBI bank. So they will say, Sumit is on my panel, I want to appoint Sumit. So NCLT will ask them, if you have a IRP, you appoint your IRP. Else, we will appoint a IRP. It is mandatory. What is the IRP? Will come to that. First, understand it is mandatory for FC, for financial creditor, mandatory to name an IRP before going to NCLT. It is mandatory. For OC, it is optional. अगर आपके पास कोई हो तो आप दे दो, नहीं है तो NCLT will find and arrange on its own. So that is the thought process. What is IRP? So there is one person called interim resolution professional. NCLT will say we agree that this CD has not paid bank loan of SBI or has not paid fees of auditor. So we want to appoint Mr. X as an IRP. Now Mr. IRP will take care of this company for next 30 days. That is the first IRP is generally for 30 days. If after 30 days the committee of creditors approves him, he will work for next 180 days, total 180 days period, and will try to resolve the problems of the company. So if the company is having cash crunch, he will try to find out a new business model or whatever, so that the money outstanding dues of people can be settled. So that's one process. Generally, IRPs are appointed for 30 days generally. It is up to the committee of creditors. If they want that this person should continue, then after 30 days, it is called as resolution professional. 99% it happens if the case is filed by FC. Same IRP continues as RP generally. And 99% it happens if the case is filed by OC. 99% IRP changes to another RP. It changes. And why it changes, that also we'll understand. What is the difference between IRP and RP? These both people have same qualification. Both are IBBI regulated professionals. There is no difference in their hierarchy. The only difference is IRP is appointed for a short-term gap to get things in order. In 30 days time, when he gets the things balls rolling, committee decides should we want to continue this person or want a new person. And it all depends on whom you like. Your likings matters a lot here. So if you are blue-eyed boys of a bank, the COC will continue you. Else they will find a new COC, new RP. If 30 days after the same RP is same person is continued, so then the process goes as it is. He will continue as a RP. If he does not continue, the bank says either the COC says we want to remove you, or he himself says I don't want to work, the company is not good, or I don't find much revenue opportunities, he may exit and a new RP will be placed. Then current IRP will hand over all documentation, all emails, everything, last 30 days, whatever he has done to new RP. So handholding will be there so that the RP can take care of things. What is a committee of creditors? So what happens when you go into NCLT? When you go into NCLT and the NCLT declares that this company is actually defaulted, now it should go into insolvency process. We are appointing a IRP on RP. Then for next 180 days, till the time period it is going on, the power of the board suspends. So all the board of directors stands zero. IRP or RP becomes the boss. So suppose there is a board of 10 directors earlier, then there will be only one director. That one director means that RP will be the only one BOD. So CEO bhi wahi hoga, chairman bhi wahi hoga, everything will be that only one RP. So RP gets all the power of all the board, and the board cannot function in next 180 days. That is one. Now we cannot give power only to RP, so there has to be a check and balance system. So they made a committee of creditors. This committee of creditors to be formed by all financial creditors. We'll discuss how is decided who is FC and all that we'll discuss once we come to the process. But as of now, all financial creditors are considered as a part of committee of creditors. But there is no conflict. Why there is no conflict, Chetan? The simple reason there is no conflict. These guys are actually given money to you. So they have given a money to a company. So the company cannot run the show. If the companies cannot run the show, then they want those lenders to come on the board and run the show. So it's like अगर मैं आपको बोलूं कि सर आप अच्छा डांस नहीं करते तो आप क्या बोलोगे? चल भाई तू आके कर ले डांस. This is process है. मैं बोलूं सर आपसे कंपनी नहीं चल रही तो भाई आप चला लो. Though the promoter never wants this, promoter will never say आप चला लो. तो एक नायक मूवी में हुआ था, सर आपसे सरकार चल रही, एक दिन का आप मुझे सीएम बना दो. नायक में होता है, लाइफ में नहीं होता. तो nobody wants to give the power to you. But here the law has made such a way that the power shifts from borrower to lenders, and this is actually a good move, because if you have this kind of reason, a borrower will always be scared that if I don't perform diligently, things might go from my hand. And I'll discuss few which actually show why IBC proved good things for a lot of people. We'll discuss that. So primarily, FC should be a committee of creditors will form of financial creditors. That's one. But what if the related parties are financial creditor? For example, we are considering a CD who has genuinely taken a loan from subsidiary, holdings, or associates or joint ventures. It's a genuine loan we have taken. Due to board is resolved, I'm asking practical situation. We'll come to Chetan. Park a question of practical because we are just start. We have to cover a long way to understand IBC. So we have still 1.5 hours left. So we'll cover so many things. I'm sure by the time it will be cleared. So, and there might be genuine I would have taken from my subsidiary, my holding, genuine loan or genuine interest. But the law says, even if I have taken a genuine loan and I give right, in that case, will I be biased to creditors? I'll be biased to the company. Obviously, I'll be biased to the company because I'm a related party. So that's the intention. So the law has mentioned that these related parties will not get a voting right. They can just attend, but they cannot speak. So not have a voting right. Suppose there is now that is one. So we understand related parties cannot be considered under composition of COC. They will be only a can be only a spectator. They can only watch. They have no right. So now what will happen if there are all related parties which are all FCs are related party? So there can be two scenarios. One, I have all FCs as related party, or I have no related party. I have no FC. For example, if you go to Infosys or Wipro, they have no creditors, they have no bank loans. So there are no financial creditors in certain companies' balance sheet. In that case, how do you form a COC? Any thought process? I know IPs knows that, like those who are working, those who read or knows this, but I'm just posing a thought process. So suppose it may happen there is a company which has no financial creditors, or all financial creditors are related parties. In that case, how do you form a COC? Any thought process? Would be, what do you think the law would have thought of? Because practically it may happen. You have, my question is, sir, there might be a possibility where all financial creditors are your related party. So in that case, the law says you cannot make a COC of them. Related parties cannot be a part of COC. They have no voting rights, or you have no financial creditors. Just like companies like Infosys, Wipro, who only have cash balances, they don't take loans. So if you have no financial creditors, then how to make a COC? So the law has mentioned if there is no FC or FC only related parties, then the COC will be formed from top 18 operational creditors. So if you can note it down, or else it will be there in the slides just for your understanding. COC will be formed for 18 operational creditors, which is higher in value, up to 18, or and one representative of employees and one representative of workmen. So 20 people will form COC in an exceptional case where there is no FC. It actually happened in a case where there is no FC. That actually happened. Related party we discussed. Related party means what is a related party as per Companies Act. So if you follow the definition of Companies Act, related party, your subsidiary, associate, joint ventures, directors' common interests, that becomes a related party. What is related party here? So they should exclude. I am not getting the question. Debtors is outside of India. Debtors means when you are.
Basically, we took the loan from the bank, and we have some suppliers also from India, and we sold the goods to outside India, and we are not getting back the money. So that obviously we cannot repay back to the loan to the bank, or we cannot paying the money to the financial operational creditors. Then how the case will be decided? Basically, the genuineness of the case, whether the goods has been delivered to outside India or not. Basically, the NPA also done, and the recovery process उस case में कैसे?
I got your point. We'll just park this question. I got your point. You have gone to IBC stage. I'll come to this question probably after 15 minutes when we'll cover this process. I parked this question now. I understood what is coming here. From where what will happen in actual case, and this actually happens. It's a practical problem for a lot of people. We'll hold this question for some time now. We will take it once we are coming to the recovery process. Now comes the most important date called insolvency commencement date. What does this mean? This date is the date where NCLT approves your order. So if I am a FC or a OC, I goes against that company, that this company has defaulted, and NCLT accepts that yes, the default has actually happened. That day when the NCLT passes the order is known as insolvency commencement date. This date is important date because it is linked, all activity are linked to this date. So for example, they say that you need to give advertisement within 3 days. So the 3 days starts from insolvency commencement date. You need to complete the process in 180 days. That 180 days starts from insolvency commencement date. So this date has a lot of importance in IBC process. That's the starting point. Now comes a concept of moratorium. Moratorium means for next 180 days or till the IBC process going on, IBC gives you a special power that is like a kavach, like Suraksha kavach. For 180 days, nobody can touch you. all proceedings, all legal cases going on previously, all surfacey proceedings puts on hold. So the moment I got ICD activated, then the day ICD is decided, from that day till generally next 180 days, nobody can touch the IRP or RP, so that 180 days, the RPs or IRPs can work with a peace of mind and try to work out the probable solution of a company. And why this moratorium is granted? For a simple reason. Imagine the person who was running a company from last 10 years, 20 years, 30 years. If they cannot run the company for any particular reasons, you are appointing a new person on the board and you are taking the power of existing board. So existing board is suspended. How can you expect a new person to work with a lot of hustle and bustle? If he's getting so much problem, every day income tax officer will come that your due is there, your assessment is happening, a GST recovery will come, a legal case going on for any matter comes to you. So it is expected that he will not be able to deliver properly. So the concept of moratorium has been introduced that for 180 days, nobody should touch him. That's the expectation. And this actually helps a lot of companies to revive. What is resolution plan? So we understand, just like take example of Ruchi Soya. I'm sure you all would have read Ruchi Soya, and it is in newspaper. We all are aware of what happened in Ruchi Soya. So Ruchi Soya, we know that has gone into trouble. Banks have gone into NCLT and say that Ruchi Soya is not delivering us good results. We want Ruchi Soya to go into NCLT. Judge admitted it. Now it went into IBC process, resolvency process. Now what happens? So it will come into public newspaper that Ruchi Soya is under trouble. Anybody who wants to take over the management, who wants to acquire it, come and give us the plan. So HLL gave a plan, Adani gave a plan, Baba Ramdev Patanjali company gave a plan. So they all gave a plan that if you give Ruchi Soya to us, so RP would have given an information that Ruchi Soya has an asset of 10,000 crore, liabilities of 15,000 crore, plant machinery here, and various other details for acquisition and takeover. Somebody would have read in newspaper and they would have taken their own assumptions. So HLL would have thought Ruchi Soya has a good plant, we can make soya oil, let's take over the project. They would have done their analysis and they would have estimated a bid of 800 crore rupees. Then Adani would have read, Adani said, let me also give. So they gave a bid of 2,000 crore bid. Then comes Patanjali. They realize, any idea how much Patanjali would have taken Ruchi Soya at what amount? Any vague thought, very vague number? It came a lot in newspapers because it was actually a battle happening between 4,500 crores. So Patanjali gave an offer of 4,500 crore. So it was counter offer. So when Adani gave 2,000 crore, they gave 2,200 crore. Adani said, let me give you 3,400 crore. They say, let me give to 4,500 crore. So approximately that amount they bid it. So imagine HLL gave only 800 crore rupees and Patanjali come up to 4,500 crore approximately. See the jump the lenders is getting from. Agar मैं Ruchi Soya ऐसे बेचता, so I would have got 800 crores. When I went to the public process, I'm getting 4,500 crores. So at least the lenders are getting some benefit, not fully, but some benefit. Now, resolution plan is anybody in the world can see the plan, can see the company and present a plan to the COC and say, I would like to take over with the certain conditions. So what will happen here? RP will say, SBI has a loan of 10,000 crore, PNB has a loan of 5,000 crore, and Bank of Baroda has a loan of 3,000 crore. So total 18,000 crore loan we have. And we have assets of, let's say, 10,000 crore or whatever number of assets we have. They will find out that assets. Now, the applicants who want to take over the company will present a plan. They will say, okay, we can take this company. I can pay SBI 75%, PNB 50%, or Bank of Baroda 60%. They will give the proposed plan that we want to propose this much of haircut. If you agree, we will. You agree to the terms. We will give you that money upfront or in a later period, whatever as you agree. If you agree with our terms, we will accept your liabilities on our head, and then you give us the running power. So then the plant and the company management shifted to the person who has given a budget. Ruchi Soya has been recently taken over, and the acquisition has actually fully integrated, happened in Indore recently. Now, then what happens? So the process we discuss is for 180 days. It may happen in 180 days. There can be two scenarios. Nobody comes to take over. For an example of, let's say, you have a Kingfisher company, and the debt is so high that we know even if I take a Kingfisher company, flights will not fly for next 6 months or 1 year to the full capacity. I may not get the value. So it will be of no value to me. It may also happen. In that case, what will you do? Nobody will present a plan. So there might be two positions. Nobody presents a plan, or if somebody presents a plan, that plan is not approved by COC. It may happen that somebody says, out of 10,000 crore, I will only give you 1,000 crore, 90% haircut. So lender will say that why should I give you a haircut of 90%? Let me sell the scrap. I might get more than 10% by selling a scrap of a company also. So if you don't get any plan, or a plan is not successful, it goes into liquidation. In liquidation, again you go to NCLT and apply for liquidation. NCLT approves, then it goes into LCD. Now, payment order. Yes, resolution plan has to be given within 180 days. Exactly. Yes, it has to become within 180 days. Then you need to get approved. Once the committee gets approved, then it has to be approved by COC, NCLT also. We'll come to that approval process also shortly. Now, suppose if it is this, if no plan given, then we go to liquidation. So that's what we are coming to liquidation. Why? So insolvency and liquidation are two things. If I'm able to, somebody is willing to take interest in my company, we'll try to run the company. So it is just like putting a company on a ventilator. If the doctor is able to pump electricity better, give a proper treatment, the company may revive and come back to the normal life. If the not working on ventilator, then it has to die in a natural process of liquidation. So it will go to liquidation. One of the classic thing has actually changed this IBC code is payment order. What is payment order? When you go into liquidation, how the assets will be distributed? Who will receive first? So if you can recall, in 1956 Companies Act winding up, who was the first person to get the dues? If you can think of. So if the company is going in a liquidation, which category gets the first dues? Always. Before loan also there is one person who will get dues. Before secured also there is one person. I'll not say one person, one institution which will always get it. सबसे पहले first dues, government dues will be always the first before IBC. Before IBC, the first will always government, always. So they will say all pending dues and all. Then comes labor. Government dues stands before labor also generally. In IBC, it has changed. Yes, Aguratan sir, absolutely. The first will always be earlier. Before IBC, the order was first all government taxes, dues, laws will go. Then comes labor, and then other things coming. That was the first general rule. First, now it got entirely toppled over. It got entirely changed. Now, what happens in the payment order? First will be given to whom? Before that, before this, first is IP. So law says, बाकी सब छोड़ो, सबसे पहले IP का पैसा चुकाओ. IP, that is interim resolution professional or RP. First pay that guy. So this is a profession which this is a code which at least take care of a professional. कि भाई आपने काम करा है, तो सबसे पहला पैसा आपका बनता है, आप लो, बाकी क्रेडिटर को हम बाद में देख लेंगे. We'll come to a payment order and understand what is the nitty-gritty and what is the problem in this payment order and why it is challenged a lot also. We'll come to that. Appellate authorities, as we discussed. So I am a company and you have gone against me in NCLT. NCLT approved, yes, the case is fine. and I think that it is incorrect because I have a dispute with you for some reasons. Within how many days from NCLT to NCLAT I can file my appeal? 30, 45, 60, 90. So there are two more options left, 45 and 90. So my query is, from NCLT, if I lose, order comes against me, from NCLT to NCLAT, how many days I can go? So the note the answer. Answer is, it is 30 days. So statutory timeline is 30 days. There is a 15 days grace period. That 15 days grace period can be given by NCLAT, considering that there are genuine reasons for a delay. But that does not make my answer 45 days in the exam. So in exam, your option will be 30, 45, 60, 90. 45 cannot be the answer from NCLT to NCLAT, because as per the law, time limit is only 30 days. That is the only time limit. 15-day extra grace is not your time limit. Now, if I lose at NCLAT also, then within how many days I can go to High Court? 30, 45, 60, 90. If I lose at NCLAT also, within how many days I can go to High Court? 30, 45, 60. I just wanted to check that only, because somebody said so there is no High Court. Now again, there is only Supreme Court. I just wanted to again double confirm. There is no High Court, only Supreme Court. Now from NCLAT to Supreme Court, how many times I can go? 30, 45, 60, 90. Now just note it again. From NCLAT to Supreme Court, where is Iti? Iti, what is your answer? Okay. Rajkumarji, what is your view? 45 days. So just note it down. From NCLAT to Supreme Court, the time limit is 45 days from NCLAT to Supreme Court. Again, Supreme Court has 15 days time period grace if they think that there is a genuine reason for filing delay. So it does not make 60 as an answer. So in exam, answer will be only 45 days. So NCLT to NCLAT 30 days, NCLAT to Supreme Court 45 days. That's the answer. And this is the beauty of IBC, that it is very fast. So there is no High Court. Otherwise, if the matter would have been High Court, then you know what will happen. Tariq pe tariq. Luckily, Supreme Court is acting fast and things are coming faster. But yes, again, Supreme Courts are also loaded with judgment. Withdrawal. Now, I am a OC or FC, whatever a creator I am. I filed a case against a company. That company has not paid. Government NCLT passed an order, COC formed, everything happened. Now this guy has come back to me and say, the owner of the company has come back to and say, sir, out of court settlement kar lete, please withdraw the appeal. I will pay you sooner. Or he gives me preferred plan, he gives me post-dated checks. Can I withdraw the appeal? Yes, no, maybe. So I am the person who initiated the complaint. Can I withdraw the appeal back? Say I went to NCLT for getting my money due. If yes, then what is the percentage approval required from COC? So the law has allowed you can withdraw the appeal. So the person who has filed appeal can withdraw the appeal even after forming COC. But the condition is you need to get 90% approval of the COC. 90% approval, Rajivji, for withdrawing the appeal. For all others, 6% is fine, all others. But only for withdrawing appeal, it is 90% approval of COC. If you get it, then you can withdraw. So in exam, they'll just ask question on percentages, that how much percentage required withdrawal. And generally, our mind goes to 66%, but 90 is the answer. So majority के साथ चलेंगे ना हम तो. I'm not able to hear you.
That 90% would be value or number?
90% would be value, because your votes decided on value, on the how much value you have. Your voting percentage is the share of COC. So if you have a 10 crore and I'm having 5 crore, It will not be 1:1. It will be, your share will be 2:1, that way on the volume value. Then Atulji, 10% has to bear with 90% is done. So that's a law is given. If 90% are okay to withdraw, we are fine with it. So now let's understand part 2, which is a relevant part for us after understanding the characters. So it might help you to go through the process faster. So there are two terms here: insolvency and liquidation. Insolvency is for till 180 days. After it finishes, it does not work, then we go into liquidation. I'll come to payment order shortly. Interesting part is payment order, and there is certain things you will realize does not make sense. Personally, if you ask me, it does not make sense, but that's what the law is. We'll come to a payment order. Individuals not relevant. Authorities we discussed. Corporate persons mean can be company, LLP, or anybody with limited liability, just like any government companies, which another form, which is a separate act. They are also under corporate persons. NCLT, DRT we discussed, NCLAT, DRT we discussed, fine. Now, one question. I told you part 3 does not apply as of now, right? So there is a company who has taken a loan, company defaulted. Directors have given a personal guarantee, okay? Now, company defaulted, a bank sends a notice to director under IBC that your company is defaulted, so we want to take action against you. If you are a director, can you say you cannot touch me because part 3 is not applicable as of now? Yes, no, maybe. And again, it is all art of how to play with law. Why no if I am saying that part 3 is not applicable?
That's because I can't declare myself solvent, but action can be taken against me if I'm the borrower.
No, but you will agree, Rajivji. But I will take action against you only if the law permits me, right? I will go to IBC only if IBC applies on you, right? I am talking only IBC as of now. So if IBC says I apply only to corporate persons, that is company and LLP. That's what that's what I showed. If that's what IBC says, because NCLT says I will apply only to corporate persons and LLP, then can NCLT apply to borrower individual? Because individual will say part 3 is not active. DRT will take action against me. Yes, no, maybe. I'm trying to confuse you all, but I'm just trying to put other side. So earlier, people have thought this point that NCLT and IBBI cannot touch us because part 3 is not activated. IBBI is also one step ahead with us. What did IBBI did then? They changed the definition. And in definition, they mentioned in corporate person also includes company, LLP, and personal guarantors of corporate person. So if you are an individual, for law purpose, for IBBI purpose, you will be considered as a corporate entity. So this is a very classic change they mentioned, they put in, so that all defaulter directors are in trouble. Now have to go under NCLT. Your case will go into NCLT even if you are an individual. So normally individual goes to DRT, but specific cases of corporate guarantors, you'll go to NCLT. So that is one of the changes happen. Objectives is this fine, what is achieved. So we say the code is very young. It is just 3-4 years old code. We cannot comment it is good or bad generally. Only the time will tell. But as of now, people are at least bankers are happy in some ways. In some ways, they are not happy. The key difference between resolution and liquidation is intent. In resolution, the intent would be to revive the company, not to close the company. IBBI has put a lot of penalties on RPs, saying that you have not taken care of how to revive the company. Your working is to close the company. So in resolution, RP needs to focus on how to run the company. And responsibility is going concern. Time period. Now, what is the time period? I mentioned 180 days is the time period. IBBC has an exception that generally 180 days is the given timeline, if think that 180 days are short, you can take an exception of 90 days extension. So I can apply to IBBI saying, sir, you work on the company, so that is allowed. So resolution, you can go up to 270 days, and this excludes all litigations happening. So suppose I've gone into NCLT, we have gone to CRP process. Now the directors moved, suspended, they can put case against me on my company. So I need to go to defend it NCLAT or other proceeding. That will be excluded from this timeline. Liquidation, it is expected within 2 years you need to close. There is expectation. Haircut, we need to understand the concept haircut generally. Haircut means here you take a voluntary acceptance. Here the borrowers voluntarily accept. Out of our 10 crore, if somebody is paying us 8 crore, we voluntarily accepting it. There is no force on you. In liquidation, you have no choice. Liquidation, आपको जो बचेगा वही मिलेगा. You have no choice there where you can say that I can get more. Liquidation, whatever the ultimate benefit remaining, you will only get that. Yes, if it does not work in 270 days, you go to liquidation. Absolutely. Interesting part on the fees here is in resolution process till 180 days, the fees can be negotiated by IP, RP, or the COC, whatever you want. It can range from ₹1 to n number of 1 crore also. It is up to your choice. You can negotiate that fees. That's not a problem. In liquidation, the fees is generally fixed by regulation. So they're given a chart that you cannot take more than this. This is ideal, you should take it. So liquidation fees is not issue. Now, who can go to NCLT? FC, OC, and CD itself can go. So if I am a corporate debtor and I have defaulted a bank, I can still myself go to NCLT and say, sir, I have defaulted. You please apply CRP process on me. You can always go that. Moratorium applicable, SFA is stayed, IRP is for 30 days that we discussed. COC, we discussed COC regulates the process. RP chairs the COC, but action is taken only by approval of COC. Percentage of approval required is 66.6%. 66% is a passing percentage. Earlier it was 75%. Now they reduce it to 66%. Appeals are invited. Resolution plans are invited. Anybody can appeal. Even a foreign entity can appeal. There is a fast track resolution. Just like we discussed insolvency for normal of 180 days. Why CD? Because it is better to declare yourself and go and take help. So if I am not able to run my company, I'm not able to pay my debts. It's like voluntarily disclosure of your filing bankruptcy. So you go to the company and say, NCLT and say, take my charge. That is also, a lot of people have done that. And this is one of the smartest techniques. A lot of defaulter people have done that. So they siphon off the assets in last 1 year or 1.5 years, and they go to claim to the bank and say, cannot pay. You take us to NCLT. This has been also misused by a lot of people. For fast track, if there's a small company having asset less than 1 crore total value, you need to finish within 90 days. So 190 days is there. One of the reason why chapter 3 is not come, I'll just tell you in 5 minutes or 10 minutes once we come to the nitty-gritty is why it is not applicable and why this process is tough.
No, I think, sir, it was that this reason where CD is going because of alienating assets and declaring bankruptcy, and the misuse that can happen would be one of the biggest reason why the third chapter for personal insolvency has not yet been notified.
Sir, one of the reason is what is the problem in corporate and in individual. In corporate, I can go and sit at your office, right? So you have a company. I can come to your company and say, boss, tomorrow onwards, I am your boss as the court has ordered me. So I can sit at your office and control it. In individual, I cannot go and sit at your house. So, so that is the operationally challenges are coming. Because if I say, there are a lot of people, so there are a lot of people who are a little bit bothered that once it actually comes in, somebody can misuse. So tomorrow, let's say I go to your house, not your house, I go to anybody's house as an IP and say I want to claim. So the person can say he harassed my wife, or there can be a lot of problems which can come up because last 4 years IBC faced so much of resistance. There are a lot of IPs who have been kidnapped. There are a few IPs who have been beaten in Haryana itself. One is in Haryana and one is in Chennai. I know, and these are all quoted cases, reported cases. In Chennai, there is one IP who was beaten. In Bombay, there was one kidnapped. So these things happened because nobody has ever thought of. Nobody has ever thought this kind of thing happen. So the law evolved slowly. So they said to go to individual, we'll just wait and test the time. And now because of COVID, we don't think, I personally don't think for next 2 years it can come. That's my view. Now, who can file an application we discussed? Application can be filed where the default amount is minimum 1 lakh. So if I'm an auditor and my fees is 50,000 rupees, I cannot go and file a claim under NCLT because the amount is less than 1 lakh. Amount can be increased to 1 crore by CG by notification. So once you read the act, whenever you read the code, in the code it is written and the amount can be increased to 1 crore by CG. And I'm sure by you all know now the amount has been increased to 1 crore. So in April, in March end notification, government has increased the amount default to now 1 crore. But for your exam purpose, answer is still 1 lakh rupees. That is the amount of default within which is required because the limit got extended. In March, the announcement came in March, but the notification came in April because Ms. Sitaraman announced earlier, but then notification came in somewhere in first week of April of Gadget, which said that limit extended to 1 crore. For example, you need to get now 1 lakh. Now, what is the actual problem happened now and why they increase the limit? 1 lakh is considered a very small amount. Anybody can give a credit of 1 lakh to any company. So they say because of Corona, it may happen. A lot of genuine people may not be able to pay loan. Their companies may get defaulted unnecessarily. So that they push this. So that they say now let's not create mess more. Extend this. Now 1 crore is extended. For next 6 months, even the IBC is suspended. No new cases are taken over by NCLT for next 6 months, again because of COVID. And we expect it to go to 1 year, again because economy is not revived as of now. So 1 crore is the amount of default. Now, what is the practical problem here? FC, it is still a reasonable number. There will be a lot of banks whose loan would be 1 crore, it is still fine. But can you think any OC, generally any OC having a loan of giving a service of 1 crore, goods or services to 1 crore? Generally, no. Generally, OCs, which are operation creators, which are MSME, may not have that much amount. So MSME sectors are out. Yes, it is not for exam purpose. For exam purpose, still 1 lakh. It is just for a practical purpose. So this actually caused a lot of problem. Yes. This is the reason why we write 11 RVOs, because 1st March 20, whatever amendments happen after 29th February is not in your exam. Yes, that is the reason. We discuss what is the adjudicating authority, what is the corporate applicant as corporate data, dispute. Now, what does a dispute means? Dispute means if there is a financial creditor and you have a dispute. So I will say SBI has charged 11% excess to me. They have charged penal interest more. Then the dispute is irrelevant. So IBBA says, अगर आपका FC से कोई dispute है, if you have any dispute with FC, it is immaterial for us. The only thing we see is if you have defaulted, action can be taken against you. That is for FC. For OC, it is checked. If you have an existing dispute, so suppose I have supplied goods to your company, quality is pathetic, and you disputed. You say, sir, till the time they revive, till the time they change, they say that amendment, when the new syllabus changes, then they will include. Maybe I expect it to be now next year. That's what my thought process is, because they took 2 years to change the syllabus of valuation. In case of operational creditor, it is the point needs to be taken care. If you have existing dispute, you cannot go to IBBI or NCLT. So I have supplied goods to you of 1 crore rupees. goods quality is pathetic, you have written an application to me, or you have written an email to me, or you have written goods to me, or you have shown an evidence where you have mentioned that we are not happy with the quality of your goods, I will not pay you 1 crore rupees. We need to discuss. So wherever there is a dispute for OC, you cannot go to IBBI or NCLT, because they say NCLT is not a dispute solving mechanism. If you have a dispute with OC, you go to normal court and get it sorted. Here we will only take care of genuine dues which can be sorted out quickly. But the dispute means pre-existing. It does not mean I have given you goods of 1 crore rupees, you have accepted it, you have not said anything to me, for next 1 month you are silent. The moment I come to your office and say, sir, give me my old dues of 1 crore rupees, and then you started showing tantrums and say, no, your quality was not good, it was smelling, that box was damaged, blah blah blah. If you start doing that, then it is not considered pre-existing, then it is considered a self-created dispute just to avoid the payment. So if it is not pre-existing, the dispute is raised only when you ask for money. Court will not consider as a dispute. In that case, you can go to IBBI. So just understand, pre-existing dispute is only for OCs, not for FCs. Financial creditor we understand, debt we understand, ICD we discussed. That day when NCLT admits your application, IRP process cost. This process cost means all cost of appointing valuers, cost of appointing bodyguards, cost of appointing CFO, CA, lawyer, security guards, any cost you want to run, a cost of conducting meetings, cost of appointing technological infrastructure. This is called or under IRP process cost. Liquidation cost, if we are not able to complete resolution process and we are not surviving, we go to liquidation, the same cost incurred for doing the process. And this cost will be paid first. IP salary, IP remuneration will also come under IRP process cost. So the only good part would be you will get paid whenever, first you'll always get a number. LCD dates we discussed, OC we discussed, date we find, related party we discussed, applicant we discussed, plan we discussed, here we discussed, can initiate. So we discussed it can be initiated by, the process can be started by either FC on default, OC on default, and CD on default also, and voluntarily also. Both the ways it can do. On default you can also go, and voluntary also you can go. And we have in regulations we need to cover voluntary and compulsory and other also. Now let's see who can initiate. Now there is a section which says who cannot initiate. Who cannot initiate means any company already undergoing a CRP. That means I am a company, and this is before there will be slight change here. It means I am a company, I am not able to pay a debt of a bank. Bank has taken under insolvency to me. I have 10 debtors. I need to collect money from 10 debtors. As Suji's question, so I have one debtor from abroad or 9 debtors from India. I need to collect from them, and they are listed companies, big companies or private companies, and my debt is more than 1 crore due from each party. That is there. They do not allow me to file case against them to also recover money from them under CIP process. Any idea why this clause was put earlier? Any thought process? So if I'm able to make the problem clear, suppose company A has taken a loan from SBI Bank and company A is not able to pay. So company A has defaulted. But company A also need to take money from 5 debtors. Company B, C, D, E, I need to collect from them. But the law says if the company A is going under insolvency process, you cannot initiate the insolvency process for these 5 companies B to F. Any thought process why the law would have put such? And it looks something like illogical कि मुझे जिससे पैसा लेना है मुझे आप अलाउ ही नहीं कर रहे मुझे उस पे IBC एक्शन लेने को, और जिसको मुझसे पैसा लेना है उसने तो मुझे आईबीसी में डाल दिया, बट मुझे भी तो पैसा कलेक्ट करना है लोगों से. आई ऑल्सो नीड टू कलेक्ट मनी फ्रॉम पीपल. Why you are not allowing me to use IRP process for remaining companies? Any idea? Any thought process? If you can think of why the law would have been like this earlier. So what? Let the multiple case go. If I need to collect money from someone, allow me to collect. So what is the reason earlier it was? So section 11 used to say who cannot initiate. So CD cannot initiate who is under CRP or who has completed CRP process last 12 months or who has defaulted any resolution plan terms or who is under liquidation. That was earlier case. Then what used to happen and why this was not allowed earlier? It was not allowed earlier because they say if we allow this, then what will happen? A systematic chain reaction will happen in the economy, and it will happen. A has to take money from B, so A has taken B into insolvency. B has to also collect money from C, so B has taken C company also into insolvency. C has to take into D, so it will be a chain reaction. Just like cycle stand mein agar if one cycle falls, all other cycles falls in place. Similarly, they thought it will happen here. Once we take under CRP process, it will be a chain reaction and entire companies in India will fall under this process. That was a thought process. So they did not allow it. But in December 2019, they amended. And now they say we allow CD to initiate corporate actions, IBC actions, even if the CD is under liquidation or CRP. Because why this they allowed now? Why they allowed after 3 years? Because what was happening in last 3 years data, and we did a lot of valuations in last 3 years with IBC cases, it was realized. Now you tell me what you will do. You are a debtor. I mean, you need to pay to a company. So you need to pay company A. You have taken, you're a debtor for that company. You need to pay company A. And you now come to know that company A has gone into liquidation or insolvency, and company A may be closed very soon. And you need to pay 1 crore rupees. Would you pay or would you like to take the benefit of the situation? That agar company band hogi to kisi ko nahi pay karna, it will be my income. What do you think generally the mindset of businessmen would have been in that case? Will they pay or they will resist? Because if I know the liquidation period is of the insolvency period is of 180 days, मैं 180 days तक अगर आपको खींच लूं, I do not respond you 180 days, then what will happen? Then I will try to take a benefit, which it's a human psychology. So nobody was paying, nobody was responding. So जैसे market में पता लगा this company is going under liquidation or insolvency process, no debtor was willing to pay. And what the debtor used to respond, so RP will send a balance confirmation to debtors that as per our records, you need to pay this much amount to us company. Please pay our money. So debtors will send a letter that there is some reconciliation issue pending with the company. As per our records, we don't need to pay any amount. We have adjusted against discount and other places, so that is not relevant. So people were not able to realize from the debtors. So now the government changed the code and say now also include under insolvency. If you scare me that sir pay my dues, else I will also put under your insolvency. So if I actually have money with me, will I go into insolvency or will I pay you? A common sense guy will always pay you, because I will say if I go to insolvency, everything will go against my hand. My company can also go against me. So that is the reason now for your exam purpose, CDs those who are under insolvency or liquidation, they can take. Yes, CDs can initiate now, because now it has been changed. In in December 19 it got amended and it got changed. So for exam purpose, CD can do. Only FC now cannot initiate who has violated any plan. Only that cannot change. Now what will happen? So default has actually occurred. SBI has given a loan to a company and company defaulted. So what will SBI do? They will file Form 1 to NCLT and they will say that this company has defaulted. So they will file to the company NCLT. NCLT, it is expected that within 14 days of time frame, NCLT to decide yes or no. But generally, it will never happen in 14 days. Generally, it takes 1, 2, 3, 9 months also. So it is taking time. Real estate we discussed. Now, what happened in real estate? As we discussed now, real estate can be home buyers are real estate. So a problem was happening if there is an example of, let's say, Amrupali, who has 10,000 flat owners. There are 10,000 people who have given flat advance. Even if one person wants to file a complaint, and if you have given more than 1 lakh dues, he can go to NCLT and file a complaint. So that was causing a lot of trouble. So this got amended in again December 2019 recently. Now, if there are real home loan buyers, they have to file either minimum 100 or 10% of the total creditors, whichever is there. So it can be either filed by 100 group of 100 or 10% in numbers. So that needs to be taken care of. Whichever is lower, that we need to take care of. Each can be one low. Yes, good question, Deepakji. FCs, financial creditors, can club together and go up to 1 crore level. So suppose there are 10 people with 10 lakh rupees, they can club together, make a 1 crore and file application. That is allowed. In OC, clubbing is not allowed. In OC, we cannot say there are 20 service providers, 5 lakhs each, they can club and file application. You cannot do that. In FC, below one limit, you can club and file that. So that is the law for FC. So this bill preferred mainly for FCs, less for OCs. And once we go to the payment pattern, you all will agree with me that why it is not any for OCs much. So whichever is less, that needs to find. So just note down this. If you can take a picture of this slide, or if you can note it down, good. Anyways, all slides will be shared to you by the end of the day. No need to worry. But because this has been a recent change, so probability of these questions asking is much higher than regular questions. Now, there is a difference between the process between FC and OC. In case of default, FC directly goes to IBBI or NCLT. FC will not call and tell CD. FC is not supposed to, as per law, FC is not required to call CD and say, if you're not paying, I'll go to NCLT. The process is not there. If he wants to call, it is his choice. If he directly wants to go, it is his choice. That is fine. In case of OC, you cannot go directly to NCLT. In case of OC, first you need to send mandatory demand notice to CD. You will send a demand notice to CDs mentioning that, look, Mr. XYZ company, I have delivered goods this or services this on date. These are my bills due. You will attach your bills also. You will also attach your ledger saying, but you have paid me only this much, or you have not paid me. So my amount is due. Please pay me within next 10 days. So just note 10 days time. So you give a notice, and within 10 days, if the payment is not received, then you have a right to go to NCLT. So 10 days is a time period you give him to see. In 10 days, CD might either respond to you by saying, I have actually paid money to you, or I issued credit note against you, there is a quality issue, something like that. He will tell you. Based on his response, you can go only one demand. Yes, only one demand notice is enough. One notice you need to give. 10 days time period finishes. If he responds back, it's fine. If he does not respond back, also fine. You need to have a proof of submission that I have submitted this, notice was delivered, and then in 10 days he is not responded, you go that. So you send by email, you send by hard copy, you send by registered post, whatever, Facebook pe chipka do uske, whatever you can do, just do that. Get a proof, and after 10 days finishes, apply under NCLT. My last 4 years of practical experience of OC, generally, and I'm sure maybe Itiji who's working can vouch, or Rajkumar ji will understand. अगर OC है, genuine dues hai OC ke, and CD has money with him, then just by sending notice you will get money. Just by sending notice, if the CD has money with him, agar CD ka khud ka paisa hai and there is no dispute proven earlier, based on your notice he will pay you money, because CD knows that case is admitted under NCLT, he will be in a lot of big trouble, so he will genuinely pay it. But agar CD के पास ही पैसा नहीं है तो फिर आप notice भेजो, does not happen. Yes, if the demand is not genuine, then CD will prove. So CD will respond in 10 days that yes, I have also emailed you the quality issue. We are not happy with the goods you service provided. We returned you. CD would also show a proof that your goods were not good. I responded you. I emailed you also. We returned back. You are not taken delivery back. Whatever reason, if the demand is not genuine, the case will not be accepted by IBBI, NCLT at all. But if the CD could not respond properly, could not justify why he is not paying, it will be accepted.
It means that operational character has to prove first that the demand is genuine, and after that he can go only to NCLT.
Yes, yes. And that is the reason the word existence of dispute is important. It should be pre-existing. If you can see on the slide, third point, the dispute must be pre-existing. It is only for OCs. That dispute is not arisen only the day when you ask for money. Dispute is already there when you would have delivered a service. So there can be a reason, suppose I did an internal audit of a company or a consultancy of a company. I delivered my report. And just after delivering the report, within 1 week or 2 weeks, the board responds to me on an email that, we are not happy with your services. It's a trash job you have done. We're not happy. So that shows there is a dispute. Dispute is not coming when after 20 days I went to and say, sir, give me my money. And normally अपने में ये होता है ना, मुझे कम करना है किसी के पैसे, तो क्या करेंगे, 4 कमियां निकालना चालू करोगे, पेंटर को आप तूने पेंट अच्छा नहीं करा, 1 हाथ ही मारा है, 2 हाथ नहीं मारे, यहाँ थोड़ा लाइन दिख रहा है. So you started showing him faults so that discount. That is a strategy we all do. In that case, that will not work out. If there is a dispute, you need to tell the OC first that there is dispute. So if the OCA send you a bill, so the company will either respond or not respond. If it does not respond, it is good OC. He can immediately go to the NCLT and say, I send him 10 days notice, he has not responded. But if the CD responds, CD will say, okay, I have paid you, or CD will say, I have given you 90% dues, 10% is left, I'm to cash crunch, give me a 10-day, 15 days time. So CD might give you some plan. IBBI may accept that plan, may not accept that plan. If you are happy with the plan, NCLT will be okay. If you say, no, I don't trust you, I want to file a case against you, it is fine. So should be always a dispute should be supported by evidence, and the demand should be there. So there is no bill. You say, "Sabche mein hota hai, koi bill nahi hai," IBBI will not accept it. In a lot of industries, there actually bill is generated only after you deliver. Like specifically, this genuine dispute has haunted jewelry industry. Those who work in jewelry industry or those who are jewelry clients would be aware. ज्वेलरी में अगर किसी को 3 करोड़ रुपए लेना होता है तो 3,000 लिखता है. दे विल नॉट राइट फुल अमाउंट. जो पर्ची बनती है उनकी पेमेंट्स की, या जो पुड़िया जब गुड्स ट्रांसफर होते हैं, तो दे डू नॉट राइट फुल वैल्यू. दे जस्ट राइट देयर 3 zeros or 5 zeros out of it. कोड वर्ड होता है इनका. If you have not paid, you cannot go to court and say, सर ये 3,000 जो लिखा हुआ है एक्चुअल में 3 करोड़ है, क्योंकि हमारे यहाँ पे ट्रेंड नहीं है ऑफिशियल बिल का. दैट कैन नॉट वर्क आउट. So it has to be genuinely legitimate bill which can be produced in court of law as evidence. So that has to be taken care of. Existence of dispute is must. It should be pre-existing, not only on when you ask money. Home buyers are not OCs; they are FCs now. Now it is in the code itself. Earlier it was not there. This is generally what happens. First, the appeal is filed by FC, OC, or CD. Anybody can file appeal. Ideally, within 14 days, NCLT may admit, but practically 14 days never happens. It is given in a recommendatory. And why 14 days it does not happen? For example, I am in Jaipur, and company is in I am Jaipur. NCLT is in Jaipur. Company is in Udaipur. So I filed a case against Jaipur NCLT because you file a case where the NCLT of the RO is there. So Jaipur NCLT is there. I say this XYZ has to give me 1 crore rupees. Court NCLT will not directly listen only on my voice, right? NCLT will say, okay, we'll ask XYZ company, sir, are you supposed to pay? We can start at, I'll finish by 1. So you can have a break of 1 to 1:30 or 1:45, whatever the class suggests. Then we can start early. Whatever the people, you are fine. Vijay, what is your view? We are fine. At least I am fine. And I'm sure rest all will be fine. So I think 1 hour 15 minutes will be sufficient for me. In between, if anybody wants 5 minutes break, do let me know if you need a comfort break. If I know theory is going too high, but if you are uncomfortable a little bit, यही problem है, बोलो और ले लो. Okay, if you all want, we can carry. So we can carry it for some time, and if then still the demand is there, then we can do that. So now we can do continue for some time. When we will get a majority, Atulji, then we will continue. When we take a break. Practically, 14 days is never decided. Practically, because what will happen? IBA will send a notice to Udaipur company. So एक दिन में तो जाएगा नहीं, 7 दिन लगेंगे उदयपुर पहुंचने में. उदयपुर से जवाब हो सकता है उदयपुर में कंपनी को मिले ही नहीं. So it will return back to NCLT. NCLT will not say कि एक बार भेजा, company is not responded, we will do X party. NCLT will send you 3 notices. So 3 chances are given for a company to respond. So technically 14 days is just a myth. Practically never happens. 14 days only happens when company is so good, company खुद ही आ जाए day 1 पे appellant के साथ and say, हाँ sir, we defaulted, we accept, which is very rare. But the moment NCLT decides, yes, we are agreeing, that day it called insolvency commencement day. If FC has already named IRP, FC says I want to make Rajkumarji as IRP, so NCLT will pass an order also that day. This company is going under insolvency, and Mr. Rajkumarji is declared IRP from that day. But suppose case has been filed by OC and IRP has not been declared, IRP has not been decided, then NCLT will send a letter to IBBI. Please mention a name of IRP from your panel. So IBBI makes a panel every 6 months. So every 6 months a panel will be made. Who is on the top? जिसने भी मैंने आज अप्लाई करा तो मैं टॉप पे रहूंगा, आपने कल अप्लाई करा तो आपका सेकंड नंबर आएगा, अतुल जी ने थर्ड अप्लाई करा तो थर्ड नंबर आएगा. तो इसमें इट गोज बाय आपकी एप्लीकेशन कब पहुंची इलेक्ट्रॉनिकली. सो दैट नंबर इज प्रिपेयर्ड. In that way, IBBA will say, okay, make one person as IRP. That IRP's consent ली जाती है and then he becomes IRP. Once IRP is appointed, then we will discuss what he does. But after what he does, a committee of creditor is appointed within 30 days of his appointment. So a committee will be formed within 30 days. And the first thing the committee needs to do within appointment, within formation, within 7 days, they need to hold first meeting mandatory. So just note, whenever a committee is appointed, within 7 days, they need to hold one meeting, COC. In that COC, they need to confirm, should we replace or continue the existing IRP? So they need to decide. So if they decide, committee decides, then it will happen. Once it is decided, the RP, so after COC, the IRP is known as RP. The interim resolution professional is now known as resolution professional. He will make an information memorandum. Information memorandum will be, he will give a detail that, okay, this company as on 31st, whatever days ICD has so much of assets, so much of liability, so much of potential, so that anybody can submit a plan. Anybody can submit a plan for acquiring. So based on that plan, people will give appeal to a committee that, okay, we read in about your company, we want to take over your company for whatever plans they submit. So that's called resolution plan, that is submitted by applicants, whoever wants to take over the company. This has become also a lot of money making opportunities, and a lot of professionals are doing this service, a good service, where they are just writing resolution plans for corporate data for applicants, because not all applicants have the art of writing resolution plan. So a lot of professionals are only expertise in writing a plan and submitting, because based on your plan, COC admits your plan. Once 66% of COC approves your plan, then it goes to NCLT. Now there is a catch here. It may happen your COC approves the plan, 66% plus approves the plans means project report. Yes. Not, I'll not say project report. It means like what is your tentative thought process that if I take over the company, how I will take it over. Here you're not putting a new project. Here you are taking over the existing project. Here you are telling how much money you will chip in. So you will say, I will take over entire liabilities at X amount. I will give you this. I will give you that. It's a plan. Yes. So if it is approved by COC, it has to be also mandatory approved by NCLT. It may happen your plan approved by COC, NCLT rejects your plan because NCLT says this is not a sensible plan or we don't think it is an achievable plan. For example, as a company says to COC that I will pay you in next 100 years, it may say, and NCLT may accept also because there might be fools sitting on the board. They say okay, 100 साल बाद दे देना, एटलीस्ट दोगे तो सही, क्योंकि मेरे कई लोगों की जुबान होती है हाँ भाई बोल दिया तो देंगे. But NCLT will say, no, this is not a commercial decision. It's a foolish decision. After 100 years, you will be there or I will not be there. Nobody knows. So we'll reject that. So that may also happen. And it has also actually happened in cases where COC approves the plan and NCLT rejects. If the NCLT rejects the plan or COC rejects the plan, whatever it may, it goes into liquidation. If the plan approves, then resolution process ends and the new management who has taken over, they take over the process. If it is not approved, liquidation process starts. What will happen in liquidation process? So in liquidation, we have normal process where actually companies are into trouble going into liquidation. Then we have a fast track process, and then we have a voluntary liquidation where I am genuine, I have full cash with me, I have no debts or I don't want to default, but I want to close my company for any reason. So we just got a, it can be any reason. Somebody gets a request that I want to wind up things. So you can still go to voluntary also, even if you have no debt issues. That is also there. So if no plans, it is rejected. And if there may also happen, you might not receive any plan. It may also happen. So for example, classic case of Moser beer. Nobody was willing to buy Moser beer. Now who will buy CDs? Now you need to remember, earlier there was a floppy disk, floppy drive. Everybody used to have a floppy disk. अभी किसी के लैपटॉप में floppy disk है? I am not sure किसी के होगा. Now everybody used to buy CDs. Abhi, do we buy CDs? I don't think I would have bought CD from last so many years. Now we have hard disk, we have cloud. So things are getting changed. Similar example of Moser beer, yeah, pen drive is coming exactly. So we are not now. So Moser beer was primarily into CD writing. So if nobody submits a plan, then you goes into liquidation directly. This is not for your to learn for exam purpose, because you can't learn the rates and all, not relevant for it. Also, they don't even ask question on this, but just to give you an idea, in liquidation, the fees is decided by a regulation which says, if you realize 1 crore rupees within 6 months, take 5% of it. So take 5 lakhs out of 1 crore if you realize. If your amount is 50 crore, take 2.5%. If your amount is 100 crore, take. So it is like a carrot and stick approach. It is like incentivize. It's a monetary incentive plan to push liquidator to act fast. Within 6 months, if you active, 5% is given. If you delay, you will get 75% only. If you further delay, it reduces to 50%. So this is just to put, if you tell me, if you finish audit in 1 week, I will give you 10,000 rupees fees. If you finish audit in 2 weeks, I will give you 5,000. I will try to work in which project where I am getting more fees and a shorter time. So I will try to put my incentive is linked to my performance. So that is the reason they put, and we know money is one of the motivator to professionals to one of the regulators to work quickly. So now we discussed all powers suspends. Okay, just note one thing. In IBC, the reports have to be kept for 8 years. In valuation, we know it is 3 years. So just note 8 years. In insolvency, it is 8 years, and valuation 3 years. So that difference should help you. Because in exam, they ask such kind of questions to confuse you. Okay. We'll discuss these points in regulation shortly. These all will be covered in regulation shortly. Just wait. Now note few things. What is relevant? So IBC process started. Now it is the choice. If there might be happened that within last 2 years, the company would have done some preferential transactions, undervalued transactions to their related parties. So it may happen I would have sold 10 crore building to my related company or my director at 5 crore rupees. So that means actually I have siphoned off 5 crore rupees worth excess to him. So RP can do a review of last 2 years transactions, and if any such transaction happened in last 2 years, he can apply to NCLT to undo those transactions. That is allowed. If it is non-related party, then it is 1 year. Generally, nobody will do a preferential transaction with unrelated party. So that is just an exception they have put. So we need to remember in last 2 years, if something has been done, they can do it. How should RP should know this? Last 2 साल में कुछ हुआ है? It is advisable to appoint a forensic auditor, and that he will give a report. In case of liquidation, how can the RP sell? A liquidator sell? He can do an auction. He can do a standalone sale. He can do a slump sale, parcel sale, collective sale. Whatever it gives you, whatever liquidator thinks the value can be realized of selling an asset, in which mode he can do that. The best is auction. He can do a e-auction, and then he can get a good value. If it is a perishable product, he can go for private sale. So suppose there is a private sale, there is a perishable product. Can a liquidator sell it to a related party? He cannot sell to a related party even if it is a perishable product. So the law strictly debars that you cannot sell asset to a related party, so that value cannot be a there cannot be a collusion between related parties and CDs. Now comes this chart is very important to understand and see this chart. Okay, the action can be taken. See, RP cannot do anything, right? So RP can just highlight what happened. RP will inform to COC that yes, this has actually happened in last 2 years, which I think is grossly preferential transaction. And if the COC also thinks yes, this is actually a preferential transaction, RP can apply to NCLT and say, please undo the transaction. That means allow me to take it back from the same person. So if a company is given to a director a Mercedes car at a 0 value, or out of 10 crore, let's say 1 crore car at 10 lakh rupees value. So they will ask the director to give back the car or give back 90 lakh rupees, the difference. They can request. So generally the transaction gets reversed generally. So a lot of companies have done that. In Binani Cements, this happened, and so many other cases it has happened. So you just make an application to NCLT, and then NCLT gives direction. Now coming to this distribution, this is called a waterfall mechanism of distribution. How the distribution will happen first. So once we are assuming the company is going into liquidation and we have got the money by realizing assets, first person will get is the dues is insolvency resolution process cost. So that will be the first he will get it. Second would be secured creditors and workman compensation. So it will be 24 months workman compensation. Then we will get 12 months employees due. Remaining employees, white collar, blue collar jobs, they will get for 12 months. And workman, which is defined under Factories Act. After that, we will go to unsecured creditors, financial debts of unsecured creditors like working capital limit, unsecured collateral loan, collateral free loan, that bank can go. Now see where the government is coming. On the 5th position, which used to be on the top always, now they have taken a hit and they say, first pay to the creditors, financial debtors, then comes the government dues. And after the government dues comes the operational creditors. And after that operational creditors, you pay to other creditors, and then it goes preference shareholders, and then it goes to equity shareholders. That's a mechanism. Now imagine a situation where you are an auditor and your bill is 5 lakh rupees due. You apply to the IBBI NCLT, your application gets accepted, the process gets started, and now the company is going into liquidation. Who will get the benefit first? You or the FCs? In the hierarchy, who will get the paid money first? You file the application. Who will get the benefit, FC first or OC first? Now, this has caused a lot of concerns and a lot of problem. So, matter of the fact is, yes, FC will get. Now, suppose out of FC and OC, yeah, liquidator will definitely get because उसने तो थोड़ा काम करेगा. Suppose the companies liquidate rupees. Suppose insurance professional ले गया 1 crore rupees. Debtors secured debtors ले गए 9 crore rupees. उनके डेट से 20 करोड़ के वो ले गए 9 करोड़ रुपीस बचे हुए. Now company has no money. Who will pay to OC now? So there is only 10 crore we received after selling all assets. 10 crore में से 1 crore liquidator का चले गया. 9 crore secured banks का चले गया. Their due was more. उसके बाद गवर्नमेंट ड्यूज के लिए कुछ नहीं बचा. Now it comes to OC. नहीं बचा ही नहीं, गवर्नमेंट ड्यूज के लिए है ही नहीं, चलो गवर्नमेंट ड्यूज है ही नहीं, फिर OC को कौन देगा? So nobody will pay to OC. Nobody will pay to OC, and that is the actual problem, which has a lot of Supreme Courts, they are under still consideration. What they are saying is that, what is the problem here? Who has filed the case? So the OC has filed the case. I have taken you to the install IBC, and I am also not getting the benefit. So it looks like injustice to me. Again, we can always argue good, bad, right? But what is, and you have to be understand and come to the OC issues. वो बेचारा ये बोल रहा है, सारा efforts मैं कर रहा हूँ. Yes, what you are saying, Atul ji, that should be there ideally, should be there, but it is not there. So as of now, there is no ratio, and that is the actual problem happening, and a lot of litigations pending under Supreme Court. So what is happening here? The OCs are saying, sir, हम केस ला रहे हैं, हम अप्लाई कर रहे हैं, हमारा दर्द है, पैसा हमारा डूबा हुआ है. बैंक हैज नॉट इवन टेकन फाइल्ड एप्लीकेशन. बैंक ने तो एफर्ट्स ही नहीं करे. एफर्ट्स मैंने करे सारे, और एंड में मुझे तो कुछ नहीं मिल रहा, और सारा जा रहा है सिक्योर्ड क्रेडिटर्स को. दैट वाज कॉजिंग एक्चुअली लॉट ऑफ ट्रबल. Unfortunate, but that is the fact. As of now, OCs are not, and that is the reason I said starting, it is not beneficial for OC to take this battle legally, because once you go to the end, you will come to know you have nothing left. Then what you will do? So this tool is as good as for OC just for sending notice. By sending a demand notice, if you can get money, end of the story. Even if by sending demand notice, if you're not getting money, for sure you will not get money even after doing the entire process. That's my personal view, and I'm sure you all will agree once you go to the actual nitty-gritties. Now take a classic example. Ruia Brothers. I'm sure we all would have heard Ruia Brothers issue. When the Ruia Brothers company, Hinduja Brothers Ruia Group company was under COC. I'm just skipping the full name of the company. I'm not able to just recall the exact name of the company. So when this company, Ruya Brothers, SR, yes, SR company. So this, thanks. So when this company had a dues of 54,000 crore approximately now to the FCs and OCs collectively put together, that's the dues. This Hinduja Brothers was not paying since Ruhias are not paying since 2000. It's Ruhia's family. Ruhia's family was not paying since 2003. So since 2003, this dues piled up from 30,000 to it has reached up to now 54,000 crore rupees. That's the number they have received. They never thought that somebody can go to IBC, like some law can come. IBC came, people filed complaint against NCLT. Now, what the so COC resolution plan came. Arsenal Mittal gave a plan to the COC. 32,000 crore cash upfront, take it or leave it. So I will give you 32,000 crore rupees out of 54,000 crore and settle it. Now, when Ruya Brothers come to know, and they was very surprised, they say, how somebody can take our company? Because we made this company since inception. We have actually born this company. It is our baby. So they requested COC and say that please give us one more chance. We will give you 54,000 crore rupees in coming years. And they've given a timelines also. Now, can you guess what would have been the COC's decision? Go to 32,000 crore rupees upfront, or take the proposal of Ruya's brothers and go to 54,000 crore rupees next year? What do you think they would have done? Any vague idea if you would have been at COC, what you would have done? So the COC actually admitted that we are happy with 32,000 crore rupees. We want to go upfront and we don't want to see tomorrow. क्योंकि कल हो ना हो. Because आपने इतने सालों तक नहीं दिया, why should I go and wait for you for next one more year also? And it is always said that दूध का जला छाछ को भी फूक के पीता है. So when so many years you have not paid me, why should I give you one more chance? And where I'm getting upfront offer, because it may happen that next year you also default, then Arsenal Mittal may not come to rescue me. Then they will not say next year कि सर अब भी वापस 32 दे दो. फिर वो 32 का बोलेगा अब तो मैं 28 ही दूंगा. एक साल बाद आए, then your negotiation, your value decreases if you are going again back. So when the offer came of 32,000 crore, they were surprised, and then they made a lot of issues. Currently, the case is again going into Supreme Court. Though as per NCLT and CLAD, the Arsenal Mittal the plan was passed in their favor, but still the case is going against Supreme Court. And what is the reason this is going under Supreme Court? In this 32,000 crore, nothing has come to OC. Everything has gone to financial debtors. And they have a substantial amount of OCs also. So OCs has said, sir, at least give us some percentage, some ratio, at least be genuine to us. That is what they are trying to find out. So this is still under discussion. I'm sure something may come within some time and that it can be decided. But as of now, OC does not get ratio. OCs will get. It is not moving. Just give me a minute. I think slide is stuck. Why Vijayji came in picture? You're getting a screen. No, you're not getting a screen. Just give me a minute. So now coming to fast track for small companies. So the time limit of 180 and 90 days. So 180 days was time limit of CRP for normal companies. You can take extension of 90 days, so it becomes 270 days. In case of small companies who does not have asset more than 1 crore, time limit is 90 days, and you can take extension of 45 days. So within 135 days, you can do that. That is a CRP process. After that, we'll discuss voluntary liquidation, how to file voluntary. That we'll discuss once we go to the rules. NCLT we can always, agreed party can always go to NCLT whenever they want. If you lose at NCLT, the time limit is 30 days, extension 15 days. Answer should not be 45, only 30 days. After NCLAT, you go to Supreme Court. Time limit is 45 days. Now, this will give you just a broad overview of the entire timeline we discussed. So if you can see the timeline, minus 14 is considered the day I'm filing an application hypothetically. And if I file application, it is get admitted. So we assume generally 14 days takes time by NCLT generally. The day they accept application, it will start as 0 date, that is insolvency commencement date. Within 14 days, it has been appointed IRP. If it is not appointed earlier by OC, then the day IRP is appointed. So if the IRP is appointed today, then within 3 days, 14, 15, 16, he needs to give a public advertisement. So in a public advertisement, IRP will give a newspaper that from tomorrow onwards, today onwards, I have become IRP as per the NCLT order. If anybody needs to have claims from this company, so he will give a public notice that if somebody wants to give a claim from this company, within 14 days, submit your claim to me. That will discuss all the process. Within 37th day, a committee will be formed, and then within 7 days of forming a committee, that is within 44 days, first meeting will happen. In that process, memorandum will be prepared, details will be shared, resolution plan will be accepted. A lot of companies will give a plan. They will make a mechanism to accept which plan, because it may happen for, let's say, for Ruchi Soya, 100 companies may send a plan. So COC cannot see all 100 companies, right? They need time to also evaluate the proposal. So they will make a benchmark. Only companies who are having a listed turnover of 100 crores, net worth of 500 crores, only they can apply. So they start filtering process, make a benchmark, so that only genuine companies stay and that they can plan. After the application plan, it goes to NCLT. If NCLT approves, it's fine. If does not approve, yes, Deepak, it will also be there. Between this, yes, the claim will come. I will come to how COC will be formed. That I will just come shortly, because without this, COC cannot, this financial creditor cannot become till the claim has came. So that process will come shortly. If the plan accepts, it's fine. Then there is a monitoring committee formed. If the plan is accepted, if not accepted, then liquidation process starts. This 180 days can extend to 90 days plus 270. Now comes the process. Actually, what this is the code what talks about how the process happens. Now there is a concept. Now imagine we told that there is a financial creditor. We discuss FCs, and if there's a committee of FCs, where you will go and meet, you might meet in a 5-star board meeting room, or you might meet in a hotel lobby, or you might meet in your own company, in your own company's premises, if that is possible, right? Generally, that is the way you have a meeting. Generally, when this act was formed, nobody else thought that there might become a situation where there will be no sufficient place to hold a meeting. Can you imagine why such situation would have happened? that there is no sufficient place to hold a meeting. When it could have happened, we can't conduct a meeting in exactly. So what happened? They thought committee of creditors will be 10, 15, 20, 100. That would be the maximum they would have thought when the code was written. So say 100 could easily Taj Oberoi, any ITC, Grand Sheraton can hold it. But when this class of creditors introduced, that is home buyers are become. So imagine a case of Amrapali or JP where there are 25,000 people who are home buyers and now which are part of FC. So if now IP needs to call a COC meeting of home buyers, the only place I can think of in Delhi would be Firozshah Kotla ground, or in case of Bombay, Wankhede or Brabant Stadium, or Calcutta Eden Garden. I think these are the only place where you can accommodate so much people and hold a meeting. But is this practical and feasible? Answer is certainly no. So IBA immediately realized that this will cause actually a lot of trouble. And this was actually causing trouble. You cannot hold. Problem, even if I hold, let's say, even if I say Brabant Stadium, 10,000 people can come and sit, we are discussing. Can we take a poll immediately? हम KBC तो खेल नहीं रहे वहां पे कि सब बटन दबाएंगे और आंसर आ जाएगा immediately. So you cannot control 10,000 people also in terms of taking decision making. So they say, let's make a class of creditor. So a new concept is introduced, class. That means if there are minimum 10 people of the same class, which have a same asset class, you will constitute class of creditors. And then instead of coming all 1,000 home buyers to your office, to your meeting, these home buyers will select one IP or one RP to represent on their behalf. So practically what does the actual RP do? So the main RP of the main company will give the name of 3 resolution professionals to these class of creditors, and they say, out of these 3, choose whomever you want to make as a representative. That IP will represent on your behalf and be your voice to me. So that was practically possible. This happened. Now understand the concept of fair value and liquidation value. In insolvency, the fair value means realizable asset that you can exchange on an ICD date, commencement date, between buyer and seller at arm's length. That's a normal definition. And liquidation value, we understand if the company is supposed to resolve. There is a fundamental difference between valuing a company in a normal scenario and valuing into IBC. Can anybody tell me what is a fundamental scenario? What is the fundamental difference between these two valuations? What do you think can be the fundamental difference between the valuation of these two things? Assuming going, because fair value is only when you are assuming going concern. Okay, what about fair value? Because in fair value, my assumption is it's a going concern. That's my assumption. The fundamental difference is the key difference is in normal company valuation, in Companies Act, when you do for Section 62 or M&A or for any other, you value the business as a whole. You value the entire company. In case of IBC valuation, you value only certain specific asset. So if you are a land and building valuer, you will only value land and building. If you are plant and machinery valuer, you will only value plant and machinery. If I am an SFA valuer, I will only value current assets, debtors, stock if it is my scope, bank balance, loans and advances. So I am only giving a particular value of particular asset. So valuing an asset is different and valuing a company is different. So in that case, I cannot apply DCF approach of in IBC because I am not valuing the liabilities. Why I don't value the liabilities here? Because liabilities is valued by RP. I do not decide what is liability. I do not take a call. That call is taken only by registered value, the insolvency professional. So there is a fundamental difference between valuing as per IBC and valuing as per normal Companies Act. What needs to be done? once you get the slide and once you, whenever you are preparing for exam, whatever the bold is written, just read that mandatory, because the questions are coming from that part. You read entire slide, it's well and good, but at least remember what are the bold things which we are discussing. So the process we need to do, the moment you appoint IP, needs to give an advertisement in newspaper within 3 days of his appointment. So if I am appointed today, tomorrow, day after tomorrow, within 3 days, he will give in newspaper that I am being appointed. I request you all people to submit your claim within 14 days to me. So if I give an advertisement today, I will give a window of 14 days to submit claim to all people. Whoever has a claim, they will file a claim against his form B, C, D, E, F. You may ask a question that what if I have to take money from a company, but if I genuinely forget to file a claim? I'm company is in Jaipur, I'm sitting in Chennai. I did not read the newspaper. Why should I read a Jaipur-based newspaper? So I did not got to know that company is going IBC. I do not submit the claim, which is actually practically possible. What should I do then? Or I am sitting abroad. I am not aware that I need to claim from you. Then they say, within 90 days, if you can claim of ICD, it can be still accepted. After 90 days, it is NCLT's choice, not a mandatory. Why they, and you may ask a genuine question also. I'm actually a genuine creditor. I need to take money. I missed to claim within 6 months also. So today is ICD day. Till 188th day, I realized that okay, company is into liquidation. I need to file my claim under IBC. Why law does not allow even a genuine people after 180 or 90 or 100 days? Why any reason why they say no, file only up to 90 days? Any reason? Because genuinely it is there, it's may not sound logical. मुझे actual में पैसा लेना है, ठीक है, miss करके deadline, बाद में दे दो मुझे. Why they say no? Any particular idea, thought process? Exactly, the order will be disturbed, and moreover the order, how the person who is taking the company will know that this debt is fine. Because जब आपने मुझे resolution plan memorandum दिया था, you would have said I have only 2 crore liabilities to pay. पता चला बाद में मुझे 5 crore का एक और claim आ गया after 6 months. So I cannot keep changing my plans accordingly. So your plan will get disturbed. One is the order getting disturbed. The most important than order is plan getting disturbed. Because whoever is buying your company is buying based on certain facts. And if you change the facts, keep on changing the facts, the plan may not be a reasonable plan. So that is the reason so the time limit is given generally 90 days. It is allowed up to 90 days if you can submit. Now, important, understand what is most important here. Absolutely, and that is the reason I told you this IBC is difficult for people who are not practicing. Those are practicing, they find it cakewalk. And in exam, very difficult to mug up the numbers, and that's why I try to highlight the bold things that may help you. More than that, I could not put any efforts to put more, because IBC cannot be concluded in 3 hours. It needs because once I do a training, even 8 days training was not sufficient to conclude, because there are so much practical problems which does not come by law, which we need to evolve. The only logical answer I can understand, Deepak ji, because of this, there are two. Once, it is in syllabus. Second, if you see your syllabus, they have put so much detail. They have put 5 regulations to read. Since because this course is formed by IBBI, so they have special inclination towards IBC, because this valuation is also coming under the umbrella of IBBI. That's why they are asking more questions of IBBI than any other law. So unfortunately, and I'm sure once you give exam, you will realize they're asking such a question. Within how many days you need to give a newspaper? How does it matters to me as a valuer? But that's the unfortunate part. So that we cannot do. Again, I completely agree. These are not relevant for valuer. What is relevant for me? I know that you need to appoint 2 valuers. Values coming different. Appoint 3 valuer. But that is the hard. So this is a. It's like I will say. एक कड़वी दवाई है जिसको लेनी पड़ेगी. Doctor, there are 2 kind of doctors who can give you sweet pill and can sour pill. So मेरे पास unfortunately कड़वी दवाई है. So you need to go through it. Unfortunately. Now you need to note it down, and this is most important. within 14 days, so I give a newspaper advertisement, submit your claim, you submit your claim within 14 days. So 14 days you have given all claim. Now becomes my duty as a IRP to verify that जिन लोगों ने whoever all submitted the claim, is that claim genuine or not? This is the most toughest task of IP. Why most toughest task? Am I the management? Answer is no. Will management cooperate me? Answer is 100% no. Then if management is not cooperating me, I am not the management, how should I know this is Indian data or not? So you will ask the account person. You will check the data, if tally is available or ERP is available, whether the bill is there, if the company is having a name or not. It may happen, I can file a bogus claim. That how do we come to know? So RP will need to check within 7 days the claims are genuine or not. He checks the claim, and once the claims are decided, then it becomes a COC. One of my friend, he became RP. First assignment he took, and within 7 days he got 30,000 claims. Can you guess which city he would be where he got such kind of claims? Chit fund company. 30,000 claims in 7 days. He literally lost his health very badly. He was in Calcutta, Sharda Chit Fund Company, Calcutta. He was in Calcutta. After that, so 7 days he did it, everything. Yes, he was in Kolkata. 7 days he approved the claim. He fixed all this. Overnight he hired a lot of staff, admitted the claim. 7 days later, once the COC formed, COC says, we are very happy with you. We want to make you a RP. With his folded hands up to the elbows, he said, sir, please excuse, I don't want to become your RP, because to handle 30,000 people grievance is not easy. So he literally resigned, despite they were willing to pay a huge fee, more than 30 to 40 lakhs per month fee, but he resigned. He refused that. He says, fees is fine, the toll on my health will be much more. So it is not as easy as it looks. If you get a typical case like this, it becomes very difficult. So within 7 days of filing, within 14 days after you get a claim, you decide the genuineness of the claim, you admit the claim within 7 days. Once you decide that yes, this claim list is final, and it is only RP's call, RP's only right. RP will tell NCLT, sir, this is for me, this is the list I think which we finalized. And then once this list is finalized, he will hold one COC within 7 days. That meeting happens. So COC will consider only FC. It will exclude RPs for voting purpose. If there's no FC, RP, you know who needs to be COC. 18 OCs, one workman, one employee. First meeting will happen within 7 days. RP will convene a meeting whenever RP wants, or whenever 33% of the member wants. So an exam question can come, when can members can convene a meeting? When 33% people ask that we want to convene a meeting of COC, that can be done. What is a quorum? 33% of the COC, it should be present. By person, by conferencing, by audio visual, it's fine. A question comes on exam, within how many days, how many hours, the meetings of the COC to be circulated. So it is 48 hours. Within 48 hours, you circulate the meetings of COC to applicant, to the all participants. Fees of IRP fixed by applicant. IRP, because now understand, IRP is generally appointed by the FC, जिसने apply करा है. So he will fix a fees of 1 month. So he can say, okay, for first month you can take 5 lakhs, 1 lakh, 2 lakh, whatever amount. So IRP can put the fee as per applicant. But once the IRP's COC is formed and IRP is becoming into RP, that fees is decided by COC. So COC can say, so if it is a banker, banker will say we will not pay more than 3,000 or 1 lakh. If there is a big bank, they will say we can pay you 5 lakh rupees, 10 lakh rupees. So I know a RP, he's getting paid 15 lakh rupees per month from a bank, and from the same bank for another assignment he's getting 50,000 rupees per month also. So there can be a variation in the fees, all up to COC what they decide depending on the amount of case involved. RP within 7 days of his appointment, so COC has happened, within 7 days of appointment or within 14th day, he appoint two valuers as we discussed. The valuer will give face value and liquidation value. If there is a difference value, he appoint third valuer and you take the average of two closest value. He will prepare IMs within 2 weeks of appointment, not within 54th day. So just note down the days, you can read that. Essential supplies, just understand 4 things. Even if the company is under IBC, CRP, company is not able to pay electricity, water, telecommunication dues, internet services, if I'm not able to pay, even then the law says for administrative purposes, companies cannot stop electricity, water, telecommunication, IT. For example, I've taken a telecommunication from Geo and I have not paid Geo from so many months. And when I go into IBC, Geo cannot stop my services, functioning services for admin purpose. They say if these service supplies are stopped, these are essential supplies, if these are stopped, how will a IRP or RP will work in an office? I cannot go to an office where there is no light, no electricity. घर में बैठ के पंखा तो ना चलाएंगे. You need to have electricity. So if you don't have electricity and also how can you function on a company? So what the law says, this, yes, absolutely, no rent you can't remove, exactly. So this is actually happening here. In this case, you can only ask the suppliers to give you services, essential supply, only for admin purpose. You cannot use it for manufacturing purpose or services purpose. For example, you are a distillery, you make mineral water. You cannot take water from the government, make a distillery, start selling, but not paying money. You can only use for your consumption purpose, or drinking purpose. You are a call center company. You cannot, they will get rent only up to the date of ICD. After that, they will not get. That's the hard part. They can go to court for that. IBC will not give you rent for the, after the IB, after the, I'll come to your point shortly. Essential supplies can be used only for admin purpose, not for the production purpose. So just note all these 4 things: electricity, water, telecommunication, and IT. So in exam, a question can come, which of these is not essential supply? So it may come like audit services, accounting services. So these are not essential supplies. Only 4 are there essential supplies mentioned as per the IBC. Now, what will happen if the company is going into liquidation? What the liquidator need to do? He need to prepare a report within 75 days. If it is a compulsory liquidation, if it is a voluntary liquidation, he need to pay within 45 days. So just note the difference. Where it is compulsory, within 75 days, he'll prepare a report, preliminary report covering all aspects of the company. If it is a voluntary, within 45 days, asset memorandum within 75 days, how much assets I have. Every quarter, we need to send a progress report to NCLT that what the status of the company. Now note a classic difference. If you are a liquidator, you need to give ad within 5 days. In RP, it was 3 days, liquidator 5 days. You need to give an advertisement, collect claims within 30 days. There it was for 14 days. Here it is 30 days claim. Collect claim within 30 days. It has to be in English and regional language, wherever the registered office is there. You need to be posted on website and IBBI and other places. In liquidation, you verify the claim within 30 days. In insolvency process, how many days you verify the claim? What is the day of verifying the claim? Somebody need to answer. In insolvency, how many days you verify the claim? In liquidation, they have given you 30 days to verify the claims. In insolvency process, 7 days. So that's a difference. In insolvency, it is 7. In liquidation, it is 30 days. You can sell whatever way you want. We discussed that. you need to appoint, Deepakji, 14 days is for collecting the claim. To collect the claim, it is 14 days. To verify it is a genuine claim, it is 7 days. In liquidation, he appoints valuers to get a liquidation value. The best valuation is for in IBC is for liquidation, because you need to only give one value. You don't need to give fair value and liquidation value. You don't need to appoint a third valuer in case of liquidation, even if the value is different. So just note that in liquidation, you are not appointing third valuer. You try to realize within 6 months, that's the expectation. Compulsory liquidation, it is assumed you finish within 2 years, that's expectation. You appointed, we appointed in one of our case. What we appointed, Itiji, if you can speak or if you can mention. In liquidation value, okay, it's your, no, the company has gone into liquidation. If the company has gone into liquidation and then you appoint third, then it is your choice. Law does not force you. So the unlike insolvency, law forces you. Here it is your choice. So suppose it may happen the COC or the committee at that time, contributors disagree with your value and they say get a third opinion. You can still get that, but law do not forces you. Once you go to the regulations and the liquidation regulation, they do not mention like they mention in solvency that you need to appoint third valuer. Here, this why they don't ask for, and the only reason why they don't ask in liquidation and why they ask in insolvency, because in insolvency the probabilities you might run the company. In liquidation, they know you are anyone to sell it, so it does not matter how much the value variations is coming. So that's why the reason they don't ask for, because in liquidation you're not getting a business plan, you're just disposing the asset. So they don't get third value generally. If somebody's choice, it's fine, you can do that. That's not a, which does not ban you but does not mandate you. When we need to apply voluntary, so if you need to apply voluntary winding up, whenever the 75% majority of the board or partners, if it is LLP of partners agree, what do you need to apply in case of voluntary winding up? Minimum 2 years of audited financials if your company is more than 2 years, 2 years financials, and a report from a registered valuer. Here you will get a lot of opportunities nowadays. A lot of companies are willing to wind up voluntary or liquidate or merge. That you need a report of registered valuer that what is my asset, and a declaration that we are winding up not to defraud somebody and it is just a genuine winding up process, and then the board can admit. These reports we discussed the same, I just changed the number. This process is exactly the same what happened in case of compulsory, same process. No need to go through. You can just read that. Now there are few pointers, just this might help you again, but you need to read it with caution. Do not go 100%. So minimum amount due is 1 lakh. It can be increased to 1 crore. It is actually increased to 1 crore, but for examples, it is 1 lakh. Who can initiate, who cannot initiate? So you can read that. This is a summary. I tried to make a summary for you to check it. Who cannot apply, who can apply, time limits, withdrawal. Like withdrawal can happen. Here it is written withdrawal can happen by 90% of approval. AAA, who is appointing authority and all. Hence, an extension can be done. Like related party can have no right to participate or present in COC meeting. They can just attend. So this can be a summary for you revision once you go through all. Time limits are there, 90 plus 45, tribunal and all that time limits you need to remember. Now, whatever you have understood till now, given a choice, and I'll come to a few questions which I have missed, stopped for next 5 minutes, I'll come. Given a choice, what do you think a banker will prefer to go? Insolvency, in IBC, or in SFA? What is your view, general view? Whatever you have understood till now, I know 3 hours is very short to make any topic explain, at least like this. A banker will prefer going where? Now, Ketan, you should have asked me one question. Is this a fact and to decide or something else is required? So based on this question, based on only the given information, difficult to decide where the bank should go. Now, what is the trend actually happening here now in industry? It came in 2016, sir, IBC. 2017, it became a fashion. Every banker want to go to IBC. So everybody went in 2017 to IBC. It's seen so many cases. IBC was very happy, getting very successful. People are liking us. They started going into IBC. 2018 mid, bankers realized we may be at loss in some cases. So in 2018 later part, reverse trend started and they all started moving to SFA. 2019 majority moved to SFA, few moved to IBC. And unfortunately in 2020 now, it is suspended for next 6 months. So now 6 months, nothing will happen to IBC. What is the decision, what is the trigger point which decides bank to decide should I go to IBC and SFA? That is only one point. How much secured asset I have. If I have very huge amount of secured assets or at least equivalent to amount of my loan, a sensible banker will never go to IBC. He will directly go to SFA for a simple reason. In SFA, you are your own boss. So if I have given a loan of 10 crore to you and I have a collateral of 12 crore to you, I can directly go to SFA. I don't need to handle this IBC madness because I can only directly deal with you. But suppose I don't have a collateral or I do have a collateral, but I wish let me go to IBC also so that company might revive. You know, that might be a thought process. You might become empathetic. Then what will happen? It may happen I have given a 10 crore to you. You might have taken 20 crore from another bank. So who will become powerful? Me, the one who has higher loan. Obviously, the one who has given a higher loan becomes powerful. So I loses my right. So where I was king in SFA, I will become a pauper in IBC. So my value will goes down. So generally people see if you are unsecured, you go to IBC. If you are secured, you go to SFA. How much level of security that decides. That's a trend. A few things to remember now and which are coming in exams, which is not covered in this slide, which generally I take an MCQ. So maybe on the second last day or last day whenever I have a final session, I will cover all things. One, you are a foreign creditor. I am sitting in Jaipur. I am a company. I have purchased something from foreign creditor. Purchased. मैंने foreign से कुछ लिया. The day I purchased, that day the dollar rate, I purchased $1 lakh some product of like dollar I purchased, let's say. The time I purchased, the price was of dollar was 60 rupees. The day IBC, it come into IBC, the dollar rate is 70 rupees. The day you submitted your claim to me, the dollar is 80 rupees. How much rate I should consider for taking your value? 60, 70, 80. Quickly. I think there's one mic. Probably I'll let me. Okay, no. Now the law says, and note this down. I will take 70 rupees as a date. Why 70 should be taken? Because in IBC, insolvency commencement date is the benchmark and it is the regulatory and reference rate for all activities. So whatever liabilities, whatever crystallize has to be crystallized till the date of IBC. I will not take claim date. It may reverse way also happen. Just then ICT date rate was 80, at a claim date it becomes 70. So it is a beneficial actually to the company, but it will not take 70. Whatever is coming on the date of ICT date, that will be taken care of recording liability. Now,
so Sumitji, in the same case, by the same example, if from that date I have made some further supply also, that further supply will not get covered? from the date.
If I came into, I'm admitted into IBC. My company is into insolvency as of now. NCLT is accepted.
The date it is deemed will be that 70 rupees date. That is the date it is deemed as the insolvency proceedings have started. So supposing in another case of a creditor, even Indian or foreigner, they have kept on supplying to that company, and within this 14 days, the credit amount has actually gone up. So they will give the amount as on the date insolvency proceeding starting.
Okay. Now, first, what are the facts will happen? Up to ICD date, whatever you have given, that claim will be as per ICD date, up to that. You are providing something to me after ICD date. Now, after ICD date, if you are providing, it is the call of RP to accept that or not accept that. If he accepts that, let's say if he accepts that, then it will be taken at that date of transaction. Because then it was not a due at the time of your filing a claim, because as on insolvency commencement date, it was not your due. So any service coming after ICD date, if RP is accepting that, then it will be the day of your transaction. So then it will be at the actual date rate what is happening on that day. That will be a differentiation.
But
now
there is no
coming to
provision, it is totally discretion of the RP.
All discretion. All RP can reject also. RP can say, I don't need it. Because what happens after the ICD, the power of board suspends. So the board cannot take any action. Now, if the board cannot take any action and I accept, no, it may supply because there is a long supply due. It's a tender of supply. He can supply. That is not an issue. But that supply has to be accepted by RP. If RP rejects the supply, and RP has full power to reject also. Because RP says, I don't find it as a regular supply, it's charging too much, so RP can reject it also. But if RP accepts it, then it will be accepted at the market rate at that time what is happening. So if I given you on 18th of July, and the rate is and the date is today 80 rupees, I will take it at 80 also for next supply. Previous supply will be at the ICD date, current supply will be at the exact transaction date. That is there, and it's all discretionary. Nothing is written in code. Now there is one. Am I audible? I think my screen got stuck again. Yeah. One last point I will discuss, not for exam, just to show what the IT intent is. And those who are IP professionals would be aware of this case or would have read somewhere of this case. Those who are not aware, it is just an interesting case to understand. I'll give you facts first, then we will discuss the case. Just 5 minutes, not relevant for exam, but just for understanding the way IBC goes and way this profession has gone so high. You are a RP professional. A company comes to you and say, so a company XYZ comes to you and say, Sumit, I need to collect 4.5 crore rupees from ABC Limited that I need to collect. The company ABC has a, let's say, 10,000 crore turnover, 10,000 crore net worth, or it's a very big company. I need to collect 4.5 crore rupees. If you are a RP, how much fees you would have charged? Given a choice, how much fees you would have charged? I given you a fact assignment. I need to recover 4.5 crore rupees. The company from which I need to recover may have 1,000 crore turnover, may have a 10,000 crore net worth. Give me amount. Don't give me percentage. Give me amount, because amount will interest me. Percentage will look very less. Any amount. Let's say so I have given you 4.5 crore rupees. So for 6 months IBC, how much fees you will charge generally? Any vague number. And there's an interesting point we need to understand here. Amount can be any. Whatever you think and feel like. Rest other people can respond. I can get only 2 response. Attendance will be marked based on response. Whoever quotes higher number will get a higher attendance. So Iti is saying 12 lakh rupees, 4.5 crore. This is acha lagta hai, 12 lakhs theek hai. And that is when this question was asked to me, I said 10 lakh, 15 lakh charge कर लेंगे when I did not know the case and when I was studying. So I said 10, 15 lakh अच्छा लगता है. So my faculty says, grow your standard, ask more. 15, 20, 50 पे आके मैं थक गया. I said 50 lakh is sufficient. I will not ask more than 50 lakhs. बहुत ज़्यादा लगता है because I know my appetite. I can only bite that much. I only bite that much I can chew. So I said 50 lakh should be sufficient. थोड़ा मैंने level बढ़ा लिया. Now see what the newspaper printed. And it becomes the classic case in IBC history till date. It is one of the classic cases ever. And those who like to join IBC profession, future or valuation profession, I'm sure we all supposed to join valuation profession. Once you become valuer, read this case thoroughly. Even if you are not becoming IP, if you're becoming valuer, and know you all will become valuer, and I'm sure you all have to become valuer, then only I feel my lecture is worth. Otherwise, it's a time pass. Once you become valuer, read this case. It will give you classic insights what the IBBI and regulator thinks. Now, by the headline, you understand what the intent of the headline is. IP professionals seek fees more than the dues to be recovered. IBBI frowns. So now, if you understood the fees is 4.5 crore rupees, how much she would have charged? And she is a company secretary turned IP professional. And again, I'm not demeaning any profession, or I'm not saying she's CSO. That intent is not that. Intent is just to tell you that she is a Mumbai-based company secretary. So now we understood she should have charged 5 crore. Itiji, how does 5 crore feels even in hearing charging a fees of 5 crore? And she's a young professional. It's not that she's a very, very senior professional, very young professional, 32, 33, that kind of age range. Itiji, your comment on that? If you're getting 5 crore fees, sounds good? It sounds very good. I think I would have do one assignment and then I take retirement, voluntary retirement. How much she quoted? She quoted 15.5 crore. And this is a classic case, again, on public domain. You can always read whenever you want, but read only after you pass, because that is a time waster, not for exam purpose. But the only reason I want to bring this case to you. So she quoted 15.5 crore. So when the fees list went to NCLT, because NCLT goes through your, how much you are charging on this particular case. So NCLT thought that this is 1.5 crore rupees, not 15.5 crore rupees. They thought out of 4.5 crore, 30% makes sense. अगर मेरा पूरा पैसा डूब रहा है, मेरा पूरा, yes, exactly, Deepak ji, exactly. The court thought there might be some decimal point or typo error. क्योंकि जब 4.5 करोड़ में 1.5 करोड़ समझ में आता है, तो मेरा पूरा पैसा डूब रहा है, तो कोई मुझे बोलेगा सर 30% दे दो, मैं निकलवा दूंगा. I will be happy to pay 30 also. So court said that there must be some typo. So court asked her, ma'am, it seems there is a typo. It should have been 1.5 crore. And I admired the lady. She said, no, sir, it is not a typo. This is what I actually proposed and agreed by the client. The company who want to recover agreed that fee is 15 crore. And then court become very angry. He actually literally shouted, the NCLT judge. And he says, what is happening? This case going to IBC also, IBBI also. You are charging more than to be recovered. So you need to recover 4.5 crore rupees. You charge 15 crore. You should be reasonable enough to charge. The fees is unreasonable. And the court point, the IBBI view was, you should have charged any reasonable fees. The girl replied beautifully. And that's the way of art to reply. The girl replied, sir, tell me which act defines the word reasonable. I have gone to all acts of India. None of the act definition of reasonable is not there. So when the word reasonable is not there, and in your code also it is not written what is the limit of fees to be charged, in that case, whatever I charge should be fine. And when I kahavat, jab Miyan Bibi razi, to kya karega kazi? Jab I am fine, the company who was supposed to give the fees, that is also fine, then what is your problem? Now the court got on a back foot. IBBI got on a back foot. Yes, the girl is saying right. There is no law which defines reasonable. So the court played a reverse psychology, and the court asked her, now tell me, ma'am, why only 15.5 crore? Why not 10 crore? Why not 20 crore? So there has to be some basis. It's not a ballpark figure. You have thrown a dart, lag gaya le lenge, nahi laga to nahi lenge. So there has to be some logic. Explain. So the girl says, yes, there is a logic of explaining. I charged 15 crore because she says, the current board of this company, which I will be taking care of, the current board used to get 3 crore rupees remuneration for the whole year. That's a current board remuneration. And there are 10 people on the board. और मैं नन्ही सी जान मैं अकेली पूरा बोर्ड का काम कर रही हूँ, because that is only power the board, all power vests with RP. So once I become RP, I will take the whole power of the board. So you expect me to work alone for the 10 people job. So I need to take leverage. So 3 times leverage I have taken. So 3:9 crore I am taking for the my mental fatigue and for all work I will do for the company. So court says fine, 9 crore we can agree. Come to next 6 crore. Then she said this 6 crore is for my CAC. I am hiring 75 company secretaries, chartered accountants, and lawyer. 75 IT professionals to take care of the company because it's a big company. I need to hire blah blah blah. So 6 crore include that. So 15 crore is what? Court went into the agreements and came to know the girl told a lie. And where here she caught. The lie was, for 75 chartered accountant, company secretaries, lawyer, there was another bill of 6 crore rupees that would be charged separate out-of-pocket expenses separately to them. Here the court got furious, and here they say that now you have told a lie, it got caught. Now the court debarred her for 2 years, practically for 2 years, and now lifetime she got debarred. Later on, another judgment came on. Now what does the court say? Court says, we understand you said there is no meaning in the word reasonableness, so we are debarring you for 2 years first. So 2 साल आप घर में बैठिए, आत्मचिंतन करिए और समझिए reasonable word का मतलब क्या होता है. Because the court says whenever a professional says of any body, CACS, ICW, any professional says, I do not know what is reasonable, then there is a certain problem with professionalism. And we expect a professional to work professionally, and they say IBBI, IP and valuations, these professionals, they have not mentioned valuation, but it is linked. These are not businessmen. These are professionals. There is a difference between who is a businessman, who is a professional. You maintain certain ethics at some point of time, whereas a businessman loses ethics, he can always put your hands, okay, there is no code of conduct. For professional, there is a code of conduct. Amchi Mumbai, from a Mumbai based. Now, she was debarred. Later on, what happened? Then she, out-of-pocket expenses. So miscellaneous expenses 5 crore, 0.5 crore fees, Deepak ji. Now what happened later on? So she was barred for 2 years. After 2 years, she again came back. She got 15 assignments of 5 crore each. She got a proposal, 15 crore. Now IBBI again debarred her for lifetime, that you cannot take 15 assignments of 5 crore each for a whole year, because you will not, IBBI one regulation says, you do not take that much assignments where you cannot do justice to the assignments. You cannot take so many assignments on your alone individually. So now she was time barred, banned. So once you become professionals, we need to go through these cases and understand what is the mindset of a regulator, what is expecting. One of the real story behind this, now you all are sensible enough. If somebody is paying you 15 crore for a 4 crore, do you think there has to be some hidden story or it is clean story? The hidden story was the kickback was going. ये 15 crore कौन देता? ये 15 crore देता ABC company. The ABC company जिससे लेना उसे fee charge होती, उसके assets से निकलती. Out of this, kickback was supposed to go to the XYZ company जिसने claim file करा है. So again, though I'm quoting it on, I know it is being recorded, I'm quoting, but आप बोलोगे ये कहाँ लिखा हुआ है, कहीं लिखा हुआ नहीं है. But does people know? All people in the profession knows who are into this IBC, they know that this was the deal. That's the reason somebody will accept 15 crore. There is no common sense of person will accept that. I think this is sufficient for IBC. Thank you for your patience. It is too much of theory, and I understand for exam purpose it looks tough, but 3 marks generally comes from IBC. So we need to read, and I'm sure we have Itiji and Rajkumar ji who has a fair experience of IBC dealing. if you guys can work out and make some charts for colleagues when you are preparing for them, और राजकुमार जी आपने तो जब IP का एग्जाम दिया होगा आपने कुछ चार्ट बनाया होगा, if you can share with your colleagues it will be good. मैंने 3 साल पहले बनाया था तो मेरे को अब चार्ट relevant नहीं है because things have changed so much. So you need to document. अगर आप summary dates को coordinate करके पढ़ेंगे it will be easy to pass. Dates को याद नहीं रखेंगे, खाली एक बार आपको हाथ से कहीं ना कहीं dates लिखना पड़ेगा या कहीं पढ़ना पड़ेगा, it will be easy. I will try, if I can get an updated chart somewhere, I'll try to share with you, but I do not commit because if I get it, I will definitely share with you. Okay, sir. So we'll break for today. Anyone have any questions which I missed? Probably you can ask now for next 5 minutes. Then we can break for today. Absolutely, it is irrelevant. Absolutely, I fully agree. But I have no second thoughts on that. It is irrelevant, but that's what it is. Because you don't need to remember advertisement page में कितना time लगेगा, 5 दिन लगेगा. If you are a liquidator, it's 5 days. If you are a regulator, it is. If you are a insolvency professional, it is 3 days. So that takes time to recall. Rest, I'm sure you will be able to go through. My system got hanged, so probably I'm not able to take out Zoom. How one can remain ethical? My personal advice would be, again off the record answers. It all depends on what is your upbringing, the way you are, the way your family have given you upbringing, the way your professionals have given you upbringing. So if I would have done an articleship in a good firm or who was ethical firm, I will mostly tempted to ethical. But from the day being I was told ki cheat clients, I may also become because you also behave, खरबूजे को देख के खरबूजा रंग बदलता है. So you behave as when you are in group. So if you are working with ethical people, generally you will remain ethical. I have seen so many cases now, at least in Jaipur itself, I can say on GST, where a lot of consultants, chartered accountants, company secretaries have been put into jail for advising fake invoices. Initially, short-term you feel excited. I'm getting so much of money by giving unethical advices. Long-term, it is good. You need to answer this to yourself. So, and this IBC, since you put one point, again off the record, one point, once you become registered valuers, you will get lot of tempting offers from COC, IPs, or anybody else off the record.
Actually, we are new in this field, but some experienced person we are talking about कि if you will be being ethical, जैसे आपने स्टार्टिंग में बताया कि someone be kidnapped or shoot out or मार पिटाई, और those who are being ethical will remain ethical, but the practical scenario is lots of different thing in the market.
Absolutely.
तो अगर उसके बाद पर्सनली देखे वो, या तो फिर उसको छोड़े केस को, या फिर करे तो फिर उनके अकॉर्डिंग करे.
Absolutely. आपने अगर पेपर में पढ़ा होगा थोड़े दिन पहले, one chartered accountant from either it was Calcutta or Mumbai, I'm not able to recall. He was an IP professional. He was caught because he was taking money from director. So director was paying money to him monthly कि आप ऐसा adjustments कर दो, and somebody recorded this and sent it to IBI and police. So it is up to you at what level you can go. You need to be taking care of this, because कल को कुछ होता है तो can you face your family? Choice is yours. Like your family would be happy if you go into jail for 1 day and earn 1 crore rupees. I don't think any family of us will be happy. We'll say that you are going from paying. Yes, work gets from IBBI always, but what will happen once you become a valuer? Somebody will come and say to you, the valuation is actual worth is 100 crore rupees. You give me a valuation of 20 crore rupees, I will give you 5 crore rupees as a fees. It will be, I got, again, I will not say, we got so many tempting offers at times. Ki kam value karke de do, so that the promoter or anybody can buy back at a lower price. Should you do that? My answer would be certainly never do that. The moment you get caught, you have no base. Never ever do such kind of practice. Never ever. Again, I cannot preach you. You all are sensible enough. It's your call. I can personally vouch, and you can, and I'm, since we are in profession, market में एक बार आपने किसी से पैसा ले लिया, पूरे market में पता लग जाता है this valuer is on sale or not. You can check my credential from any valuer or any IP. If he says we have left so many assignments and one IP has pressurized us, if you don't change value, I will complain against NCLT that you are being adamant. I say go and complain against NCLT. If you follow standards, nobody can touch you. But if you do not follow standards, people can always play you around. So it is all your sensible call. I am sure ethics, I don't need to preach. We need to follow on our own. And your conscience is the best conscience. And I again, जब इतना time waste कर ही लिया तो 2 minute और waste कर लेता हूँ आपके. I got a fortunate privilege of get upbringing in profession by various good faculties and good good principals. They used to tell me 2 things. आटे में नमक खटता है, नमक में आटा कभी नहीं खटता. So modify accordingly. Second, there are 2 tests, mama's test and papa test. Whenever you do anything, think, will your mom be happy with by knowing this? If the answer is no, never ever do that. If you're not able to pass mama test or you are confused at mama test, go to papa test. If tomorrow your son does this, as a father, you will be happy. Answer is no, then never do that. That's probably we can end today. Rest, we all are sensible enough to take our call. Any questions on IBC, you still get confused, then let's take it on next session. I will be coming probably on Saturday or Sunday, whenever the Vijayji fixes the schedule, then we can cover up. And whenever the last session happens, we'll try to cover most of exam purpose MCQs. That will be more of practical, not of theoretical. And then and any question you have on courses till now, whatever we covered, feel free to take care. Time to rush now. Second session is by Tarun Mahajan ji. So he will be coming around 1:45. So he'll cover on. I will share PPT. Don't worry on PDF. I will share all PPTs, everything to you. Just give me a time today. By the end, I think Vijayji will upload on. There is a Google Drive of Vijayji. He will put all materials of all faculties. If I can send you on PPT or WhatsApp also, but you will get confused. So one presentation on all Google link will be easy for you to store. And on my link, I will share you some other things also, which will be relevant for exam purpose. Good day. Take care. Take a lunch. Take a light lunch, so that don't sleep in second session. You need to study. Take care. Thank you all.
नमस्कार चेतन जी।
नमस्कार सर।
कैसे हो और कहाँ से हो, आपके बारे में बताइए।
सर मैं औरंगाबाद प्रैक्टिस करता हूँ, 8 साल हो गए। और मेरा इनकम टैक्स और प्रोजेक्ट फाइनेंसिंग में और पार्टनरशिप फर्म में काम है। आपके बारे में सर?
मैं विमल मालानी, चेन्नई से हूँ।
जी
ऐसे
सर।
नेटिव तो राजस्थान का हूँ।
बताया सर, सीकर।
हाँ, पर काफी समय से 30 साल हो गए करीब इधर ही हूँ मैं।
जी। प्रैक्टिस किस एरिया में सर?
प्रैक्टिस मेरा एक्चुअली प्रिसाइसली तो लॉ है।
ओके।
बाकी घर में सीए वगैरह है तो वो लोग मैनेज कर लेते हैं, वो काम भी चलता ही है।
वही मेरा भी है सर। एक्चुअली मिसेज भी सीए, तो जीएसटी वगैरह वो संभालती है।
सही है।
और अब ये वैल्यूएशन है तो और एक एरिया बढ़ा लिया।
अच्छा, आईपी भी करोगे?
सर अभी मतलब देख तो रहा हूँ, बट पता नहीं, पहले वैल्यूएशन हो जाए फिर सोचूंगा। है मन तो है सर, लेकिन उसमें कैसा है ना, जैसा पंगे बहुत होते हैं, वो एक थोड़ा सा इशू है।
पंगे तो हैं, बट माय व्यू इज कि जो बहुत एकदम ऑर्डिनरी या स्ट्रेट फॉरवर्ड चीज है उसमें सभी लोग घुसे हैं, उसमें देयर इज नो क्रीम एंड देयर इज उतना मजा भी नहीं है। ये जहाँ पे बोला डेंजरस वाली टाइप की चीज, वो एक अलग हो गई, बट आई बिलीव दैट आईपी में भी ना बहुत काम बढ़ेगा।
सर काम तो बहुत बढ़ेगा प्रोफेशनल्स के लिए। जब पार्टनरशिप और इंडिविजुअल आ जाएंगे ना, तो उसके बाद तो और भी स्कोप बढ़ेगा।
Then तो I visualize tremendous. No, but I'm saying even before that, there are a lot of even the small companies who may prefer and who are currently just carrying on with the compliances, but they just want to shut down. They'll actually go into liquidation.
Perfectly right, sir.
आप कहाँ पे हैं चेतन जी?
सर मैं औरंगाबाद, महाराष्ट्र।
अच्छा, so that is why it was becoming कि ये आज Zoom और ऑनलाइन की वजह से ये विमल जी चेन्नई से, I am from गुड़गांव, आप औरंगाबाद से, तो अलग अलग जगह से भी हम लोग जुड़ सकते हैं।
सही
ये तो है सर।
आई थिंक इट इज बेटर कि अपन सब एक दूसरे के मोबाइल नंबर शेयर कर ले।
सर व्हाट्सएप पे जो ग्रुप है ना, तो मेरा पर्सनल ओपिनियन है कि नाम, मोबाइल नंबर, ईमेल आईडी और लोकेशन, और यदि मन हो तो डेट ऑफ बर्थ, मतलब बर्थडे वगैरह। तो
मेरे
ये
पास
चीजें
सबके कॉन्टेक्ट पे वैसे तो ग्रुप में डाल रखा है मैंने। किसी आपस में वैसे तो नाम आई गए हैं, यहाँ से पैनलिस्ट में आप सबको एक दूसरे के नाम भी दिख रहे हैं
जी।
हाँ, तो मैं
So actually Vijay ji
भेज दूंगा।
No, we will actually request Vijay ji ki maybe one of these sessions, 15 minutes he can keep time out, just for introductory type of a thing. So we rather than just 3-4 of us, also we all 15 of us come to know each other, at least the basics. And
कल शाम को कर सकते सर, लास्ट में
कल शाम को कर लेते हैं, शाम को।
I think you can formally put it into the program. शाम को, कल सुबह, before, मतलब whichever, whenever everybody is comfortable, but I think it's a good thing to know the basics of each other.
सर मैं तो वैसे भी थोड़ा सा बातूनी हूँ, मुझे अच्छा भी लगता है इस मामले में ना।
सर आपके पास तो हमारी सबकी डिटेल है, लेकिन हम लोगों के पास नहीं है।
नहीं, मैं तो चाहूंगा सबकी डिटेल। और अब मैं आपको जो मैं YouTube पे जो भी रिकॉर्ड हो रहा है, इन सबके भी मैं सबके ईमेल आईडी डाल के वो पर्सनलाइज आपको शेयर हो जाएगा, पब्लिक में नहीं रहेगा, बट इट विल बी अवेलेबल फॉर यू लाइफ टाइम आपकी ईमेल के थ्रू।
थैंक यू सर। सर एक्चुअली फैकल्टीज बहुत अच्छी है सर, मतलब आप जो बोले थे ना, मतलब ऐसा कुछ नहीं रह रहा है कि जो नहीं समझ रहा है हर चीज।
अभी तरुण जी आ रहे हैं आज दोबारा से, लास्ट वीक जो थे। एक्चुअली मैंने
स्पेशल एप्रिसिएशन फॉर तरुण जी नहीं, जितना कॉम्प्लिकेटेड रहता है, इंक्लूडिंग दोस कैलकुलेशन एंड द स्टैटिस्टिक्स एंड अदर थिंग्स, so he's explained it pretty lucidly and very patiently, which is actually a very nice thing for a presenter.
दीपक जी, जब मैंने अटेंड किया था ना, तो मुझे हरीश जी और प्रीति जी और चैतन्य जी थे, तो कई बार सब्जेक्ट में हो सकता है कि उनका पढ़ाने का नॉलेज अच्छा था, लेकिन हरीश जी थोड़ा सा ज्यादा डीप में चले जाते थे। तो फिर मैं तो चलो यार बाद में देख लेंगे, काम तो चला ही लेंगे, बस काम चला लिया था। स्टैटिस्टिक्स में काफी बोरियत मेरे को होती है, क्योंकि कई बार सब्जेक्ट आदमी के इंटरेस्ट का नहीं हो तो थोड़ा सा बोर लगता है। सब्जेक्ट बोर नहीं होता है, हमारा इंटरेस्ट उसमें नहीं होता तो बोर लगता है।
करेक्ट।
यस
राजकुमार जी, आपके बारे में नहीं जाना, यू आर फ्रॉम वेयर? म्यूट है आप।
राजकुमार जी unmute करो, unmute करो।
I'm from Gurgaon only. I'm
अच्छा,
practicing in Manesar.
तो पड़ोसी हो गए आप तो दीपक जी के।
बिल्कुल बिल्कुल।
सर
Which
I'm
office
in
कहाँ पर है?
सिकंदरपुर। I'm in
अच्छा
सिकंदरपुर।
सिकंदरपुर, अच्छा।
सर
So earlier I was in job.
अच्छा।
तो 10 years तक मैंने 12 years तक जॉब की. From last 2 years I'm in practice.
I've been in practice since beginning. My dad was in practice, so when I qualified, just joined him as a partner, which was in 1989 actually.
Okay.
So that was in Calcutta. Then I shifted. यहाँ पे अकेले हैं. Now dad is no longer there. It's my proprietorship. So family में वैसे एक आध और, my sister is also a chartered accountant.
Okay.
Younger is a CS, but they're both in the industry.
Okay.
अतुल जी आप बताइए।
अनम्यूट कीजिए अतुल जी। अतुल जी ने अपने स्क्रीन के रहते हुए उनको डाउन कर दे तो उसमें क्या होता है कि जो लास्ट इमेज होती है वो सेव रह जाती है।
चलो इति जी आ जाइए सर।
इति जी जब तक है तो वो बता दे। इति जी, we were just having a round of introduction from all of
थोड़ा सा
us.
परिचय दीजिए अपना बाकी पार्टिसिपेंट्स को। आवाज नहीं आ रही आपकी, यू आर नॉट ऑडिबल। आपके माइक में
साउंड लेवल का होगा।
नहीं, अभी भी नहीं आ रही है। आप एक बार म्यूट हो गया, आप दोबारा से म्यूट कीजिए। नहीं, अभी भी नहीं।
अतुल जी, where are you from? Mute है, mute.
Sorry. I am from Delhi as well. Reside in Menda Bagh, Rani Bagh, and office in Rohini.
अच्छा। हम पहले उस साइड में थे 10 years when I shifted here. So I was 10 years I was in Ashok Vihar when my office was also in Ashok Vihar.
Ashok Vihar.
वेलकम तरुण जी।
गुड मॉर्निंग, गुड आफ्टरनून सर।
नमस्कार सर।
आप सुबह आते थे इसलिए आपको मॉर्निंग का थोड़ा शेड्यूल रहा आज हमारे। तो सर आपसे सारे पार्टिसिपेंट हमारे परिचित हैं और आपकी काफी तारीफ भी कर रहे थे।
अरे
तो
सर,
अब सेशन के इंचार्ज आप हैं, प्लीज टेक अप द चार्ज।
इनका 43 किलोमीटर का मैराथन का वो
वॉइस
याद रहेगा सर।
जी।
खाली वैसे एक बात लग रही थी कि he should not be adding 10 years to his age.
थैंक यू सर, थैंक यू। चलिए सर, तो आपने एकदम बहुत अच्छे मूड बना दिया मेरे लिए। With this I will start. So luckily and unluckily, what should I say? But today's session is more about the theory and less about numerical. And it is post lunch also. Still I will try to make justice to it. तो कुछ छोटी-छोटी 3-4-5 बातें हैं जो हम आज के सेशन में कवर करना चाह रहे हैं। And first of all, some strategic management chapters are there. Not chapters, but some strategic management concepts are there, which are part of equity valuation, better I say. So if I talk about what strategic management concepts we are talking about, so we are going to discuss about Michael Porter's 5 forces or 5 factor model. And then we will be talking about core competencies, then SWOT analysis, General Electric model, which is also named as McKinsey's model. And then ADL matrix is there. Arthur D. Little matrix is there. And then the pastel model is there. So the question arises that why, as a valuer, we are going to study these strategic decision-making tools. These tools are actually used by management of a company, and they use these tools either before they start a new business division, or to overview their performance of an existing strategic business unit. As a valuer, why are we going to study it? That's a question now. And the answer is, it is the duty under, there are three approaches: income approach, market approach, and the cost approach. And the most prominent approach I'll say is income approach. Under income approach, you need forecasted cash flows. Providing forecasted cash flows is the duty of the management, but it is the duty of the valuer to kind of check those cash flows. Now, a question arises that how do I check the projections provided by the management? So I need to look into their strategic planning. What are their future strategic planning? What is their strategic position in the market with respect to competitors, with respect to whole industry, with respect to the economy? It means I need to think like a businessman. I need to think like an entrepreneur. Then only if I have the knowledge of business, and better I say, if I have deep knowledge of business, then only I can make justice to my valuation. Let me tell you, practically for many, medium size or small size valuation assignments, we usually don't bother much about what is the business model. But say you are just not a registered valuer and your work is not just certification, and you are an equity analyst retained with a mutual fund, and your job is to advise the portfolio manager on FMCG industry in India or on banking industry in India. So day in and day out, you will study their strategy. And when you study their strategy, some of these models may actually be useful. When this valuation profession has started, it started right now a year back or 2 years back, I can say. And as of now, valuers are doing all kind of valuation. You come to me, a steel company comes to me, I'll make a valuation. A cement company comes to me, I'll make valuation. A software company comes to me, I'll make valuation. But when this profession will grow, thereafter the specialization will also rise. So some of the valuers will start saying that, I work more in the area of valuation of FMCG companies in India, something like that. At that point of time, these analyses may be more fruitful. So here we go. We are starting with Michael Porter's 5 forces. So suppose I want to make valuation of a company named as ABC Limited. It may or may not be a listed company, that hardly matters. So I need to look at 5 forces which affect ABC Limited. The first force is bargaining power of buyers, that is of customers. Say ABC Limited has only 2 major customers. What is the business of ABC Limited? It is the telecom equipment manufacturer. 70% of the equipment manufactured by ABC Limited are purchased by Reliance Jio. Remaining 30% equipments are bought 20% by Vodafone Idea, 10% by Bharti Airtel. Imaginary examples I am taking. So in that case, the bargaining power of the buyer is very high, because your customer portfolio, if you look at your customer portfolio, it is not diversified. Or say I'm a chartered accountant in practice, and my major time I devote to serve only one client. Say I am doing the retainership, or I am the internal auditor, and I do other certifications also for them. And day in and day out, I'm working just for them. 2, 3 other small clients are also there. Then my dependency on that client will be huge. And he will have a higher bargaining power. And my profession, my company, my business will be at a risk if they choose not to take services from me, if they choose not to buy goods from me. That tells that the buying power of the buyer is very high, and that put my company at a risk. So in that situation, I will say that my business risk is comparatively higher, and I would like to make adjustment either to discounting rate, I'll take comparatively a higher discounting rate, or at the time of projecting cash flows, I need to take a little discount in the cash flows because cash flows are very risky. Similarly, I need to check bargaining power of the suppliers also. Okay, on the other hand, there may be an advantage also in this situation. Say I have 1,000 buyers of my product and they are all scattered and they are not united, and each one of them is buying a small quantity. So they don't have the bargaining power. Say the competition is also less in the market, and that way I can decide my selling price. Now, bargaining power of the supplier is also there. If I'm into service industry, then supplies of some kind of physical material is not really important. So even if the supplier is in a bargaining power position, if he raises the price, say I am the software development industry, I am into software development, and I do buy hardware, computer hardware, obviously I'll have to buy. But my dependency on the hardware or my spending on the hardware is very little as compared to my total business size. Because what counts for me is my employees and not the computer hardware I am buying. So even if the supplier is in a dominant position, still I'll not suffer actually. On the other hand, say if I'm a manufacturing company and I draw steel wires, from 10 mm steel wire, I draw 2 mm steel wire. My raw material is 10 mm steel wire. And then I draw 2 mm steel wire and then I sell it. And my supplier is one big steel company, and there are no other suppliers in that region. If I try to get a supply from other regions, the transportation cost will be very high. So there are quite a few suppliers. I'm getting most of supply from one or few of them. They are at a higher bargaining power, and that can reduce my profitability at any point of time. That is the higher risk in business. Threat of substitute. Now, this is the most deadliest thing. It comes as a dark horse. Most of the time, even not the valuer, but the entrepreneur themselves, most of the time they are not able to listen to this particular problem. Threat of substitute. You are fighting with your competitors, and one day some other product comes into the market and you are wiped out. Maybe like the companies, once upon a time, they were making, the cameras which were based on the camera reel. They were producing cameras and they were producing camera reels. And one day came when digital cameras were introduced from these companies like Sony and other companies. So what happened? All those cameras which were based on the photo film or photo reel, they were wiped out. They went out of the business. Later, these digital camera companies were also wiped out by mobile phones. They never thought that this type of competition is coming up. And even when they saw that this competition is coming up, they were helpless to do anything. Nowadays, we don't prefer to buy cameras because it has been substituted by mobile phone. Only a few people buy it. So threat of substitute is the biggest threat. Sometimes and we are not able to assess it. Threat of new entrants in the market. So when Reliance Jio entered into the telecom space, the idea was there, Vodafone was there, Reliance, Anil Ambani Group was there, Bharti Airtel was there, and several other small players were there. Aircel was there. And this new entrant came to the market and changed the whole game, whole scenario. So it largely depends on the entry barrier. So entry barrier may be legal, it may be huge amount of capital. As far as telecom space is concerned, the entry barrier was actually huge amount of expenditure. But Mukesh Ambani Group borrowed a heavy amount, more than 1.5 lakh crore rupees. I'm not really sure about their borrowing for Reliance Jio project. But yes, they borrowed huge trillions of rupees of amount they borrowed. And later when they established themselves, Now they have invited equity of huge amount and repaid debt and become a kind of zero debt company. And in fact, in today's newspaper itself, it was reported that 35,000 crore rupees they are investing in debt mutual fund because they got the money, but this money is not going to be invested immediately. 2.12 trillion rupees they got in total, but this money is not going to be invested immediately. So they are investing a part of money into debt securities. Slowly and gradually, they will invest it into their project. So threat of new entrant is a challenge which a business faces, and rivalry amongst the existing firms. That is also which you need to keep in mind, because if your competitor come in with a better pricing strategy, they can take your market share. So all these things may go on negative or the positive side, and you need to be aware of it while making valuation of a company. That is Michael Porter's 5 forces. Examination question will be simple. Say these 5 factors are there. So in MCQ, they will ask you, out of these 5, they will give you 3 actual factors and 1 factor, something government policy. They will say which one of the following is not Michael Porter's 5 forces, is not part of Michael Porter's 5 forces. Bargaining power of buyer, bargaining power of supplier, threat of substitute, threat of government policy change. And then you will have to identify that this government policy change was not actually told by Michael Porter. Right, sir? Now, this is we have already discussed. The second theory is core competencies. So you need to identify as a business that what is your core competence, and then you need to play on that core competence. Core competency is a distinctive or unique skill, or it is a technology know-how that creates distinctive customer value. Like, for example, the core competency of the Google is its capability to deliver excellent search results, which could not be imitated by its competitors. Sir, if you ever get a time, I'll recommend you one book to read, though it's not a recent book. It is 10, 15 years old written book. The book is named as the Google Story. Yes, the book is titled as Google. And it tells you about the journey of the Google. That how Sergey Brin and Larry Page, 2 university students, they devoted their time day in and day out just for one thing, which they later named as Page algorithm. That what kind of algorithm can be made which can quickly search thousands and millions of web pages in a fraction of a second or in few seconds and give you a very relevant result. They were just focused on one simple thing, and that was quality. Such a motivating book it is that if you focus on your skill development, if you focus on, quality, just one thing, that initially people will not appreciate you, but later you will flourish crazily. So the core competencies are a function of the collective skill set of people or organization structure or resources or technology or a combination of all. The competitive advantage could result from cost leadership or product differentiation. There are 3 tests which are useful for identifying a core competence. Benefit of the end product. So when this Google search engine came up, people realized that this is such a beautiful thing. Before that, Yahoo was in a dominant position. But when people used to visit yahoo.com, the page was so much cluttered and full of information and flashy advertisements were there that you couldn't concentrate on what exactly you are doing. When Google came, there was just one little box and colorful Google was returned. And the whole page was blank. You just look at it and you see, wow, beautiful. You enter your search, press enter, and the fantastic results you could see on your screen. When this product came, people find it to be very beneficial. In its initial 5-10 years, Google never made advertisement. They just grow up by the word of mouth. I used it and I spread it to 10, 15, 50 other people. Have you used Google search engine? It's such a wonderful product. Access to a wide variety of market. Being a technology-based company, they were having access to the whole world market. Difficulties for competitor to imitate. Their page algorithm and all other things are actually patented. They do have the legal rights over there, so others cannot simply copy it. And the pioneer advantage they do have. Now even the Microsoft, what do you pronounce it, Bing or Binge? I don't know, because the J and G is always confusing. Bing. So the Bing search engine is also there, but they are not the pioneer. So until and unless now somebody come up with something really fantastic, which is much more better than Google, people will not easily shift from Google search to any other search engine. So if you have core competencies, then it's really positive. Then your future cash flow growth can be higher. Stability of business will reduce business risk, and your discounting rate can be lower. So one thing is Michael Porter's 5 forces, and the second thing is core competency. On the other hand, a failure of core competency example is of the Nokia. At one point of time, Nokia was a leader in the feature phone segment, and then the smartphones were introduced. Even I can recall I was having a Nokia phone, and one of my friends bought a phone at that time of approximately this size. That was not a touchscreen phone, but that was named as Samsung. And kind of we all were making a mockery of him कि भाई ये क्या नया ले आया है, नोकिया चलता है मार्केट में, तो सैमसंग तो कंज्यूमर ड्यूरेबल कंपनी है, इसका तो कुछ दूसरे प्रोडक्ट आते हैं. And you bought mobile phone, do you really believe they are going to be good about it? And their research and development is so fantastic that in this world now there are 2 types of people. One is the Apple people, and the other one is the families are divided. My family is, say, you can say Samsung family, some other family is Apple family. It's like that. The changing dynamics of industry mean that Nokia lost the top position in the mobile phone industry, and eventually it was sold to Microsoft. So the most important thing is to continuously evolve. While making valuation, you must ask the management that what new skill set, what new evaluation you are going to do. Like all of you are here because you want to come up with a new skill set of valuation. You're already established very well in your career, and still you are learning this new skill, because if you don't keep on learning new skill, you will soon become obsolete for the market. Okay, so some more examples on core competencies. Like one of the company from, this pronunciation, most of the time I do it wrong. So give me 2-3 seconds time. Scandinavian, yes, okay. Got it right. Yes, Deepak sir, exactly. You also posted the same thing. We are learning this registered valuer course, that is enhancement, that is acquiring the new skill set. So this Scandinavian company, IKEA, it changed the way furniture industry was working. So about their design, the designs are simple, high quality, and they are designed for the lower cost. As far as the parts of their furniture are concerned, they are standard and common. So if you're buying a table or a chair or a sofa or anything, the things which are needed, nut and bolt and everything to fix them together, they are standard. So same parts are being used in various furnitures. If you're using some standard parts and common parts, and if you have the global supplier network, then becomes easy later, even for repairing the furniture. Then their assembly. Assembly is done by customers. They simply ship the furniture in parts. If I ship the table or a chair as a whole, the shipping cost will be very high. But if you fold it, if you then you send the instruction to the customer, and the customer thereafter will join it. In India, we will not prefer it, because in India the labor is comparatively cheap, and we prefer that a carpenter should come to our house and he will do each and every single thing. But in developed countries, they are not dependent on all such things for the labor force. They do most of the things themselves. So they prefer that they can assemble their furniture themselves. So just before this session, me and Vijayji were talking about cycling. So I can recall that there are many folding bikes. Even if the folding bikes are not there, what the cyclists do, they make a habit. When we go for a very long distance cycling, what happens, you can face a flat tire any point of time, and you're gonna find a puncture shop over there. So you carry spare tube, and you need to change it. So if it is the rear wheel, then first of all, you need to open it and take out the wheel from the cycle, and thereafter open the tire and then take out the tube and put the tube again and the tire, and then one small hand pump is there. And with this hand pump, you put in the air in that tube and then you go ahead. So you need to learn it. Before doing long distance cycling, you need to be self-dependent about it. So developed country customers, they are used to it. They can assemble it themselves. Transportation becomes very easy because you are sending the compact parts only, and then the customer will assemble it. And they use the computerized system for suppliers and warehouse. Marketing image, so Scandinavian image is there. When I say Scandinavia, it is about the Sweden, Denmark, Norway, the country which are in Northern Europe. So these were the core competencies. These are core competencies of this IKEA company. There are many such examples, like the Tetra packing. It changed the way perishable items are actually distributed. So I was just looking at one video that even now the Amul company has came up with the Tetra packs. Many perishable liquids are now sold in Tetra packs. So first they boil the liquid at 90-100 degree temperature for few seconds only, and they suddenly cool it down, and then they pack it in the Tetra pack, and it is air sealed. So Tetra, once, if you are selling milk in polythene pouches or in bottles, then it must be refrigerated. But once it is packed in the Tetra pack, then you need not to refrigerate it, because the air will never enter. The way it is packed is so solid that no bacteria can approach it. 6-layer packing, it is there. The Tetra pack is, the cardboard packet. You must be aware of it. So the shelf life increases dramatically. Transportation cost, no refrigeration is required, it reduces. And that way you can market your product like anything. So filling of Tetra pack, you can do it yourself. Transportation cost is reduced because you don't need refrigerated trucks. Retail display space is reduced. There also you don't need refrigerators. Customers, they prefer longer shelf life, and that way, the industry come up with the innovation, and thereafter their sale increased crazily. Core competency. You need to look into that. Now, the third model we are going to discuss is SWOT analysis. This is the most common model. Even if you are not a student of management, you always hear about it. Even if you're not doing job in a corporate, as an individual also we listen about it. So this is strength, weakness, opportunities, and threat analysis. People, the strength and weakness is your internal analysis, and opportunity and threat is the external analysis. So SWOT analysis is also named as IE analysis, internal and external analysis. SWOT analysis can be done for a company, for a country, for a political party, for a government, and for an individual also. What is my strength? What is my weakness? What opportunities do I have? And what threats I am going to face? So when I was quite a young chartered accountant, when I became chartered accountant in year 1999, so I started full-time practicing, and part-time I started teaching. And when I started this academic career also, 1 hour in a day or something like that, I found that my strength is to communicate what I think. Whatever is here, I can transfer it to other brain with minimum transmission loss. I found that this is my strength. What was my weakness? My weakness was listening. So I went to the income tax office, and the tax officer will ask something. When I was student and I was new in a city, and I entered my two-wheeler in a one way, and the traffic policeman stopped me, and he said, "Don't you know this is one way?" I said, "Sorry, sir, I'm really sorry. I was not aware this is one way. I'm new to the city." He said, "Okay, गलती की है तो अब उसका punishment, उसकी सजा तो भुगतनी पड़ेगी." I said, "Do you mean challan?" He said, "No, give me 50 rupees cash." Believe me, my hands were shaking when I delivered him 50 rupees. So I found my weakness in listening, bribing, marketing. That was my weakness. I'm just giving you an example of SWOT analysis. Then I thought about opportunity, and I realized that this education industry has a great opportunity to come, because India has quite a huge amount of young population, and still in India, people believe in degrees and percentage of the marks obtained so much and crazily that we are least bothered about innovations and entrepreneurship. We are most concerned about obtaining qualifications, and that too with the merit. So that way, the education is going to be very fruitful. And threat. What is the threat? So I never realized, but threat comes in the form of the competition. So earlier we were regional player or the local player, and with the evolution of internet technology, we suddenly became competitor with the national and international players. And if you want to fight with them, you need to improve your skill set crazily. Otherwise, you will be out of the business. So your strength, your weakness, it is internal. Opportunity is available and the threats are external. You need to do this internal, external analysis, and then play on your strength. Try not your hand in the area of your weakness. Stay away from that. Encash opportunities and be prepared for threats. Learn new skill set so that even if the threat wipe out your existing business model, you are ready with a new business model. That is SWOT analysis. Strength is inherent capability. Weakness is inherent limitation. Opportunity is favorable condition, which is external. You cannot change it. In the organization's environment, which enable is to strengthen its position. And a threat is an unfavorable condition in the organization's environment. So coronavirus is a threat, and you can play on your strength still, improve your immunity, have a regular lifestyle, do yoga, do exercises, take some immunity boosters which are natural in nature, like the giloy juice or something like that. Improve your strength so that the threat like coronavirus cannot affect you. That is SWOT analysis. That was model number 3. Now, strategic business decision making, model number 4. It is named as General Electric model. It is also named as McKinsey's model. So in 19th century, General Electric company used the services of consultancy firm McKinsey to give them a model for strategic decision making. And that's why it is popularly known as General Electric model or McKinsey's model. This model uses only 2 factors. So in examination question, they may ask you that business strength and market attractiveness is about SWOT analysis or Michael Porter's 5 forces or about General Electric model or the ADL matrix. And if you kind of memorize it, then you will be able to answer. Number 1, business strength, that is about yourself. Are you strong or weak? Number 2, market attractiveness. That is, what are the opportunities available in the market? So it works on 3 signals, just like traffic light. Green is for go. Go and make investment, run fast. Yellow is be cautious, even if you are making investment, be very careful about it. Red is to stop. Don't make any further investment, better to harvest it. Better to make disinvestment and take out. They can use the fancy terms like harvest your investment. Harvest your investment means take out your money. Do disinvestment. If you face a green rectangle, then go. Yellow, then cautious. Red means take out the money. So what are the points to be considered for market is attractive or market is not attractive? I'll tell you, these entrepreneurs, they are really very smart. What happened that 5 years back, I thought that I need to get developed one mobile application. It is now there are off-the-shelf products available in the market, but 5 or 6. No, I started thought process 6 years back. In fact, 6 years back, I thought that I need to get developed one mobile application, my own mobile application, where the participants can download PDF files containing excellent notes, audio files containing the audio notes, and my video files also. They should be able to download it. They should be able to watch it, but they should not be able to take it out from their mobile phone. That is my intellectual property remains safe. It is not leaked out. So I tried to find off-the-shelf products, and there was no off-the-shelf product available. So I contacted one developer based in Indore. He worked for 5-6 months and then he failed. Then I contacted one software developer from Calcutta. He worked for 2-3 months and failed, and I lost my money also. Then I contacted one firm based in Indore, which has office in US also. They developed my mobile application, and that was very costly for me. 6-7 lakh rupees I spent on that mobile application. And I told them that why don't you make it a product? You're developing it for me alone, and this is the first version, and I need to keep updation also. So huge amount of money I'll have to spend each time. Why don't you make it a product and sell it out to market at large, so that cost to me? There are 2 things in software industry. One is product, one is service. Service is very costly because they are used to make billing in terms of dollars per hour. And product is off the shelf and it is sold to thousands of people. So the cost effectiveness comes. So that entrepreneur, within 2 minutes, he calculated and rejected my proposal. He said, how many teachers are there, academicians are there like you in India? Maybe 1,000. Out of that, hardly 10% will go for it, or even if 50% will go for it, they are 500. Even if I sell for 1 lakh rupees each, then 500 into 1 lakh is like 5 crore rupees. Oh, the revenue is even less than 10 crore rupees. I don't indulge into such activities. Yeah, it was less than 1 minute's time. He calculated and rejected my proposal. So entrepreneurs are actually really smart. So size of the market. Reliance group of companies, they don't indulge into many other activities which are also available. They are not into airline. They are not into many other things because the size of the market is small. They want to play where trillion rupees business is there, not the billion rupees business they want to play. Even if the market is small, the growth rate must be high, then I will call market is attractive. Profitability is high, then only I will enter into that market. Competition in industry is low, then I will enter the market. Technology is available, then only I will enter the market. Overall, pricing trend is in my favor. Opportunity for differentiation of product and services available, then only I will indulge into such business activity. Segmentation of the market is possible or not possible. All these things will decide whether the market is attractive or not attractive. If it is attractive, I will enter into the market. If it is not attractive, then why should I waste my energy? Now, once I find the market to be attractive, number two thing, I will say whether I am capable of doing good in that market, or if I am already into that market, whether I am already doing good. What is my existing market share? What is the growth expectation of market share? What is my profit margin? What is my brand image? What about my customer loyalty? What about the technology and production capacity I am using? What is the management capability I am having? So I look at two things. One is what is there in the market, and number two, what is my position in the market. So that way I'll create a matrix. This is the G matrix. See, so in the horizontal side, you can see the business strength. My business strength is strong, average, weak. And in the vertical, in the column side, I'll say what is the market attractiveness. If market attractiveness is very high, I'll take back my word. Sorry, I missed some comments also. Deepak ji is saying some venture capital have minimum ticket size of 5 million. Yes, sir, that's really true. They don't indulge into the small activities. मतलब local language में हम बोलते हैं कि चिल्लर वाला काम नहीं करना है हमको. So, if the market attractiveness is high because the market is huge, and if my position in the market is strong, it's a green signal. Make further investment. Market attractiveness is high. It's a big market, but I have an average position in the market. Still, I can make further investment. Market is very attractive, but my position is weak. I need to be cautious while making further investment. Market is okay type of market. It's not going to flourish. So market is okay type. So what I will say is, even if but my position is strong. Small market, I am strong player. I can still make investment. Not small, but medium market, and my position is also average. Cautious. Medium size of market, my position is weak. Don't invest. Even if I have invested, better to withdraw the money, harvest it. Market size is low. Even if I'm strong, I need to think. Market size is low. My position is average. My position is weak. Better to come out of this business. So green is invest, expand. Yellow is maintain and be cautious. Red is harvest, divest. This is the GE model or McKinsey model for strategic decision making. Arthur D. Little, that's the full form. Arthur D. Little, ADL matrix. This is the second last. If you got bored of all these things, this is the second last. Last one will be pastel. The ADL matrix is a portfolio analysis method it's not necessarily investment portfolio, it may be a business portfolio that is based on product life cycle, PLC. PLC is something very important. The approach form a two-dimensional matrix. Actually, it will be a 4x5 matrix. So here, this is the age of the industry. And here on this side, this is my competitive position. So ADL matrix is a 4x5 matrix. There are better I say 5x4 matrix. There are 5 rows and 4 columns. So what is my competitive position? This is one thing. And what is the life cycle of the product? So life cycle of the product we'll discuss later. First, let's discuss about what is my competitive position. Accordingly, I will decide should I enter into this market, or if I'm already into this market, should I continue or withdraw? My position may be dominant, kind of a monopoly situation. Microsoft Corporation was playing for years this kind of situation. Even the antitrust law, they were alleged many times that they are creating monopoly and they are not allowing other players to enter into the market. Dominant position. Strong position. Maybe Reliance Jio, Reliance Industries Limited. There are other competitors in the market, but I make my strategy with freedom. It doesn't affect my value. I don't follow industry. I make a new path and then industry follow it. So I have a freedom to make my own strategies. Kind of RIL position. Then favorable position. So it's not a monopoly or oligopoly type of situation. There is competition, but one segment of the market I have secured for myself, that here I will play. This is my core strength, and here nobody can stop me. This may be your position, favorable position. No one competitor stand out clearly. All are doing good kind of situation. Then tenable position. So though you are not weak, your position is just satisfactory. Although the firm within this category are able to perform satisfactorily and can justify staying in the industry, they are generally vulnerable. So probably I can classify Idea Vodafone over here, or I'm not sure. You can have your own opinion, a different opinion. I can classify Bharti Airtel over here. They are, yes, Reliance Jio is there, but still they have their own customer base, which who are still loyal to Airtel. And probably Idea Vodafone may be classified over here. And this is the position of Arcom before they went out of the business. Weak position. Or the position of the BSNL, or like that. The performance of the firm in this category is generally unsatisfactory, although the opportunities for improvement do exist. Now, if I look in the row, if I look horizontally, this is the stage of industry. Introduction stage, embryonic stage, that is the industry has started initially. So 2 years back, if I look at the e-commerce industry, this was the position. Now they are in growth position. And now some businesses are in mature position. Automobile business, telecom business. It is in kind of, telecom is still between growth and mature. But yes, mature business, maybe FMCG, banking, you cannot make extraordinary money. And aging business. So kind of, it is a declining position. This is the product life cycle, and this is my position. 5x4 matrix. Let's just see 2 or 3 boxes, because otherwise 20 such boxes are there. Market is in the introduction, product is in the introduction life cycle stage, and my position is dominant, like Flipkart was having initially in India. So what should be your strategy? Grow fast, that is, put huge money into your business. Build barriers so that other cannot enter into that market. Act offensively, even if somebody is trying to enter into it, then you destroy them by offering huge discounts, etc. That should be your strategy. On the other hand, if the industry is aging and your position is weak, this is just opposite position, withdraw. And in between that, there are many strategies which are told that how can you actually respond to various situations. Like you have a favorable position, but industry is mature. Already industry is mature, there is no growth potential, and your position is okay, favorable, not strong, not unfavorable. Then focus, differentiate, harvest part of this investment, find some niche area, hold that niche area, try to turn around your business if there is some growth in industry, and try to hit smaller firms. So that is ADL matrix, sir. And the last, niche means a particular specialization area where you keep yourself away from the crowd. That is the niche area. So while all the chartered accountants are busy in doing auditing practice, I have started a consultancy to set up business in India. Like in Indore, we don't have firms. We have, but not much into it, that we will help foreign firms to set up their shop in India. That is the area I practice. Or if you are starting a new business, that licensing from the all departments I do on your behalf. That is kind of niche area. Pastel analysis, some people also pronounce it as L silent also, pastel. So the term pastel is used to describe the framework for analysis of macro environmental factors. P for political, E for economic. Try to recall SWOT analysis. Strength and weakness were internal factors, and opportunities and threats were external factors. So this is kind of extension of the SWOT analysis. In SWOT analysis, when you look for external environment analysis, that can be done through pastel. Political environment, economic, social, technological, legal, environmental. If the political scenario changes, like before Donald Trump and after Donald Trump, American business policy changed drastically. Especially, he started a trade war against China. They are kind of planning to put some kind of taxes against India also. We have introduced the Google tax. Popularly, it is known as Google tax. And France also did the same thing. They also introduced something like Google tax. That is the tax on technology companies which are not having physical but online presence in India. So America kind of imposed many bans, or you can say huge taxes on import from France. And now they are thinking in the same way from India also. Trump announced we will not give, H1B, whatever visa it is called. Fresh visas they will not give. Trump announced that students, if they are not going to college physically, if they are just having online education for their whole semester or year, they are not allowed to stay in America. Now, these are political changes. It can change your situation overnight. Tomorrow, government can say this type of business is illegal. And for 4 generations, you are doing this. Suddenly, your shops will be closed. Many times in many areas, it happens. So that's the political situation, external factor, and it can create opportunities also. When this Notebandi came, it was like a boon to Paytm and other digital payment players. Then there are economic factors. So I don't want to start any political debate, but even before COVID-19, the economic position of India was not good. After demonetization and after mishandling of GST, we suffered a lot. So I'm not speaking on behalf of either bhakts or chamchas, but that's my personal view. Social factors can also affect the demand of your product. You know, the choice of the people, how they consume. So I was talking to one guy who is into jewelry business, who is my relative. And he said that our business model will still survive. Even this internet technology is there. But as far as the jewelry business is concerned, it is still conducted in the traditional manner. We were talking that how this COVID-19 will affect business models permanently, even after this episode is over. Work from home will become more a common thing. Online education will become common. Online food ordering, online grocery, online medical. Many people were not used to it. Now they started using it and they started loving it. It will change the entire business model. So what is the social preference of people? Like the youngsters, they don't like televisions nowadays. Typical cable televisions, they don't like. They don't like theaters. They like web series. Entire business model of the entertainment industry is changed. Technological changes, legal changes, environmental changes. This is going to affect your business. So you need to study all of these things before you say, yes, the projected cash flows are correct or the discounting rate is right. All right, sir. So that was a long discussion. One way, that too. Now it's your time to be active. The capability of an organization which helps it gaining competitive advantage over its competitor is classified as managerial competency, core competency, organizational competency, or workforce speciality. Okay. I think 2-3 more people are left to vote for it, to answer the question. And the answer is core competency. You know, we have studied 6 models in total, and one of those was core competency. That's why the answer is core. In general, you can name it the way you like it, but core competency is a kind of model, and that's why that's the answer. Which of the following SWOT element are internal factors for a business? Strengths and weakness, opportunities and threats, strengths and opportunities, weakness and threats. And yes, that's correct. So minus 0.25 for the first one and plus 1 for second question. In which position? Okay, can you write down the full form of ADL in a private message? Okay, we all are penniless. Okay, no private messages are there. So post it here only. It was Arthur D. Little. Maybe, you never know, they can ask it. In which position ADL metrics companies are generally vulnerable in the face of increased competition from stronger and more proactive companies in the market? If you're dominant, if you're tenable, if you're favorable, if you're strong. So look for the weakest, and it's tenable. Dominant, strong, favorable, tenable, and weak. So weak is not there. So among these four choices, the weakest one is tenable. They are more vulnerable to competition. Okay. From the list below, identify which factor does not form one of the 6 key areas of pastel analysis. And in pastel, P is for technology, P is for political, S is for social. So social may also be named as socio-cultural. What was not there was ecological, kind of a branch of biology. So ecological was not part of pastel. P is political, E is economical, S is social, yeah, socio-cultural. T is technological, E is environmental, L is legal. Okay, sir. In a SWOT analysis, the difficult cash flow situation of business will be treated as it is not strength, it is not opportunity, that is for sure. So it must be either weakness or threat. Difficult cash flow situation. It is not strength or opportunity, it is weakness or threat. No, it's not really clear, but yes, it is the weakness, because actually the language of the question is not really very clear, but it looks like that the answer must be weakness, because no external factor they have mentioned. So we have assumed that difficult cash flow is due to internal factors. It can be threat also, but unless otherwise mentioned, we will assume that this is our own problem. If they would have mentioned something that due to the legal changes, political changes, economical changes, the cash flow has reduced, then it would have been a threat. Okay, sir. So this was one of the things we wanted to discuss. Now, allow me to discuss with you one more thing. I had discussion with some people who appeared in examination in last few days, and there are some new things they have started asking. One is some discussion, in valuation of fixed income securities. We learned about valuation of bonds. We also learned about one more thing, that was calculation of YTM. But they started asking about these calculation for odd dates also. How to handle that situation? Let's create one example for same. Valuation of bond and calculation of YTM. So I'll create one example, say par value of a bond is rupees 1000. It is issued on 1st of April 2010. Coupon rate is say 10%, and it is paid on 30th June and 31st December each year. And kind of say maturity date is 31st December 2020. Okay. So question 1 is like, what is value of bond on 1st March 2013 if interest rate at that time is 12% per annum. No other information is available. You don't have the opportunity to make a cross question also. We learned valuation of bond, and now I'm giving you this question to solve. And you have to solve it now. I'll give you 5 minutes, 7 minutes time. I hope everybody is trying, right? Vimal sir, Sahil sir, Raghunath sir, Iti ma'am, Manonik ji, Rajiv sir, Ashutosh ji. Okay. Yeah, one thing is sure that the value will be at a discount because coupon is 10% and rate is 12%. Chetan ji is asking whether the time will be sufficient in exam. Yes, sir. Most of the candidates report that time was sufficient. Hardly anybody make a complaint that I was knowing answers, but I got out of time. Hardly. I'm also trying to solve. Maybe right, maybe wrong. Even I'm not sure. So don't look at my solution. Just do it yourself. Okay, let me tell you, this type of situation arises in all real life situations also. So you don't make valuation on 1st of April of each year. You make valuation on any of the dates. So you are making valuation, say on as of today. and it is mid of the July. So what do? First, you make valuation on 31st March 2021. It becomes a two-step valuation. First, if you want to make valuation of equity share as of today, you can first calculate value of equity share as on 31st March 2021, because thereafter the time gap will be one year. This time gap is not 1 year. Once you get value at 31st March 2021, then you will discount it for a period of 8-9 months to arrive at the current value. So similarly, I have done it in 2 steps. Question is asking me to make valuation as of today. So first I am making valuation on the next coupon date. When I make valuation on the coupon date, I get clean price. When I make valuation between 2 coupon dates, I get the dirty price. Dirty price means the price which includes accrued interest for the period also. So first I am making valuation on the next coupon date. Now, if I'm standing on 30th June 2013, sir, the number of coupons remaining are 15. Look, forget about 2013. 2014, 15, 16, 17, 18, 19, 20. 7 full years are there. So in 7 full years, I'll be receiving 14 coupons. Plus, during year 2013, I'll be receiving 1 coupon. That is on 31st December 2013. So after 30th June 2013, I'll be receiving total 15 coupons, half yearly coupon. And then I'll be getting redemption price. So I used PV formula where number of periods are 15. PMT is 50 rupees of coupon amount, 1000 into 10% by 2. 1000 into 10% is 100 rupees, half yearly it is 50. And future value is 1000. Discounting rate is considered as 6%, because they are saying on 1st March the interest rate is 12%. It means the market return for similar securities is actually 12%. That is 6% for the half year. And that's why I have taken 6% as YTM, half yearly YTM. So that way, the value on coupon date is 902.88. Then the value as on 1st March. So on 1st of March, if I am standing, I'll be receiving 2 amounts. One amount is coupon as on 30th June 2013. And second is the price of the debenture, which is 902.88. So I have taken E112. Oh, just a minute. Some mistake I have done. I don't know.
I think formula is right, but in the narration it is wrong.
Yes, correct. So 112, E112 is the price of the bond, plus 50 rupees is the coupon amount, which I'll be receiving on 30th June 2013. And then I'll bring it down by 4 months, because I'm starting on 1st of March, the full March, April, May, and June. So I need to discount it for 4 months. So it is 6% for the half year. And that's why I have taken 1% per month. That is 4% for 4 months. So I simply divided it by 1 plus rate of interest. That is 1.04 to arrive at the fair value as on 1st March 2013. This is one way of doing it. I can tell you the other way of solving this situation also, odd dates. The problem here is just one, that is odd dates. If odd dates are not there, then you can solve the question usually. how to handle the odd date situation. You can use XNPV function also. So like today it is 1st of March 13, and then the next coupon date will be 30th June 13, and then 31st December 13, and I need to add 6 months to it. So either I can type it for 15 times or I will have to apply formula. A formula is going to be, very complex. So let's simply type it. So 30th June 14 is there, 31st December 14, then 30th June 15, 31st December 15. Or if you wish, we can learn the formula also, but we'll have to learn date function for the same. I actually don't want to indulge into that. I'm trying to avoid that. Probably Excel will be able to understand this. Oh yes, it is smart enough. Right. So these are the dates. Okay, here there is no cash flow as of today. But on 30th June, I'll be receiving 50 rupees. And I'll keep receiving 50 rupees. In fact, at the end, I'll be receiving 1050 rupees. So this is the list of cash flows I'll be receiving. Now, rather than using NPV function, I'll be using XNPV function. In NPV function, the first cell is first year, second cell is second year. But when I use XNPV function, then first it will ask about a discounting rate, and I'll take it as 6% because the interval is half yearly. For any odd period, it will automatically adjust the rate, and then the value range from here to here, and then I put a comma, and then ask for dates. Oh. Something has gone wrong. Just a minute, please. 1st March 13, 30th June 13, June 14, December 14. No, it's correct. Okay, probably I'll just check it later and get back to you. Dates are here, values are here. Rate, probably it will take 12%. Oh yes, sorry. The dates are there, the formula will automatically adjust for the rate. I'm sorry for that. See. But it is not giving the same answer. Okay, so let's not rely on
that. Could it be that on March 13 there'll be accumulated interest of 2-3 months, so that would be in the calculation? That is not coming.
That is the situation.
So your calculation why it is not coming as the same as 916, maybe that could be the reason.
No, that's not exactly the reason, because the way XNPV function works is somewhat different. That's why it's not coming. So let's not use this XNPV function. That the way actually we accrue interest, if we have a price available for the last point of time, and then we accumulate interest for 2 months, and that actually becomes the dirty price. So in the market, if the clean price is traded, then you accumulate interest separately for that period, and then you actually pay dirty price or receive dirty price. This is how it happens. put 25 instead of 50.
So you should have put 16.7 added to that.
16.7
added to the cost on 1st March, or otherwise on June, take it only for the 4 months.
No, Sarvik, that's the fault of NPV function. I have just experimented on it in front of you only, and the experiment gone wrong. Don't worry, I'll correct it and I'll get back to you. But this answer is correct, and that is for quite sure. This 916.23 is perfect because this is simply discounting all future cash flows, nothing else. I'm studying at a point of time and I'm discounting all future available cash flows and making sum total of all those cash flows. That is actually the perfect answer. How to get the answer with other formula, that I'll experiment first and then I'll come to you.
So Tarunji, in this case, we took 6% because we've taken 15 periods, which is 6 monthly period. So 6 monthly rate of interest is what we're taking here at 6%. In that other one, which you had changed from 6% to 12%, because the actual dates were mentioned, it would have automatically calculated that 12% is for the full year, and June and December are meaning 6 months, so it would have taken 6%.
Yeah, it will automatically take care of that. So
in that X and PV.
Okay. Yes, sir. So this is the way you can calculate the value on any particular odd date. Now I'll give you one more thing over here, and that is calculation of YTM also. For YTM, definitely now I will be using X IRR function. X NPV function was not working, but for YTM we will not have any other choice. So let me create question number 2 for this same case study. What is YTM on any other date? Let's say, what is YTM on 1st of April 2013? If the bond price on that date is rupees 980. Okay. So usually when I calculate YTM, what we handled the situation was for equal time gap. But here again, one time gap is going to be unequal, because from 1st of April to 30th June, it is a time period of 3 months. And thereafter, the each time period will be for 6 months. So you cannot use the IRR function, which we use for calculation of YTM. And you will actually have to use the XIRR function. That is the only way to solve the question now. If they ask to calculate YTM on 30th June 2013, that will be fairly simple to calculate. But if they ask to calculate YTM on any odd date, then I think XIRR is the only function which will help us. How? I will tell you. So let's enter 1st of April 2013. On this date, you will be paying 980 rupees. Then from 30th June 2013, you will start receiving coupons. That will be your entitlement. And then 30th December 2013, again 50 rupees. And this will keep on happening for just a second. So kind of I'll copy it down. 18 and then 18, 19 and 20 and one more. Right? So on 1st of April 2013, you will be spending 980 rupees. From 30th June 2013, you will start receiving 50 rupees. And 50 rupees every 6 months you will keep receiving. And thereafter, on 30th December 2020, you will receive principal amount also. So these are the cash flows you will be receiving, and you are buying the bond at a discount. So YTM must be more than the coupon rate in this case. Let's see, is it actually more than that rate? If I want to calculate YTM, then the only function which can be used is XIRR. So under XIRR, first of all, I'll give it all values, and then I put a comma, and then I'll give all dates. In IRR, I give just value, nothing else. But in XIRR, I'll provide it with dates also. And I'll say express it in percentage form and see. This is 11.16% YTM. I'll just copy the text of formula. Look at this, sir. And try to do it. What is in the guess? Okay. So actually Excel is asking, even Excel is doing trial and error, that it will keep on trying various rates. So if you want faster result from Excel, then you can give it some hint that, look, buddy, you should start trying at 11%. And still the answer is same. Excel is already so fast. Like in my laptop, it's a 16 GB RAM and 500 or 250 GB SSD is there. And MS Office 2019 version is there. So Excel is already so fast that you need not to give it any guess number. Without a guess number, still it is working very fast. Okay, sir. I request everyone just to try it immediately. This is how you can calculate YTM. I'm just experimenting. Meanwhile, while you're doing it, I just want to experiment something. You know, while we are making this calculation, we have gone with just the approximate answer. If the rate is 6% for 6 months, it cannot be 4% for 4 months. It should be less than that, because there is a concept of effective rate and nominal rate. That is actually causing difference between X and PV function and this function. You know, if somebody is saying that interest rate is 12% per annum compounded half year, what does it mean? It is 6% per annum. It is 6% per half year. Now you cannot say it is 3% for the quarter. It must be less than 3% for the quarter, because after compounding it will reach the 6% level. Or let me put it in a different way. Say if a rate is 15% per annum compounded monthly, then this is called the nominal rate. And if you want to calculate effective rate, then you will have to input nominal rate and number of times it is compounded in a year, and then you will get effective rate. So this is same as 16.08% per annum compounded yearly. You know, 15% per annum compounded monthly will produce results same as 16.08% per annum compounded yearly. So that is how we are kind of doing it slightly wrong, because we are using, if it is 6% for 6 months, it is 4% for 4 months. Now that's a wrong approach. It must be little less than 4%. while we are using full 4%. And that's why the answer through X and PV function and this way it is not matching. That was the reason, sir. But anyways, you cannot, you can do it this way. This is acceptable. All right, sir, are we good to go? Do we need any break or something? Because 1 hour 40 minutes we have been studying. Should I proceed or do you need a 10 minutes break? Fantastic. What is the opinion of others? Chetan sir is good with continue. Okay, at 4 o'clock we'll have the break. 10 minutes. No opinion from others? Okay in all the way? Fantastic. Then let's move ahead. Let's study further. And thereafter, where do we put percentage in XIRR? You don't put a percentage. Because XIRR, you just give the values and it calculates the rate. But how to put the percentage in the final answer? Control 1, sir.
Okay, that is the formatting of that cell.
Yes, yes.
Okay. That is why I got 11.15 something. 11.11. Whatever.
0.1115.
Yeah. 0.11.
Yes, it's just the formatting of the cells. Okay, so before I proceed, before I go further, yes, we are now supposed to do the ratio analysis thing. Let's do it. Financial statement analysis. So now this is a very simple chapter. I should have covered it earlier, in fact, because teaching financial statement analysis to chartered accountants is like downgrading them, kind of. Anyways, let's go through it quickly. Financial statements include balance sheet, income statement, cash flow statement. For whom it is not necessary to make a cash flow statement, sir? Please type your answer. Which companies are not required to prepare cash flow statement? Yes, the answers are partially right. One-person company is not required to prepare cash flow statement. Small company is not required to prepare cash flow statement. And dormant companies are also not required to prepare cash flow statement. All other companies are supposed to make cash flow statement. Then statement of changes in equity is there. Notes on accounts and schedules forming part of financial statements are also there. This is how the corporate financial reporting is done. Besides that, you have the director's report and auditor's report. What is balance sheet, income statement, cash flow statement, statement of changes in equity, and notes and schedule that you already understand, sir. You know, the course is designed in a way so that the people who are not chartered accountants or company secretaries can also pursue it. And that's why these things are there. Look, now there are 2, 3, 4 type of things. One is the ratio analysis. One is common size analysis. One is comparative statement for different time period. Now see, ratio analysis we will go through, but what is comparative income statement? And what is common size statement? Let's discuss these two things. So whenever I get any valuation work and I'm supposed to do it with the income approach, so before checking or making, practically for MSME clients, you need to prepare cash flow forecast. They are not going to give you cash flow forecast. So while preparing cash flow forecast, the first thing you do is you take data for last 3, 4, 5 years. So as soon as you get data from the client, you will tell your office staff that put this last 4 years balance sheet and profit and loss account and the cash flow statement in one Excel sheet. Okay. And the next thing you will do, I'm not talking comparative, I'm talking common size. Next thing you can do is to make a common size balance sheet and common size profit and loss account. How do I make common size balance sheet? Each item of the balance sheet is divided by sum total of balance sheet and multiplied by 100. Whether it is asset side or it is liability side. So it will look like this. Paid up equity capital is 10% of balance sheet total. Reserves are 40% of balance sheet total. It is 50% now. 30% is long-term debt. Remaining 20% is current liability. On the asset side also it will look like this. 40% is fixed asset, 10% is investment, remaining 50% is current asset. Each and every individual item. How do I make a common size profit and loss account? So each individual item of income statement will be divided by sales and multiplied by 100. So now what will happen? For last 4 years balance sheet, I'll have total 100 for each year's balance sheet. And for last 4 years profit and loss account, I'll have sales of 100 rupees for each of the last 4 years. So when I look at it, then it will be easy to make a comparison for last 4 years. On that basis, I would like to see the trend in the balance sheet figures and in the profit and loss account figures. That will form a basis to take assumptions for future forecast of cash flows. So this common size statement is a practice which valuers actually do when they receive data from the client. This is common size P&L, common size balance sheet. You can get 1 mark MCQ. What is common size? What is comparative? Comparative is YOY. Year on year. Percentage increase in sales, percentage increase in direct cost, percentage increase in indirect cost, percentage increase in financing cost, and so on. So that is the trend analysis. That the sales has been growing. First year, the growth in sales was 10%, then 15%, then 5%, then 18%. So on an average, sales is growing by 12% per annum. That is comparative income statement. Okay, now the next thing is to do ratio analysis. Just a second, sir. Okay. I just need to communicate one message. Just give me 2 minutes time. I'll be back. Sorry for the interruption. Okay, balance sheet ratio analysis. Before I begin, I must tell you one thing, that ratios are of three types. Probably we discussed it in one of our sessions, but allow me to repeat it if it has already been done. Ratios are of three types: balance sheet ratios, P&L ratios, and mixed ratios. In case of balance sheet ratios, both the numerator and denominator data comes from balance sheet, like the debt to equity ratio. So debt is as at 31st March 2020, equity is also as at 31st March 2020. So the periodicity of the numerator and denominator is matched. In case of P&L ratio, both data come from P&L. So gross profit is for entire year ending 31st March 2020, and sales is also for entire year. Again, the period is matched. But in case of mixed ratios, one of the data come from income statement and the other data come from balance sheet, like the return on investment, EBIT divided by capital employed. EBIT is P&L item, capital employed is balance sheet item. Here comes a problem. EBIT is representing the whole year's period, while capital employed, if you are taking the closing capital employed, it is just representing end of the year. So this is the period mismatch. How to get rid of this problem? In case of mixed ratios, balance sheet items are taken average. So this is EBIT is for the whole year. Therefore, you take opening capital employed plus closing capital employed divided by 2 to get average capital employed. So in case of hybrid ratios, balance sheet items should always be taken average. This is one thing to be kept in mind. Balance sheet has three parts: asset, liability, and equity. On the asset side, you have current assets as well as non-current assets. Non-current assets such as property, plant, and equipment, investment property, intangible assets, and other long-term investments. Liability side, you have current liability as well as non-current liabilities. Income statement, you have revenue, you have expenses, and then you have profit. Cash flow statement divided into three parts: operating cash flows, investing cash flows, and financing cash flows. Okay, now here comes one interesting question. Deepak ji is asking, closing capital would include profit for the year, how to average? Yes, definitely. The closing capital will include profit for the year after proposed dividend, etc. So, in fact, what happens that suppose there is no change in the capital employed except profit. Paid up capital was same as before. Amount of debenture is same as before. 100 crore paid up equity capital at the beginning, 100 crore paid up equity capital at the end. Debenture 100 crore at the beginning, 100 crore at the end. Reserves 100 crore at the beginning and 120 crores at the end, because after distributing dividend, retained profit is 20 crores. So now this way, opening capital is 100, 100 and 100, 300. And closing capital is 100 capital, 100 equity, 120 reserves, and 100 debt. It is 320. 300 plus 320 divided by 2 will give you 310, sir. So rather than taking average, if this is the situation, one can simply do opening capital employed plus half of the profit for this year will give you average capital employed, or closing capital employed minus half of the profit for this year will give you average capital employed. So that will make your job easier if that is the situation at all, that there is no other change other than profit. Right, sir? Okay, now let me ask you one question. In cash flow statement, when we calculate operating cash flows, here you will have to help me actually. So in operating cash flows, the final figure is cash flow from operating activities, right? But before that, you get two other things. And how do you name that? Operating profit before working capital changes, I think one of the name is. And cash generated from operations, the other name is. Am I correct? First you get operating profit before working capital changes. After working capital changes, you get cash generated from operations. Then you adjust for income tax and extraordinary item, and that is cash flow from operating activity. You need to validate it, sir. I'm not sure about it. The indirect method of cash flow statement. You start with net profit before tax and extraordinary items. Then you add back depreciation and all other non-cash expenses. Can somebody help me? If not, then whatever I say, we'll have to assume it correct.
Net profit before tax and extraordinary items. Then you add depreciation and interest paid. Then you less profit on sale and interest. And then you have working capital changes.
Before working capital changes, do they name it as operating profit before working capital changes?
Cash flow from operating activities before working capital adjustments.
Yeah, that was the nomenclature I was missing. Cash flow from operating activities before working capital changes. Oh,
adjustments.
Okay. And then cash generated from operations, and then cash flow from operating
investing activities, cash flow from financing activities.
And then, yes, got it. So tell me one thing. Now, within operating activity, there are 3 steps. One is cash flow from operating activities before working capital changes. Then adjust for working capital changes to arrive at cash generated from operations. Then adjust for income tax and extraordinary items to arrive at finally cash flow from operating activities. Now my question is, sir, if you know cash flow from operating activities and you want to arrive at free cash flow to firm, how will you arrive at it? What we learned was calculating FCFF and FCFE through P&L. Now I'm asking to calculate FCFF through cash flow statement. You can give it a thought and then come up with the answer. There is no hurry. So this is the start point. And this is the finish point. Now you need to put in add less, add less, add less. Okay, tell me, do I need to deduct capex and long-term investments? Say yes or no, sir. Vimal sir is saying yes. One answer is no, then one answer is yes. We have 3 answers only. Do I need to deduct capex and long-term investment? Even, or you can at least type pass if you don't want to answer it. Iti ma'am, where are you? Manonik sir. Raghunathan sir. Rajiv sir. Yes, actually, we need to deduct it because cash flow from operating activities means investing activity is shown separately. Under investing activity, capital expenditure, long-term investments are shown. You want to arrive at free cash flow. And to arrive at free cash flow, you will have to deduct this item. Capex and long-term investment, Okay, allow me to ask one more question. Should I deduct repayment of borrowing? Say yes or no. And the correct answer is actually no. You know why? Because this is free cash flow to firm. The bigger circle, debenture holders are part of the family. And if they are part of the family, then you need not to treat their cash flows. Okay, allow me to ask one more question. Do I need to deduct dividend on preference shares? Definitely no. Not at all. I reject it. Do I need to deduct dividend on equity shares? Yes or no? Not at all. They are also, yes, the big no is the correct answer. They are inside the circle. Their cash flow should not be treated. Okay. Do I need to deduct increase in working capital? Sir, the answer is no, because it is cash flow from operating activities and is already after adjusting changes in working capital. It has already been adjusted. So you need not to adjust anything about it. Okay, do I need to add back depreciation? Come on, everybody, answer it. Yes, no, or pass. One of three answers is compulsory, sir. It will be taken as an attendance for IBBI purpose. And the answer is no, sir. You know why? Because cash flow, you already have cash flow. And cash flow is after, yes, it has already been accounted for. Try to recall the delivery boy situation, service, how should I approach your home? What is your starting point? That's really most important. That's it. I think, yes, one thing I need to adjust now or not, that you will tell me. Do I need to add back extraordinary loss? Now that's the first participation from the side of Iti ma'am. Yes, I need to, because I want, you know, if this is my base year, if my base year is smoothened, then only my forecasting will go right. But if this extra, okay, tell me one thing now. Tell me one thing. If extraordinary loss is predictable, I'm talking absurd. It is called extraordinary because it was not routine. But say it is predictable. Would you deduct, would you still add it back? Say at the end of third year, there will be one extraordinary loss. And it has been deducted while calculating cash flow from operating activities. So will I add it back? I will not. Because if I know that in future there will be some loss, then while making valuation, I need to take care of that portion. Okay. So kind of in the situation, in a normal situation, you just take cash flow from operating activities, you deduct capex and long-term investment, and you'll get free cash flow to firm. But if you're interested in free cash flow to equity rather than free cash flow to firm, then make two additional adjustments also. Repayment of borrowing kind of things, fresh loan, borrowing, redemption of preference share, issue of preference share, take that, and also take dividend on preference shares, and then you will arrive at free cash flow to equity. Right, sir? So these are the things you need to take care when you are starting from cash flow statement figure. Okay, Deepak sir has asked one question. Sorry, sir, I forgot to address it. What about the cash balance? You know, as per popular belief, under working capital, cash and cash equivalent should not be taken. And we have not taken it. So that was the correct treatment and we need not to make any adjustment. Cash profit from operation before working capital changes. Then you make adjustment for change in inventory, change in data, change in creditors, etc. And thereby you ignore change in cash balance. And that is what the popular belief is also saying. That don't adjust, don't take cash as part of current asset. So we need not to make any adjustment for that, sir. Okay. Now, let's talk about ratio analysis part. So this is here. It says that profitability analysis, gross profit ratio is gross profit divided by sales. There are three popular ratios. Forget about this slide. One is gross profit ratio, which is gross profit upon sales. Other one is operating profit ratio, which is operating profit upon sales. Other one is net profit ratio, which is net profit upon sales. Now, what is the difference between gross profit, operating profit, and net profit? You already know that sales minus cost of goods sold will give you gross profit. Then gross profit minus administrative expenses. Listen carefully, sir. Gross profit minus administrative expenses, selling expenses, depreciation, interest on long-term borrowings, interest on short-term borrowings, income tax. This will give you operating profit. Once you get operating profit, then you can add non-operating income, profit on sale of fixed assets, profit on sale of trade or non-trade investment, any interest or dividend income from non-trade investment, Then you deduct, sir, non-operating expenses. Loss on sale of fixed assets, loss on sale of trade or non-trade investment, etc. Extraordinary losses. So once you get operating profit, then you add non-operating incomes, then you deduct non-operating expenses to arrive at net profit, and then you can calculate the net profit ratio. So my question here is, if you want to check sustainability of a business, which ratio is more relevant? The operating profit ratio or net profit ratio? If you want to check sustainability of a business, which ratio is more relevant, sir? Operating profit ratio or net profit ratio? Exactly, it is the operating profit ratio, but it was year 2004. Around year 2004 it was, and the interest rate was actually reducing month by month, quarter by quarter. When market rate of interest reduces, what will happen to, I'm telling you one story about operating profit versus net profit. So just answer my one question. If market rate of interest reduces, what will happen to the government bond value which I have already subscribed? I'm holding huge amount of government bond in my portfolio. I'm a bank. For SLR purpose, I keep investment in government bonds. Market rate of interest has came down. What will happen to the value of my government bond portfolio? And you know, being a bank, I keep on churning my portfolio also. I keep on selling some of the existing bonds. Then I buy some new bonds. I sell some previous bond. I buy some new bond. This is what happened around year 2004. Interest rates were falling. Government bond price was rising. Due to treasury operations of the bank, banks started showing higher amount of profit. Mind it, it was not due to the core banking operation of the company. So it was not operating profit. It was due to the churning of government bond portfolio that they were making huge profit. And their quarterly results were improving crazily, almost all the banks. And people, market as a whole, started thinking that the banking industry has revived and now it will become the next bet where one should put money. And this was, you know, the bank share prices started rising heavily. And when this interest rate, rather than falling further, became stable or slightly increased, then the treasury profit reduced again to the normal level. So again, the profitability of bank was looking very ordinary, not the extraordinary. And the banking bubble busted. Price of bank stocks came down. Just due to one misunderstanding of the market participants at large, that operating profit is sustainable, net profit is not. One need to be careful about it. Okay. By investing surplus fund in bond and buying, selling them is a regular feature for me. But sir, falling interest rate is not regular. Falling interest rate is something irregular, because that was the era when the falling interest rate was kind of considerable amount of fall was there. This is not a regular income for me. So if the interest rate rises tomorrow, I'll suffer a loss also, or my profitability will reduce also. But even if interest rate falls, I'll still accept deposit and loan money to people and make money out of it. So that's my sustainable business. Churning portfolio is
in operating profit, you said that the taxation has to be reduced. That tax will be what, a calculated tax on the operating income I'm getting before tax, or is it the taxation that I've debited to my profit loss account?
As far as ratio analysis is concerned, now we are not talking FCFF and FCFE. So as far as financial statement analysis is concerned, people take amount of tax which is tax expense as per the Companies Act.
As per the profit loss. But in that case, which you said, after that we are to add the non-operating income and reduce the non-operating expense.
Sir, we actually mix two things now. One chapter of the cash flow statement is over now. And I closed it, and now I'm doing ratio analysis. At that point of time, I was simply asking that I'm taking figures. There are two separate things. If you're talking
in ratio analysis, the point is that the taxation on operating profit, if I take the full taxation debited to the profit loss account, that taxation will also include taxation on non-operating income.
No, sir. Actually, let me make it clear. Now with this ratio analysis, we are not going to calculate FCFF or FCFE. First of all, let's be clear about it. So we are not interested in calculation of FCFF, FCFE. We are just doing the ratio analysis.
Yes.
Right. Number two thing, that what amount of tax should I deduct over there? So now there are two things. If there is some extraordinary gain, or if there is some extraordinary loss, and due to which some tax treatment is also there, on extraordinary loss I'm getting tax benefit, on extraordinary gain I have to pay tax, then definitely the effect of that tax must be excluded while calculating operating profit.
But if I'm adding the amount of tax as per the profit loss account to my operating profit, I'm reducing from my operating profit. That will
where I am adding, sir? Where am I adding it? I'm simply deducting it. I'm saying you start with gross profit, then you deduct administrative expenses, selling expenses, interest on long-term borrowing, interest on short-term borrowing, and then income tax, which is attributable to your regular income.
No, is it
not
attributable to the regular income, or is it the amount debited to the profit loss account?
No, attributable to the regular income.
That's okay then.
Yes, that's fine. But there are two things again here also. One is the income tax expense as per the Companies Act, and one is the income tax as per the Income Tax Act. So in my profit and loss account, I'm debiting say 10 crore rupees I have to pay as per Income Tax Act, plus 5 crore rupees is my deferred tax liability provision. So my total tax expense is 15 crore. Then for the sake of analysis, I'll take 15 crores as tax expense.
No, sir. The taxation debited to the profit loss is always the income tax depreciation, income tax taxation. Any difference which is there as per the company law calculation is put into the deferred tax, which may be a positive or a negative.
That is the balance sheet treatment, but the second impact will come in P&L also, sir. Say 10 crore I have to pay as per the income tax return, and 5 crore is my deferred tax liability, which is created this year. Suppose till last year there was no deferred tax asset, there was no deferred tax liability, but this year I realize the tax authorities are asking 10 crore rupees only. But if I charge depreciation as per Companies Act, then that is comparatively lower depreciation. So my tax liability should have been 15 crore rupees. So I create.
Don't go into the finer point of that. The tax attributable to the operating profit is what should be reduced from there to arrive at the
tax expense will be reduced, sir, and tax expense will include tax as per the income tax authority, as well as tax due to the deferred tax asset and deferred tax liability adjustment also. But excluding extraordinary items like huge loss on some item or huge gain on some item, excluding that.
Okay.
Right, sir? Okay, thank you. Okay, now allow me just for one thing. Now, yeah, after profitability ratios, there are activity ratios. Activity ratios are mostly checked by the management for their efficiency. That are they making good utilization of the assets they have invested in the company? So if I see here, I will say that the receivable, all turnover ratios are called activity ratios. All turnover ratios are called activity ratios. In all turnover ratios, in the numerator, you put either turnover or anything similar to turnover. So either you will put in the numerator sales or credit purchase or cost of goods sold or cost of production or raw material consumed, as the case may be. And in the denominator, some balance sheet item will be there. So most prominent ratio here is, I'm not going as per the slide, I'm telling you just normally. The most prominent ratio here is the capital turnover ratio. That is sales divided by capital employed, average capital employed. So my sales is 200 crore rupees and my capital employed is say 100 crore rupees. I'll say I turn around my capital 2 times in a year. Higher the ratio, better the profitability. Then I break down capital employed turnover ratio into 2 parts. One is fixed assets turnover ratio and other one is working capital turnover ratio. So it will become sales upon fixed assets and sales upon working capital. You know, if my capital turnover ratio, which is sales upon capital employed, if my capital turnover ratio is on the lower side, it means I am overcapitalized. 1 mark MCQ will be like this. If the capital employed turnover ratio of a company is higher than the industry average, the company is overcapitalized, undercapitalized, fairly capitalized, or need further information. Then I'll say overcapitalized. My ratio is on the lower side. It means I have capital more than my requirement. So where am I exactly overcapitalized? Do I have got more fixed asset or do I have more working capital? So I break down capital turnover ratio into 2 parts. One becomes sales upon fixed asset, other becomes sales upon working capital. Then I realize, oh, my fixed assets are more, or oh, my working capital is more than required. Then working capital turnover ratio is further broken down into 3 parts majorly. You can break it down into 5 parts also. 3 parts are inventory turnover ratio, debtors turnover ratio, and creditors turnover ratio. So in inventory turnover ratio, I don't do sales upon inventory. Rather, I do cost of goods sold upon inventory, average inventory. In debtors turnover ratio, it is not sales upon average debtors. It is credit sales upon average debtors. In creditors turnover ratio, it is not sales upon creditors. It is credit purchase upon average creditors. And in any working capital turnover ratio, the beautiful thing is 365, or in round figures say 360 divided by turnover ratio will give you period. So suppose my sales is 12 lakh rupees, 12 crore rupees per annum. My average inventory is 1 crore rupees. My inventory turnover ratio is 12 times. Now 360 days, round figure, divided by 12 times will give me 30 days. It means my inventory holding period is 30 days. Whatever inventory I acquire or produce, it remains with me for 30 days and thereafter it is sold. So it's a faster, I will churn it 12 times in a year. Similarly, if my debtors turnover ratio is 6 times, so 360 divided by 6, 60 days is my credit period. My creditors turnover ratio is say just 3 times, as low as 3 times. Then 360 days divided by 3 times will give me 120 days credit I am getting from my creditors. So these are activity ratios. Then I do capital structure analysis. So one is liquidity analysis. Now there are current ratio, quick ratio, and cash ratio. Ratio analysis is more an art and less a science. So there is no perfectly defined ratio. But yes, current ratio is current assets upon current liabilities. Here current assets include even cash. Here current liability includes even short-term borrowings. This ratio must be more than 1. Okay, can you tell me consequences if the ratio is less than 1? Or interpretation, better I say. If current ratio is say 0.8, yes, liquidity crisis is one of the fantastic explanations, sir. What do other people say? Yes, that is also a very good explanation, Chetan sir. You know, my current assets are 8 crore rupees, my current liabilities are 10 crore rupees. So where has 2 crore gone? That 2 crore of current liability is funding my fixed assets, my long-term investments. Now, which is absolutely wrong. If you are funding your long-term investment through short-term sources, then anytime you will fall in crisis. Say, the current liability people come and ask for the money and you say, sorry, buddy, it is invested for 10 years. How can I pay it back? And then you will lose the goodwill and then your gain will be finished. There are two things which kill any organization: poor profitability and poor liquidity. Poor profitability is like a cancer, which will kill your organization in next 8, 10, 15, 20 years. Poor liquidity is like heart attack. If you don't address it immediately, the patient is gone. So be careful while maintaining liquidity. In my surrounding, I have seen that some of the good profitable business became bankrupt just because of poor liquidity management. Then after current ratio, there comes quick ratio. In quick ratio, actually, I exclude inventories. So I take current liability in denominator, but I exclude inventory from current assets to make it a quick ratio. Yes, in real estate also this happened. After RERA, their hands were blocked because RERA says keep money in escrow account and this and that. Now they cannot rotate money. And a series of, in Madhya Pradesh, there is a series of default by real estate people at all level, and they kind of came up with a campaign, the government, Bhoo Mafia. Bhoo Mafiaon ko pakdo, giraftar karo. So many people are running across the country, here and there, they are running. And people lost their money. Those were businessmen, not criminals, but due to liquidity crisis, everything went wrong. Yes, inventory, why don't I include it in current asset? Because inventory is the most problematic item. The whole exercise in this world is to sell stock. I cannot quickly sell it out. That's why, though it's current, but not quick. Yes, on the other hand, very high liquidity is also bad. So my current liabilities are 10 crores and my current assets are 30 crores, and that's not the demand of the business. On the safer side, being conservative, I am maintaining extra inventory, extra cash, so that I never go out of stock and never run out of cash, just to be precautionary. So my assets are sitting idle. It is not generating profit. That will reduce my profitability. Then there is cash ratio. Here I will include receivables also. First I excluded inventory. Now I'm excluding receivables also. So that is the cash ratio. Current ratio will be the highest one. Then quick ratio will be comparatively lower. And the cash ratio will be lowest. How much should be the cash ratio? That depends on industry. In a manufacturing concern, the cash ratio may be 25%, something like that. But in a software company, the cash ratio may be huge. Defensive interval. What is defensive interval? In the numerator, you put your cash and cash equivalents, maybe daters also, if they are easily realizable. In denominator, you put your daily cash expense. So normally, I gave you one of the examples that software companies maintain a defensive interval of 3 months. They keep cash equal to 3 months of their salary to the staff. And that's why they maintain huge cash and cash equivalents. Now, there are some capital structure ratios, debt to equity ratio, and all those, simple to understand. Then coverage ratios. One is the interest coverage ratio. What is the formula for interest coverage ratio? It is profit before interest and tax divided by interest. Some people also include lease payment. So it becomes profit before interest, tax, and lease payment divided by interest plus lease payment. A money lender or a lessor will always prefer this ratio to be on the higher side. If it is the ratio calculated with projected figures, it must be more than 1. It should be 1.5 or 2 times at least. Like you are projecting my income will be double as compared to my interest expense. That's just a projection. It may go wrong also. If you are giving a projection that my income will be equal to my interest expense, then nobody is going to give you loan, because a slight fluctuation in projection will make you defaulter in payment of interest. Now, here comes a very interesting thing. There are 2 ratios. One is return on equity, and the other ratio is return on capital employed. Where is the other one? Okay, it's not here. So if you break down return on equity ratio into 3 or 5 parts, it is named as DuPont analysis. So DuPont was an American company, and this type of concept was first used while making analysis of financial statement of DuPont company. Just a minute, allow me to open a Word file. So now we are doing something important. DuPont, yes, this is how it is named as analysis. The spelling error, okay. First, I'll do DuPont analysis of return on investment. Oh, sorry. So return on investment is EBIT upon capital employed. What if I multiply it by sales and also divide it by sales? Then I can rewrite it like this. It is EBIT divided by sales, and sales divided by capital employed. Or then I can name it as profit ratio multiplied by capital turnover ratio. Okay, now allow me to ask you one question, sir. If the capital turnover ratio increases, that is making more turnover with same assets, what will happen to ROI? Will it increase proportionately? Like if the capital turnover ratio is doubled, so ROI will be doubled or less than doubled? I'm asking the concept, the theory, or more than double. If capital turnover ratio is doubled, what will happen to ROI? It will be doubled, or it will be less than double, though increase but less than double, or it will be more than double. Or you can say a pass. So at least I can see that you are here. Okay. So Deepak sir and Viva sir are saying more than double, and they are right actually. If you double this profitability ratio, this capital turnover, the profit ratio will also increase. Profit ratio, I'm not saying profit will increase. I'm saying profit ratio will increase. If sales is doubled, EBIT will be kind of tripled. You know why? Due to operating leverage. Your fixed operating cost will remain same even if sales increases. Sales increases, variable cost increases, fixed cost remains same. Therefore, EBIT increases disproportionately, which is named as operating leverage. So if you increase capital turnover ratio, your profit ratio will also increase. So ROI will increase disproportionately. Now, let's do the same thing for return on equity also. Return on equity is EAS, earning available to equity shareholders, divided by ESF, equity shareholders fund. Now, I'll multiply it by sales and divide it by sales. And similarly, I will do it for assets also. This is DuPont analysis of ROE. Look, sir, in this case, the formula will be EAS, which is actually nothing but a type of profit. And here it will become asset. And this is asset upon ESF. See, the sales and sales will be cancelled, the asset and asset will be cancelled, and you will be left with EAS and ESF only. If I try to name it, it will be like this: ROE is equal to EAS is a type of profit. So profit upon sales is profit ratio. Sales to asset is asset turnover ratio. And asset to equity shareholders fund, I may name it. Nomenclature may be different for different people. I may name it as financial leverage. If you want to increase your return on equity, hence earning per share, hence dividend per share, hence value. If you increase ROE, then earning will improve, then dividend will improve, then value will also increase. Then there are three ways. Number one, you can increase your profit ratio. If you're already working efficiently, there is no chance to improve profit ratio, not profit amount. Number two, you can increase your asset turnover ratio, but always keep in mind there must be a limit to it. Otherwise, there will be breakdown in the asset and your business will collapse. With same asset, you are increasing turnover further. Very much if you do it, then asset will be under pressure. So there must be a limit to increase utilization of the same asset. And this third ratio, this is usually more than one. So your assets are more than equity shareholders fund. You know why? Why this ratio will be more than one, sir? Exactly. Because you'll have debt also. So by increasing debt, you can increase ROE. But keep in mind, if you increase debt, your financial risk also increases, beta increases, cost of equity increases. Hence, that will cause value of equity to come down. If this ratio increases, your business, this ratio increases, your business risk increases. Same asset, more turnover. If this ratio increases, your financial risk increases. So stay within limit and then try to maximize return on equity. That is the DuPont analysis of ROE. And now, one last important thing we are going to study is like this. ROI, ROE, reconciliation kind of thing we are going to study. You already know the formula for ROI, but allow me to repeat it. It's EBIT divided by capital employed. You also know the formula for ROE, and that formula is EAES upon equity shareholders fund. When I say equity shareholders fund, it includes paid up equity share capital and all reserves, nothing else, no preference share, no debt. Now I'm going to reconcile these two ratios. How? Like this. I'll say ROE is equal to ROI multiplied by 1 minus tax rate plus it will be kind of ROI minus the rate of interest multiplied by 1 minus tax rate multiplied by debt divided by equity shareholders fund. Plus, now this is going to be interesting, plus ROI multiplied by one minus tax rate minus rate of dividend on preference shares, which is further multiplied by preference share capital upon equity shareholders fund. Give 1 or 2 minutes time to this formula, or allow me to break it down into 3 parts so that it becomes easy to digest. It's like this. This is the leverage analysis of return on equity. Yes, profit ratio has to be more than cost of debt, then only it will be beneficial, right, sir? You know what exactly it is happening? No, EAES, PAT and EAS are two different things. PAT minus dividend on preference share will give EAES, earning available to equity shareholders. If there are no preference shares, then I can simply write PAT. Then there is no issue. Equity, what equity shareholders will earn? So I am the equity shareholder. Deepak sir is debenture holder. Vimal sir is preference shareholder. So we together, I put 10 crore, Deepak sir put 10 crore, Vimal sir put 10 crore. Total 30 crore rupees is there in the business. On 30 crore rupees, we are earning 15% return. So on my 10 crore, we are earning 15. On your 10 crore also we are earning 15. On entire capital employed, we are earning 15% return. So what is return to equity, return to me? It will be return on investment, which is 15%, multiplied by 1 minus tax rate, because ROI is before tax, so I need to make it after tax. Then only this amount is available for equity shareholders. Plus, ROI is 15%, but I'm giving interest 10% to the debenture holders. I earn 15% amount on debenture capital. I pay 10% amount on debenture capital. So 5% is the surplus. And this surplus goes to equity shareholder because they are owners of company. But obviously after tax. Then this surplus is multiplied by amount of debt and divided by equity shareholders fund. So if debt amount is double as compared to equity shareholders fund, then this advantage will be doubled. If that amount is triple as compared to equity shareholders fund, then this amount will be tripled. If that amount is half as compared to equity shareholders fund, then this advantage will also become half. The same thing goes with preference share capital also. I earn 15%, I pay 30% taxes, so I'm left with just 10.5%. But my commitment to pay dividend is say 12%, and I'll make that payment. So there will be actually a financial disadvantage of preference shares. Now this disadvantage, it may also be advantage in some case, is multiplied by preference share capital divided by equity shareholders fund. So if the ratio is 2, disadvantage is doubled. If the ratio is 0.5, the disadvantage becomes half. One quick example will help us to understand. See, equity shareholders fund, that is paid up equity share capital plus reserves and surplus, is equal to 100 crores. And 10% debt is also say 200 crores. Then 12% preference is say 50 crores. EVIT is say 52.5 crores. Tax rate is 30%. Calculate ROI after tax ROI, and then ROE, and then ROE leverage analysis. You're required to do 4 things. Okay, sir. Equity shareholders fund is 100 crores. 10% debt is 200 crores. 12% preference shares are 50 crores. And our return on EVIT is, 52.5 crores. Tax rate is 30%. You're required to calculate ROI, after tax ROI, ROE, and ROE leverage analysis also you will have to do. So first help me with ROI, sir. %. Okay, we'll check that. Come on, everyone, just participate. Next 5-7 minutes and the session will come to an end. Non-stop 3 hours. Thank you for your cooperation. Ashutosh ji, Rajiv ji, Iti ma'am, Atul Kumar sir, Raghunathan sir, Sujit ji. So the formula for ROI is here. I'm sorry. This is EBIT upon capital employed. So in this case, EBIT is 52.5 crore. And look, capital employed will include equity, preference, and debt, all three items. So that will be 350 crores. So in percentage terms, it will be 15%. Oh yes, that is 200, sir. After tax ROI is 15% into 0.7. Now, ROE. So for ROE, first I'll have to calculate earning available to equity shareholders. No, after tax ROI goes straight without taking tax benefit. Just like in FCFF, we do EBIT into 1 minus T gives us profit after tax. Because tax benefit on interest will be taken care separately in this formula itself. So EAES is going to be EBIT, which is 52.5 crore, less interest, which is 20 crore. This will become profit before tax, which should be multiplied by 1 minus tax rate to make it profit after tax. Profit after tax minus dividend on preference shares. I guess it should be 6. Oh, yes, it's 16.75. Divided by equity shareholders fund, which is given ready-made to us. 100 crores. It includes paid up equity share capital plus reserves and surplus. Now, here comes the most important part of this question. Look, in this case, first I'll take ROI into 1 minus tax rate. So ROI is 15% multiplied by 0.7. Or let me put it here. Plus I will do 15% minus 10% multiplied by 0.7 into amount of debt, which is 200, divided by amount of equity shareholders fund, which is 100, plus 15% into 0.7 minus dividend on preference share rate which is 12%, into preference share capital, which is 50, upon equity shareholders fund, which is 100. Okay. If I further solve it, it will become 10.5 plus 15 minus 10 is 5, 5 into 0.7 is 3.5, into 2 minus 1.5 will become into 0.5. So 10.5 plus 7 minus 0.75. So that will be 16.75. Just look at the calculation carefully so that we can conclude it. Okay. So concluding remark here is, we were earning 10.5%. Our ROI was 15%. Our after-tax ROI was 10.5%. We were earning 10.5, but I am earning 16.75. This extra income is named as advantage of trading on equity. This extra earning available to equity shareholder is named as advantage of trading on equity, or you can say it is the advantage of financial leverage. You know why? 5% surplus is here from the debt side. After tax, it becomes 3.5%. Double the amount of debt, make it double, that is 7%. Here I am earning just 10.5 after tax, and I have to pay 12% after tax. So there is disadvantage of trading on equity to the extent of 1.5%. But thank God, amount of preference share is just half of equity share. So that way the disadvantage is 0.75%. Trading on equity advantage 7%, trading on equity disadvantage 0.75%. Finally, 16.75. So if ROI is expected to be more than interest rate, more borrowing is preferred. Yes, Reliance Industries Limited has gone a debt-free company, but still, if you look at the total debt size of Indian companies, it has gone up. Few selected companies are becoming debt-free, but most of the companies have raised more debt in financial year 20 as compared to financial year 20, because leverage has its own advantage. Why companies go debt-free? You know, some companies feel like that their business model is more vulnerable to changes in economic condition, and the size they are carrying is huge. So that way they perceive risk to be higher than the advantage of trading on equity, and that's why they want to become kind of debt-free. Infosys is a different thing because they don't need money. That's why they don't borrow money. Their main capital is human capital, not that they are not capital intensive industry, and that's why they don't need borrowing. Debt-free has one more advantage. Your financial risk will reduce, so your equity beta will also reduce. Yeah, Reliance Industries Limited in India is one example. Worldwide, some other companies are trying to be debt-free, but entire world is not trying to be debt-free. If you look at the BSE 500 companies debt situation, it has actually gone up. It is not reducing anymore. So debt-free cannot be a universal good policy also. To some extent, that is good. But if it is huge, then it should be avoided. Okay, sir. So with this, I give this rest. I give rest to this whole ratio analysis thing and all type of SWOT and every other analysis. Okay, on a different note, Baniya Buddhi. That's true, sir. Too much of debt is really bad. Some little amount of debt is okay for business. You know, if your business risk is already higher, then you should not take financial risk. If your business risk is lower, then you can take financial risk. That too should be in limit. Because the market keeps on fluctuating, economic situation keeps on fluctuating. So you should borrow amount which is bearable even in bad days. All right, sir. Thanks a lot for being here and for all your patience and participation. And still, if there are some doubt, you already know that you can ping me personally or you can post it on the group. Thank you, sir. Vijay, sir. आज का सेशन यहीं तक है सर या आज इसके बाद भी कोई और शेड्यूल प्लान में है? No other plan today? Okay, fantastic. All right then, I'm taking a leave. Thank you.
चेतन सेशन क्लोज हो गया क्या?
सर आप ही का वेट कर रहे थे, मतलब
अच्छा।
अभी है
चल ठीक है, मेरा एक दूसरा वेबिनार है चेतन, तो फिर मैं करता हूँ, मैं इसी का वेट कर रहा था कि अब खत्म होगा। ठीक है,
ओके।
ओके।